on my unconditional apology, my lord.
No. Thank you.
It was never intended to, my lord.
No, Mr. Dasgupta. We know you for so long. Yes. Call on
My
that.
lord,
My lord,
I'm so sorry, my lord. I'm very
my lord, mine was completely different. 25
Please call on the
weeks.
list. We mention item number 1. Yes, who is appearing in 1?
My lord, this was for 25 weeks of pregnancy. Identical.
1, none is appearing.
Well, the day after tomorrow, notice has been given for demolition. I request a matter is pending, my lord, they are not stopping.
1 not today. Next.
I have given notice to the other side.
My lord, this will be infructuous, my lord. It will be 25 weeks of pregnancy. Rape victim, 13-year-old.
No, 1 not today. Yes.
My lord, exceptional, urgent, otherwise I should.
Hand over both the slips,
Yes.
please. Yes.
It is-
No, no slip.
Well, kindly give it tomorrow. The day after tomorrow, notice.
I'll consider that.
My lord, may I,
Yes,
may I,
I'm
Yes, Mr. Dhari. You also.
I am extremely grateful.
Leave the one, okay?
sir, can it be on tomorrow 10:30? Can it be on
Lordship.
tomorrow 10:30, my lord?
2. 2 call.
Lordship, may I be permitted to mention, Lordship, for inclusion?
हाँ दिए दो.
May make over a sleep, my lord, there is extreme.
For orders, item number 2.
May it please,
Who
your
is
lordship,
appearing?
I'm appearing, I'm the special officer in item 2, my lord. I had moved this matter yesterday, my lord.
Item
Right.
1, my lord, I was
No,
appearing.
it's not today. Yes.
My lord, this was that matter where I had pointed out the dichotomy in bylaw number 3 and bylaw number 8 of the West Bengal apartment ownership bylaws, my lord.
Right.
That there are two rival interpretations by the petitioner in the matter and
You
the
got a
private
copy of
respondent.
Vote
Yes,
as
my
well.
lord. I have a copy of the.
Father. Yes. Are you mad? Out of your mind? Are you out of your mind? You're in item 2. Please get lost. Don't test the patience of court all the time. You're an officer of the court, sir. You're out of your mind. Item 2 is going on. Is it a license to disturb the business of the court just like that? What do you think of yourself? This is a playground for children. Yes. 3 and 8.
3 and
was-
8, my lord.
Yes.
My lord, yesterday.
You've given notice on all this.
Yes, my lord. I believe they're appearing.
Yes, sir. 4 who is appearing. Yes. What is your stand in that?
Lordship, my first stand is that this writ petition has been disposed of.
Right.
In this disposed of writ petition, several orders are being passed
Mhm.
without any formal application being filed. Today, this matter has been mentioned in a disposed of writ petition without taking out any formal application.
Hmm.
If your Lordship kindly.
No, the special officer seeks a clarification. Special officer is an extension of the court. So he seeks a clarification on pure law. What is your stand on this?
Kindly see what was the relief prayed for in the writ petition. The relief
Yes.
prayed for in the writ petition was an order.
I'll only see the order which has been sought to be modified in the sense. Not a modification, even an interpretation of that order. This order was passed by Justice Bhattacharya, probably, yes. Justice Bhattacharya
Yes, your Lordship.
on May 12th, 2023. There a direction was given to the special officer to hold an election for him.
Special general meeting and
Now,
election.
some tricky point has arisen in connection with that. He's saying there's a dispute among you and the other side as to what should be the interpretation, whether the new people should come in or not. You said they shouldn't come in. What is your contention? Why?
Your Lordship will kindly.
3 and 8 are the only relevant provisions.
Yes, 3 and 8 of the bylaws.
Right. Let us come to 3 once.
Yes. Lordship kindly sees bylaw 3,
Yes.
3(1)(a).
Right.
There shall be in respect of each property and association and each apartment owner of such property. Please complete.
Yes.
And each apartment owner of such property is a member of such association.
Hmm.
Where an apartment owner transfers his apartment by sale, gift, lease, exchange or assignment to any other person, he shall cease to be a member of the association concerned from the date of the sale, gift, lease, exchange or assignment, as the case may be, and the transferee becomes immediately a member of the said association in place of the transferor. The transferor and the transferee shall notify such transfer to the board by writing a letter addressed to the president of the association within 7 days from the date of such transfer. The board shall keep this intimation letter for its record only. Now, Lordship, see, where more persons than one jointly own an apartment, such
This is probably not applicable in the case.
the only concerned provision is B. as to who will be given the notice.
Right.
Or who will participate in the election process.
And 2 also says something regarding 45 days and all. I
Yes,
don't think
that
that's relevant.
This is relevant, Your Lordship.
Yes.
Within 45 days from the date of acceptance of Form A by the competent authority, or within such further period as the competent authority on application made to it, or of its own motion, may allow the apartment owners of each property shall in a general meeting to be held on such date and at such time and place as may be decided by such owners, and to be presided over by an apartment owner chosen by the apartment owners present in such meeting, form an association under some specific name and style, and the apartment owner presiding over such meeting shall immediately communicate the formation of such association along with the names of the members thereof in Form 1, along with a copy of the resolution and attendance sheet of the meeting of the competent authority, who shall register the association under serial number and issue a registration certificate in Form 2. Lordship, I'm late by Mr. Bhattacharya.
Yes.
I'm sorry, I'm extremely sorry. I was
No, no,
taking-
why? He started very
taking
well.
leave.
He started well. Yes.
Now,
Why shouldn't these people come in? The transferees.
the transferees are not before your lordship's court.
No, special officer is in doubt.
Special officer has expressed, my lord, a doubt while arguing the matter yesterday that I am a busybody. He has urged this, my lord. He has
Mr.
decentralized
Bhattacharya,
himself.
let us not be sentimental or
There is
let
not
us be
necessarily a
pure.
question of sentiment.
Busybody, idle body, immaterial.
He has-
Whether these transferees
He
are
is not
entitled to
appearing
come.
for the petitioners, is he?
Could the transferees come in? He has to
The
hold the
question
election.
is, now, he has not got to hold the election. He is to hold the
Mr.
special
Bhattacharya,
general meeting.
actually, when I decide a matter, I have to first consider whether you are a busybody or not. If you are a busybody, I won't listen to you.
Yes.
So my adjudication depends on whether you are a busybody.
Now, my lord,
Similar
your
for the
lordship
special
is
officer
looking at- Your lordship is
Yes.
looking at a situation whereby
Yes.
an order at page 42 of the writ petition was under challenge. An order whereby, my lord, I was directed to officiate a special general meeting by the competent authority under the West Bengal Apartment Ownership Act. Now, my lord, the West Bengal, it is correct that, my lord, this Form 1 meeting was presided over by the writ petition. Form 1 meeting. This, my lord, Rule 3, Sub-Rule 3. Now, my lord, incidentally, the entire Form 1 as a whole is not a part of the records in the writ petition. My lord, what is part, my lord? The subsequent part or a part of it is a matter of record. Incidentally, in the Form 1, my lord, which was sent to the competent authority incorporating the 462 persons' names, my lord, it had the name of the writ petitioner's wife who was a joint owner. And the signatory to that Form 1, whereby, my lord, this association, Merlin, Fifth Avenue Owners, or whatever association was named, my lord, this Form 1 was signed by none other than the writ petitioner. Form 1 was signed none other than the writ petitioner. Now, my lord, Form 1 was sent. Now, kindly visualize the position. Form 1 was sent, association was named. Now, thereafter, it contemplated a SGM, special general meeting, to be presided over by the person who presided over in the Form 1 meeting. That person was the writ petitioner. My lord, rightly, wrongly, that person was sought to be removed. Your lordship's court interdicted, my lord, and the writ petition was allowed. The writ petition was allowed, disposed of. Now, my lord, because of this problem, who is to, my lord, preside in the SGM? My learned junior friend, my lord, my learned friend, Mr. Mukherjee, was appointed as the special officer for the purpose, for a limited purpose. Limited purpose is what? According to his second, my lord, clarification made by the court, the first, my lord, order was he should be appointed to send notices to all these 462 persons. Now, my lord, rightly, wrongly, my learned friend has, apropos the Honorable Court's order, conducted 2 meetings of the parties, and in that parties these issues cropped up. Who is to be Form 1, whether Form 1 is to be amended or not.
So what I said, do you say that Justice Bhattacharya's direction was regarding the 462 members?
Yes,
specifically?
462.
So now these transferees would
The
include.
transferees were not before the court. The transferees were
No,
never
the
before.
transferees, if the transferees are brought in, that would not be these 462.
No, that transferees are the original 462 whose names were signed by the writ petitioner, sent as Form 1.
So you say let it be restricted to those.
Because of Rule 8. Please see, my lord, this Regulation 8 of the
Yes.
regulations.
Right.
Kindly subject to correction. I may be wrong, my lord.
Yes, yes.
Within 15 days of formation of an association under 3(2), bylaw 3(2). The apartment owner presiding over the general meeting referred to in the said clause shall serve notice upon each member of such association. Such association presupposes the association formed on the basis of Form 1. And it cannot have any other member ordinarily. Now, my lord, it is entirely for the election body, because, my lord, SGM is for the purpose of appointing dates. Now, my lord, what happened? I'll tell you a lot. What has not been told to your lordship yesterday, I'm very surprised, my lord, is that the special officer, upon his appointment, served notices on 462 Form 1 members. Served notices. SGM was also fixed. SGM held on the 26th or 27th of July, 2023, presided over by a senior resident there. In that SGM, an outsourced agency was also, my lord, appointed to hold the election in the month of August. At that juncture, my lord, Can 2 came before your lordship's court. Can 2 filed by the writ petitioner seeking modification of the original order. His lordship, her ladyship, my lord, felt that the order, insofar as the SGM is to be held, only that portion needs to be modified, because further remuneration was directed on the special officer. Therefore, the special officer is to hold the SGM. Now, my lord, SGM's notice has already been served by the special officer on the original 462 members. Before the special officer, at least, my lord, from the 2 minutes appended to the Can 2, apparently, I don't find even one complaint lodged by any person who says that my name ought to have figured in the Form 1. My name is not before the Form 1. My lord, the ultimate idea is, I'll tell you, lordship, why. My lord, if Form 1, these persons, the notices in Form 1, they are to hold the election. The election details are to be prepared on that particular day. My lord, the original, my lord, the promoter, Merlin, my lord, in the month of February 2023, intended that their own man should manage the election. The idea was very clear. My lord, today there is an understanding, outside understanding, that they have a limited period till November. All these ploys are being engineered, my lord, not at my instance. Let me tell you, lordship. I wanted the special officer to hold the special general meeting. I have never I have not even raised the issue about who the member is, what the member is. My lord, that is to be decided, if at all, by the body who is to be appointed to conduct the election. My lord, it's only the question of participating in the democratic process. Now, today your lordship visualize, my lord, a voter list is published, assuming, my lord, someone attains, my lord, before the date of voting, someone attains majority. He will not have a right of voting unless and until his name specifically is incorporated in the voters list, my lord, in terms of, again, my lord, 3(3) or 3(2), where, my lord, a transferee's name has got to be incorporated. My lord, here, who is going to certify that he is a new owner? My lord, yesterday I saw the clippings, my lord, the recording. I'm telling your lordship, in fact, none of the parties could identify that these persons are new. Even Merlin, the promoter, said, I do not know who has come. The writ petitioner does not know. We do not know. So, my lord, therefore, the Form 462 members who were originally sent, they become the Form 1 members, and those Form 1 members may kindly hold the SGM, my lord, at the behest of my learned friend. He has already served a notice. Let him serve a fresh notice if he wants, and conduct this within a time-bound process. The matter ends and a date be fixed. My lord, if the owners feel, if the occupiers, whoever, my lord, those persons present in the meeting feel that, my lord, outside agency, in fact, I'll tell you, lordship, apropos the order made by your lordship's court, these problems never cropped up. Those 462 Form 1 members were put on notice. And the meeting was in fact held at the behest of a person, which meeting, my lord, if your lordship looks at the last order made by your lordship's court, my lord, Justice Bhattacharya's order, the last part or 1-2 paragraphs before that, there is a recording that if anything has transpired in the meantime, that will be taken care of. And if there is any problem, my lord, first of all, the learned special officer, my lord, makes an oral comment. I need not say that, but makes an oral comment regarding my status. Second thing is, he himself does not inform your lordship that apropos the orders made by your lordship's court, he has already served this notice on 462, and 462 members did hold a meeting, which in effect has been set at naught by the last order of 31st, where it is contemplated that it is the special officer who is to serve a fresh notice and hold the meeting. Let him hold the meeting. I do not object. I have no problems. What is happening is, in this process, November is coming. And if November comes, there will be a action at the behest of some persons, who will be enjoying the fruits of everything, not at the cost of a statutorily elected board managers.
What will happen in November?
Because November, the promoter is inclined to hand over, charge. The deadline is November. Your lordship extends the time. I have.
Bhattacharya, how do you deal with this three? Only this part tell me. 1B says, where an apartment owner transfers his apartment by such and such to any person, he shall
1B comes at a stage.
no, he shall cease to be a member of the association, and the transferee becomes immediately a member.
Undoubtedly so.
If the
But
transfer
it has
happens
to be-
prior to the election,
it
what is this?
Yes, it has to be read along with C1C, subject to correction.
All right.
Where more than one persons jointly own an apartment, such person shall nominate one of them as a member of the association concerned before submitting Form 1.
That is regarding more than one person.
Before submitting Form 1, who are
That
the...
pertains to where more persons than one jointly own an apartment.
Yes.
That is a different field altogether.
But Form 1, Form 1 is the first thing. Form A is first, Form 1 is
Form
second.
A and Form 1 are two different
Two
things.
different things. Form A is first.
Form 1 has no nexus with Form A.
Form A is first thing. First thing which is to be done is
Are
Form
you
A.
addressing me on Form 1 or Form 1 is not applicable here.
Form 1 is the thing, which is...
Form 1 is applicable only where B says where an apartment owner please let me
I'm
finish.
sorry.
B says where an apartment owner transfers his apartment to a person. And C says where more persons than one jointly own an apartment, such person shall nominate. Now here, where is the question of Form 1 here? You are dealing with Form A.
The entire thing centers around Form 1, if I may say so.
No.
Because, the matter has been disposed of.
Form 1 is regarding one apartment.
No. Form 1 is regarding the persons whose name figure in the list of owners in the total number of apartments. 462 persons, names figure in that Form 1. And kindly sees, I have the original Form 1, the entire details with me. Please see, before the competent authority, this was sent. This is not appended to the writ petition. A part of it is. Kindly sees who is signatory to this typed document. Kindly sees the last page. Please see what is annexed to the writ petition. I may be
pertains to bylaw 3.2.
Yes, 3.2. 3.2.
Probably this is the misnomer. This
No,
form-
it is
form
not.
way.
It is not. With respect, please see page 34 of the writ petition. It is annexed from page 34 onwards. It is not annexed from the entire
These are
thing.
the 462 persons.
These are the 462 persons. Kindly see who has signed.
The copy the
This is this. I'm sorry. This is the document. It has the signature of the. Kindly see who has signed the last page.
Who is appear? He appeared. He was appearing for the not to be added parties. What have you handed over?
Yes. Form 1 was signed. This Form 1 is not a part of the writ petition. What is annexed is the subsequent page. Page 35 onwards is annexed. The signatories to the
Form 1 is something entirely different from Form A.
Yes.
Form 1.
Mr. Bhattacharya, Form 1 is under 131C, and it's written here C bylaw 3.2. 3.2 does not contemplate in Form 1 at all. This says, please, within bracket it's written C bylaw 3.2.
That is Form A.
So it has to be under 3.2. 3.2 does not contemplate any Form 1. It's a misnomer, it's obvious. It must be referring to 3A, Form A.
3.2 is here. Now please see. Formation of association.
3.2 refers to Form A. There is no Form 1 in 3.2.
Yes.
In the bylaw.
with respect.
Please come to the bylaw without respect also,
Not
Mr.
formation of association kindly.
It's not a question of respect. Come to the bylaw. Please
Kind-
read 3.2.
3.2. Within 45 days from the date of acceptance of Form A.
A, not Form 1.
No.
Form 1 is referred to in 3.1c.
Yes.
What is written immediately after this Form 1
my lord,
nomenclature?
my lord.
No, what, my lord? After the Form 1, what's written there within bracket? Read your form.
No, not my form.
Whoever's form. The one which you have relied on.
Bylaw 3.2. Yes.
Who does not mention any form,
With
form 1.
respect, may not kindly cease. Or within such further period of competence on application made to it or of its own motion may allow the apartment.
Mr.
owner-
Bhattacharya, we are not on this section.
Yes.
I am saying, I am putting one question to you. 3.2 does not speak about any Form
No,
1.
it does. It does. May not
On one.
respect. Yes. It does.
At the end.
No,
that's
it
the-
does. Kindly cease the entire section. May not pardons me for saying this. May
Read
not kindly pardons me.
Read it. Just see the reference to Form
But as
1 in
the
3.2.
competent authority on application made to it or of its own motion may allow the apartment owners of each property shall in a general meeting to be held on such date and at such time and place as may be decided, such owners and to be presided over by an apartment owner chosen by the apartment owners present in such meeting, form an association under some specific name and style, and the apartment owner presiding over such meeting shall immediately communicate the formation of such association, along with the names of the members thereof in Form 1.
So you say this is a different Form 1 than.
No, this is the Form 1.
What
the one
about
that I have
C?
handed
1C?
over.
What about 1C? That also speaks of a form.
But
Those
one
are
C
different.
says, once,
Those
no,
are different
no,
Form 1s.
no, the same Form 1.
So the genesis is Form 1,
Form 1.
1C.
3.1c says the names whose name figure in Form 1 may not, there may be cases, a person may be more than one apartment owner, the owner of more than one apartment, a
That is
joint,
Form 1.
that is Form 1.
And what is this Form 1?
Same Form 1. It is the same Form 1. There are no two Form 1s. Where more than one persons jointly own an apartment, such person shall nominate one of themselves as a member of the association concerned before submitting Form 1. Here, before submitting Form 1, may not insofar as some of the persons have made X and not himself, or herself and not Y. This is the goof up. This is the problem.
No, perhaps not.
The goof up is a better word than problem in this
But-
case.
May
Oh, you are also there?
I just take one
No,
minute?
let him finish. Yes. Yes,
That is
sir.
not the,
What else?
Now, the Form 1 contemplated in 3.2 was submitted in that meeting. When the meeting was held, the Form 1 was submitted and the association was approved. Now it goes to the second stage of, second stage of conduct of SGM for the purpose of holding election. Where do we get it? Please see 7 now. Kindly see 7. Rule 7. And kindly reads it with Rule 8.
Yes.
Please see 7.
7.
Has my lord very kindly got it. Constitution of a board and its functions. There shall be a board in respect of each association to carry on the management and affairs of the association and to exercise all such powers, etc., etc. Now, my lord kindly ignores 8 now. Kindly come. The number of managers is 7.2. Election of managers of the board. Within 15 days of formation of an association under 3.2. Association 3.2 by submitting Form 1. The apartment owner presiding over the general meeting. Here the apartment owner presided over in the general meeting contemplates my learned friend's client, the writ petitioner. Referred to in the said clause shall serve notice upon each member of such association. Such association falls back to Form 1 association.
Let me get this clear.
I'm-
Mr. Bhattacharya, are you saying that the members for the purpose of the election has to be fixed on the members who have been formed under
This is the
3.2?
first election. This is the first election.
You say this election,
This election is the first election of board managers. There was no previous board managers.
the election contemplated in Rule 8, for participating in that, the members who are to be considered are only those 3.2 persons.
3.2%.
3.2 persons.
For the first time.
That appears to be true.
Yes.
Yes.
For the
So
first
that
time.
is your case.
Yes.
After that, whoever is
Whoever is
the transfers,
Yes.
Very
Will not a person who is buying today, definitely he has a right to will not get his name incorporated. Will not,
Yeah, very well.
will not
Yes.
kindly visualize.
Yes.
Will not, this is not something unheard of. Will not, if a person will not.
No, Mr. Bhattacharya, we need not go into Form 1, Form A for this. 3.2 says these persons will be the members, and 8 clearly says within 15 days of formation, such and such date of an association under 3.2, the apartment owner presiding over the general meeting, such and such. The general meeting the
Shall
election-
serve notice upon each member of such association.
and the election. Yes, I get your point.
Yes.
So you
there-
want to fix it at 3.2.
Yes.
3.2, there is the number is 462. You say it cannot be more for the purpose of this
It
election.
cannot be more or less. The
More or
the
less for
special
this election.
officer in terms of the honorable court's order has.
No, less
served
it can always be, sir.
Yes, of course. Well, 462 members were put on notice by the
Very
learned
good.
special officer and the learned and the meeting was also held.
Very good.
That meeting will not ultimately, virtue of the subsequent order made by the
And
court.
up to Justice Bhattacharya's order, the last position was these 462 members, the election had to be held with them.
Yes.
So it cannot be made elastic.
Now, Miller, 31st July 2023 is an order made by the court.
Yes, yes.
Has my lord got it, Miller? 31st July order in Can 2.
No, that I haven't.
Miller, that is, Miller, I'm told Mr. Mukherjee had handed it over to.
30, yes, yes,
Now, please see that.
yes.
In that, Miller, your lordship is looking at Can 2. Miller, I think, Miller, in your lordship's records, Can 2 will be available.
No, what was the order passed?
Miller, yes. This is an application for modification of order dated this.
This is the additional remuneration.
Filed by directing the respondent number 2 issue a notice of the special general meeting under the relevant bylaws of this. The first order of the writ petition was passed on this, whereby the court found that the order of the competent authority to amenable to challenge on several grounds. This is ignored it by the next order, which is subject matter of the present application. The court found that the only thing which remains to be fixed is the date for holding SGM in terms of the relevant bylaws. Now here, her ladyship modified it to direct him to, in fact, physically hold the SGM. Upon notice. Now, this SGM has already been held. That has been set at naught by because of this observation made by the court. Please see the last but one paragraph of the ordering portion. Can 2 is accordingly allowed. Has my lord very kindly got it? The next paragraph after that. If any of the respondents have taken any steps pending the application for modification, that would be deemed to have been taken at the risk and consequences of the concerned respondents. We accepted. We never went up anywhere. We accepted the position. We accepted this portion of the order. Can 2 is accordingly allowed and disposed of by modifying to record that the additional remuneration of the learner was fixed to mean the special officer would also conduct the SGM. Now, the SGM's notice was previously sent by him to 462 members. Let him once again send it. We do not have any problem. No one is raising any problem. But because of this paragraph in Can 2, kindly sees Can 2. Now, in Can 2, the writ petitioner in paragraph 10, which is not modified and not clarified either. Can 2 next. No, this is the Can 2. And this is paragraph 10. I'm reading it for your lordship. Furthermore, it is stated that clarification regarding I'm sorry.
You please continue. Mr. Bhattacharya, please continue.
Furthermore, it is stated that clarification regarding Form 1 is vehemently required as far as after submission of Form 1. Several units of flats have been resold to many residents whose names have not been incorporated in Form 1. Those persons are not before your lordship's court, as they were not the owners at the point of time. The election under the such and such is a democratic process, and every member resident has their fundamental right to participate as well as to cast their votes in such election. As in the instant case, there are several residents whose names have not been incorporated in Form 1. If opportunity is not given to them in participating in the election as well as cast their votes, they would be rendered the intention of the statute is nullified. This modification was not granted by the court. This was also a modification paid for. Kindly sees the prayers in this application. Kindly sees the prayer. This portion was not modified to allow him.
Sir, not even argued before the court.
To allow him. We have got nothing. We want this democratic process to take place. Nothing else. Nothing beyond this. Nothing outside this. We have never raised these issues about outsiders, insiders.
So, Mr. Bhattacharya, the Justice Bhattacharya's order said
Hmm.
to record that the additional remuneration such and such was fixed to mean that the special officer would also conduct the SGM.
Yes,
Now, previous SGM goes. Now,
goes.
this SGM
Yeah,
is the one
now
just.
we want that
Shall-
SGM to
The
take
very
place.
crucial line is also conduct the SGM in the backdrop of the continuing dispute between the petitioner and the respondent of 4. This is very vital because Justice Bhattacharya's order clearly says that there is a continuing dispute between them and you, and he has to hold the conduct the SGM in the backdrop of that dispute. That means he has some discussion to decide also.
So if he wants, Milord, that the 462 original Form 1 members, if your lordship gives this clarification, Milord, simply speaking, Milord, we all want. Incidentally, I have only been arraigned as party. Milord, our persons, Milord, our application in view of the disposal of the
So,
canton.
Bhattacharya, it requires a clarification of Justice Bhattacharya's order. Otherwise, it cannot be resolved. Because this
Yes.
backdrop is proving the
Absolutely.
sticking point.
And in view of, Milord, the averments made, and in view of the
Whatever order I pass on this, either 462 or these new members, that will be a modification of this order. Has to be or a clarification at least. I cannot
this
clarify
is in
someone
the
else's
garb
order.
of, Milord, with deepest of respect to your lordship, it is further made clear that any continuing dispute in the last order, Milord, the last order made by the court,
That same order.
it is, yes, same order.
Yes.
It is further made clear that any continuing dispute between the parties manifested in events subsequent to the orders would be matters for consideration before the learned single judge.
Then I decide.
Yes.
Lord, may I just make one submission to cut it
No,
short?
no,
Lord,
more than
I
that.
have,
More
I
than
have,
that, Mr. Thakur.
Lord,
I assure you. Yes, Mr. Bhattacharya, complete that.
একটা আরো বলবে?
So I've heard the matter.
Only thing is,
I was the intention.
Sir,
My
the
intention has
intention-
been frustrated by the last line.
yes, I want a decision, I want the election to take place. I
Yes,
need
very
the
well.
election to take place.
Obviously, you won the election.
SGM to take place and election to take place and
Very
not
good.
go in the hands of, Milord, some outside agency who is going to take care of the helm of the affair.
So you say bylaw 3 read with 8 also touching 7 can give only
One-
one interpretation that the 462 members they should be the persons.
The one, Milord, and for obvious reasons, the original Form 1 in its entirety has not been appended to the writ petition.
Very good.
Because it bears the signature of the writ petitioner himself, who has disclosed the names of this 462 person. He now cannot say something else.
I'll keep a copy of the form
Yes,
on record.
yes. Grateful, Your Lord.
Subject to you giving a copy to.
I mean, Didish,
Very
he has it. I will give it. I have given it.
Let me hear Mr. Thakur. Yes.
Lord,
Mr. Mukherjee, take your seat.
in
You're the
my,
neutral citation here.
in my humble understanding, Lord, my
Oh,
lord
you-
need
The
not,
special officer has to have a seat. Yes.
my lord need not go into all these factual aspects for the present.
You tell me what I should go. What should I go into?
I'll not take it that way.
Yes,
Lord.
Mr. Chakraborty, what?
What I'm saying is that
Would you agree to the 462 members being the only
whether the
person?
statute says that Form 1 would be the electoral roll. It doesn't say that. Lord, kindly take 3(1)(a) for a second.
Yes.
What is being projected before your lordship, perhaps that is not that cannot be the intention of the statute. Kindly have a look at
So you
3(1)(a).
want to stress on immediately?
Yes.
3(1)(a)
So-
immediately?
So kindly read with me 3(1)(a) and B for a second.
Yes.
There shall be in respect of each property and association and each apartment owner of such property is a member of such association. Lord, one admitted fact is there are 462 units. So member is 462, it cannot go beyond that. It can be lesser than that because the explanation of rule 3 says if one person, Lord, purchases more than one flat, he will be one unit. So it can be less than 462, but not more than 462. Now, the moment I purchase a flat in this apartment, I become a member. I become a member of what? The association that is formed. So, Lord, kindly visualize a situation. What is the agony of the special officer perhaps is that after the sending of the, Lord, first comes Form A, by that we wrote to the competent authority saying that X is the name of the association, kindly allow us to form it. The competent authority says yes, within 45 days from that, we sent, Lord, names of the members,
means
the
the original members.
the original members. They send, Lord, they hold a meeting in terms of 3(2), send a Form 1 to the competent authority for registration of the association with the names of its members,
The original members.
the original members.
462.
462.
Right?
Now, Thereafter, according to the statute, within 15 days, the special general meeting should be conducted. It is not conducted today in this case. Now, in between, after submission of Form 1, there are several persons who have transferred their flat and several new entities have come.
That is after that 15 days.
After
But-
that 15
but
days,
before-
I am not sure whether after that 15, but after Form 1 submission.
All
But before the election, today there is no election. So in between this time, the Form 1, if I'm not wrong, was submitted on 12th of March 2023. So from March 23 till today, there may have been transferred, even there may have been transferred before that, because the association was not consulted. Members have submitted it. Now kindly appreciate one thing, under 3(1)(a) and B, purchaser and subsequent purchasers become member automatically by operation of the statute. So I become a member by purchasing a flat from Mr. Bhattacharya on resale, but my name doesn't, it is not mentioned in the Form 1, his name is mentioned. He cannot vote. He cannot vote because he is no longer a member, but I am a member. Despite being a member, according to his submission, I cannot also vote. Lord, Form 1 is not the electoral. Form 1 is not the electoral roll. Form 1 is a document by which the association is given birth. Form 1 cannot be constituted to be the electoral roll. When I go to hold an election, when there is a special officer, he has been directed to issue notice. Lord, I have 2-3 emails of the members who have purchased subsequently. He must have been informed by many that we want to vote. We have purchased subsequently. What would happen to their right? Lord, this act does not say that Form 1 will have to be taken as the electoral roll. Kindly see Bylaw 7 and Bylaw 8. It doesn't say that. Kindly have a look at Bylaw 7 and Bylaw 8. Bylaw 7, there shall be a board in respect of each association to carry and manage the affairs of the association and the exercise all such powers. Then 2, the number of members of equal to 1/3. Then 8, take within 15 days from the formation of the association under clause 2 of Bylaw 3, the apartment owner presiding over the general meeting referred to the said elect clause shall serve notice upon each member. Lord, here this apartment owner is in me, the petitioner. I presided over that meeting. Lord, why the writ petition was filed? Lord, what happened, I tell you, Lord Similar. I hold the Form A meeting. I submitted Form 1. Lord, I was supposed to call this 8-2 meeting in terms of the statute. The competent authority out of nowhere suddenly directed Mr. Bhattacharya's client to hold the meeting. Because in the meeting that I called, instead of special general meeting, I said extraordinary general meeting. For quoting a wrong nomenclature, I was removed. My statutory right was taken away and he was given the right, wherein he is a nobody. What has been said by the special officer yesterday is absolutely correct. He has got a right created in his favor by the order of the competent authority, which has been set aside by my Lord Justice
You
Bhattacharya.
are not on your right.
I'm not on
You
that.
are only on the question whether the new
Whether-
members have to come in
Yes.
or they don't.
Now, my Lord, if the
on
statute
that.
doesn't
For
say,
this present purpose.
yes, if the statute doesn't say that the Form 1 is the electoral roll, then whoever is the member today would have a right to vote. And Lord, he cannot be prejudiced by that. Then if he is not prejudiced, then there is no necessity to stop the special officer from giving notice or ascertaining whoever. Lord, he can issue a public notice in the apartment notice board. There is a group of the apartment. He can post it there. And whoever is the member, he will write back to him. Yes, we have
Sir,
purchased.
Chakravarti, tell me this. Please come to 3-2 once.
3-2, my Lord.
3-2 contemplates
grateful to
that
your
within such and such date, 45 days, Form A has to be given and
Yes.
such and such.
Yes,
The association is to be formed.
yes.
The association form, the corollary of that is shall immediately communicate the formation of such association along with the names of the members in Form 1,
My Lord.
along with the copy of resolution and attendance sheet. So as on that date, as on the date when the Form 1, this Form 1 is given, as on that date, there were 462 members.
Yes.
That is a crystallized number
Absolutely.
that cannot, as on that date, there cannot be any dispute on that. So as on this date, this was the position, these 462 members. So we cannot go back to that date to look into transfers because as on that date, this was the association. So that association has been referred to in 7 and 8 now.
My Lord.
Now, what is the question of the transfer is coming in at this juncture between 3 and 8?
Because had it been a
But
case that the
I'll
election.
just complete my thing
so
and
sorry.
then you answer that. Let us come to 8 once, Mr.
My Lord, my Lord.
Within 15 days of formation of an association under 3-2, which has been formed 462, The apartment owner presiding over the general meeting referred to in the said clause shall serve notice upon each member of such association, fixing therein the date such and such, then the special general meeting. So where is the question of the transfer is coming in at this juncture before the election?
Had it been a case that the election was conducted within 15 days, as per 8.1, this question would not have arisen. Today, from March till September, 3-4 months have passed in between. There are transfers in between, and in terms of 3.1a, those persons have become members automatically. 3.1b. Lord kindly appreciates the situation. Had the election been conducted within 15 days, Lord, that Form 1 could have been construed as an electoral roll. But today, since on the teeth of the fact that there are several transfers in between, Lord, tomorrow kindly take a situation that tomorrow a new customers come to your lordship, a new purchaser. A new purchaser comes to your lordship.
I don't sell.
A new purchaser comes to your lordship
Yes.
and says that I have purchased a flat, I will have a right to vote. Now, this statute doesn't take away the right to vote of that gentleman, because Form 1 is not described as an electoral roll in the bylaw. It is silent. So if we read 3.1a and b along with 8, it has to be, Lord, in my humble submission, that whoever as on date is a member by virtue of a purchase would be entitled to vote in the election. And since kindly appreciate the situation, SGM has not taken place till date. He is going to issue notice. Mr. Bhattacharya's client is not going to suffer any prejudice if the new owner comes, because they are automatically become members. Now, if we restrict it to the Form 1, the persons who are subsequent purchasers, they would be deprived. And the statute, not intention is not that. Otherwise, it would not have been mentioned in 3.1b that automatically there will be a cessation of membership, automatically there will be a new membership. It's absolutely clear. The moment, even if today someone sells and someone purchases, the person named in the Form 1 will cease to be a member, the new purchaser will become a member. So, Lord, there is no dispute at all. And one more thing, the SGM, in the SGM, the members will decide the mode of election and the manner of election. That is 8.2. 8.1, 8.2. So that stage has not arisen. We are pre-8.1 stage. Pre-8.1 and post-3.2 stage. So in between, transfers have taken place. Let them be, Lord, given a notice. This is my, I don't want to argue anything. And Lord, before Justice Mausami Bhattacharya, Lord, this point was not argued. Her ladyship, Lord, we have only said that Mr. Bhattacharya's client, after filing this, conducted an SGM, which was illegal. It should have been conducted by the special officer. The court has accepted it and they have also accepted it. So today there will be a fresh SGM. But I bow down to your lordship. My lord says that it will be with original members. It will be original members. If it is with the new Lord members who have purchased, it will be with the new members.
Madhava.
Lord, only
Yes. এটা ইয়ে হবে না, এটা মিথ্যা সাইটেশন হবে না, কারণ ডিসক্লোজার হচ্ছে না, কিন্তু রিপোর্টেবল হবে। The matter was mentioned at the behest of the learned special officer appointed by the coordinate bench in connection with passing interim orders regarding holding of elections of an association in connection with WPA 11321 of 2023. Push up next para. With the order dated May 12, 2023, the court had directed inter alia that Mr. Arjun Mukherjee, learned advocate of the Bar Library Club, was to be appointed as the special officer to ensure that all 462 members of the housing complex are served for the special general meeting. Push up next para. However, subsequently a dispute arose with regard to certain transfers having taken place at the behest of the original allottees of the said housing, in favor of third parties. Push up next para. The writ petitioner sought to allege that the said transferees would automatically become members of the association, comma, thus having a voting right as well. Full stop. With the order dated July 31, 2023, comma, on Can 2 of 2023, filed in connection with the writ petition, comma, the learned single judge was pleased to dispose of Can 2 of 2023 by modifying the order dated May 17, 2023, comma, which had been passed in the meantime, comma, to record that the additional remuneration of the learned special officer was fixed to mean that the special officer would also conduct the SGM, তারপর double inverted, in the backdrop of the continuing dispute between the petitioner and the respondent number 4, double inverted close. Full stop. The special officer was also directed to take necessary steps to do the same. Full stop. Next para. It was also recorded that if any of the respondents had taken any steps pending the application for modification, that would be deemed to have been taken at the risk and consequences of the concerned respondents. Full stop. The learned single judge, the said coordinate bench clarified that any continuing dispute between the parties manifested in events subsequent to the orders dated May 12 and May 17, 2023 would be matters for consideration before the learned single judge, who presently has determination to hear these matters. Full stop. Next para. The reading in conjunction the said observations of the learned single judge, comma, it is clear that the conduct of the SGM was to be in the backdrop of the continuing dispute between the petitioner, comma, which was to be resolved for the purpose of holding the SGM by the present bench, comma, which now has determination to hear such matters in regular course. Full stop. Next para. The learned special officer submits that the dispute arises regarding whether the election would be confined to the 462 members, comma, who were originally mentioned in the order dated May 12, 2023, or the transferee members who have come in place of their original transferors in the meantime. Full stop. Next para. Learned counsel appearing for the respondent number 4, comma, while opposing the proposition that the transferees should come in, comma, places reliance on bylaw 3 of the West Bengal Apartment Ownership Bylaws, comma, 2022. Full stop. In terms of the clause, in terms of clause within bracket 1, within bracket small a of bylaw 3, comma, there shall be, comma, in respect of each property, comma, an association. Association যেখানে use করছি a capital হবে. An association, and each apartment owner of such property is a member of such association. Full stop. Crucially, comma, subclause small b of clause 1 provides that where an apartment owner transfers his apartment by sale, comma, gift, comma, etc. to any other person, he shall cease, CEAC, to be a member of the association concerned from the date of the sale, gift, etc., as the case may be, and the transferee becomes immediately a member of the said association in place of the transferor. Full stop. Hence, comma, clause 1 within bracket small b of bylaw 3 clearly provides that the date on which a transferee becomes member is immediate on such transfer taking place. Full stop. Read in such perspective, comma, clause bylaw 3 within bracket 1 within bracket, sorry, bylaw 3 within bracket small within bracket 2 stipulates that within 45 days from the date of acceptance of form capital A by the competent authority, CA capital competent authority, or within such further period as the said authority may allow, comma, the apartment owners of each property shall in a general meeting as provided therein, comma, form an association under some specific name and style and the apartment owner presiding over such meeting shall immediately communicate the formation of such association along with the names of the members thereof, in Form 1, along with the copy of the resolution and attendance sheet of the meeting to the competent authority, who shall register the association under a serial number and issue a registration certificate in Form 2. Full stop, next para. It is contended that bylaw 7 provides that there shall be a board in respect of each association. Full stop. Bylaw 8 within bracket 1 provides that within 15 days of formation of an association under clause 2 of bylaw 3, the apartment owner presiding over the general meeting referred to in the said clause shall serve notice upon each member of the association of such association, fixing the date, time and place when the special general meeting shall be held for deciding the detailed manner on which the election of the managers of the board be held. Full stop. It is, thus, submitted that after the submission of Form 1 within the contemplation of bylaw 3 within bracket 2, there is no further scope for modifying the voters list for the purpose of such first election as envisaged in bylaw 8. Full stop. Next para. Learned counsel appearing for the writ petition, the other contesting party on such proposition, controverts the submissions of respondent number 4 and argues that the language of bylaw 3 within bracket 1 within bracket small b is explicitly clear to the effect that the moment a transfer is effected, the transferee becomes immediately a member of the said association in place of the transferor. Full stop. In the present case, although the Form 1 did not take into account subsequent transferees, which it could not do, the subsequent transfers mean that the transferees automatically became members of the association as on the date of their transfer, which took place before the election in the present case. Full stop. Hence, bylaw 8 should be read in the light of clause 3 within bracket 1 within bracket small b to mean that the special general meeting to be held had to be participated not only by the original owners of the flats, but also the subsequent transferees in place of their respective transferors. Full stop. Next para. It is further argued that if a contrary view is taken, an absurdity would arise, since on the date of the election, not all the voters will be actual present members of the association. Full stop. Upon an anxious consideration being given to the arguments of both sides, certain facts come clear from the materials on record. Full stop. Next para. It is seen clearly that as on the date the initial order was passed by the learned coordinate bench on May 12, 2023, appointing special officer, the number of members of the association in question were 462. Full stop. The Form 1, which was submitted pursuant to bylaw 3 within bracket 2 of the 2022 bylaws, also contained specifically the names of only those 462 members. Full stop. Hence, as on the date of submission of Form 1, there cannot be any manner of doubt that irrespective of transfers before or after, the members of the association were fixed and crystallized at those 462 members named in such form. Full stop. Next para. A careful reading of Rule 8, Bylaw 8 of the 2022 bylaws shows that the same refers to the within double inverted each member of such association, double inverted close, as the intended notices for this special general meeting. Full stop. Next para. a composite reading of the relevant bylaws as discussed above, comma, go on to show that the scheme of the bylaws is that the members of the association who are named in Form 1 submitted under bylaw 3 within bracket 2 are the members who are to participate in the first election. Full stop, next para. By a turn of fate or due to delays in the formation of the association beyond the period of 15 days as mentioned in bylaw 8, comma, the election process is delayed, comma, the same per se cannot cannot be a sufficient stimulus from deviating from the scheme of the said bylaws. Full stop. If a different view is taken, comma, the situation would be that if the election or the special general meeting contemplated in bylaw 8 is delayed indefinitely, comma, there would be umpteen transferees in the meantime, comma, and the election could never be held, or any number of members could not be fixed at any point of time, comma, since the members of the association may always be fluid. Full stop. Next para. Hence, comma, a finality has to be lent, L-E-N-T, to a particular point of time, full stop, since bylaw 8 clearly refers to the to the members of the association as contemplated in bylaw 3 within bracket 2, comma, the same is a relevant consideration for deciding as to who are the participating members in the SGM. Full stop. In the present case, comma, there was no doubt that the 462 members mentioned in the Form 1 were the relevant members of the association at the point of time which is to be considered, that is the submission of Form 1. Full stop. The submission of Form 1 crystallizes the association to the members whose names are contained therein, comma, which also is followed by the consequence that the said association shall be registered under the serial number and a registration certificate issued in Form 2. Full stop. Hence, comma, the association within double inverted association contemplated in bylaw 8 is definitely the association which has been registered pursuant to bylaw 3 within bracket 2, which in the present case, comma, is confined to the 462 original members. Full stop. Next para. A relevant point which has a very arguable point which has been raised by the writ petitioner is whether the transferees, comma, who have acquired rights immediately upon such transfer as per bylaw 3 within bracket 1 within bracket small b of the 2022 bylaws, comma, would be deprived from the right to cast votes, comma, despite being members as on the date of the election. Full stop. Next para. However, comma, in view of the discussions above, comma, and keeping in mind the specific scheme of the bylaws, comma, a legal myth has to be constructed in the present case. Full stop. The original members whose names found place in the Form 1, comma, on the basis of which the association was registered in the first place, comma, has to be deemed to be the within double inverted association for the purpose of participating in the first special general meeting to hold the election as contemplated in bylaw 8, comma, irrespective of others having acquired interest in the respective flats in the meantime. Full stop. The transferees in the meantime, comma, who come in after the submission of the Form 1 and the election being held, comma, have to be subjected to the scheme of Rule 3 within bracket, bylaw 3 within bracket 2, read in conjunction with bylaw 8 within bracket 1, comma, which unerringly indicates that the number of members of the association has to be fixed at the Form 1 members, comma, on the basis of which the registration was granted to the association for the first special general meeting. Full stop. In such view of the matter, comma, the dilemma which is arising in the mind of the special officer can be resolved by holding that the number of members shall be restricted to the 462 members who found place in Form 1 for the purpose of registration of the association concerning the present housing society as per bylaw 3 within bracket 2 of the 2022 bylaws for the purpose of issuing notices and holding the special general meeting and the consequential elections. Full stop. Hence, comma, the learned special officer is requested to take immediate steps for completion of the process of notice on the 462 members, comma, if not already concluded, comma, and to conduct the election at the earliest, comma, in compliance with the orders passed by the coordinate bench. Full stop. A comprehensive report in that regard shall be filed by the learned special officer on the next date of hearing, when the writ petition shall be listed for final hearing, along with the
But
filing.
the writ petition is
It is
disposed of
disposed
already.
of.
Very good.
Let it come for the report.
Then no report is required. I cannot
No,
use.
only one thing, elections to be conducted by the special officer.
But
Your
ca-
lordship.
1 minute. Mr.
Yes,
I'll just hear you.
be conducted by the
যেখানে,
special officer.
SGM is
হ্যাঁ, হ্যাঁ,
Let the election also be conducted by
এটা
the special
উড়িয়ে
officer.
দিন, আর রিপোর্টের ব্যাপারে।
to-
নেক্সট প্যারা, it is made
করুক
লাস্ট
না,
তার আগেরটা কি কোথায় শেষ হলো বলুন? হ্যাঁ, তারপরে দেখুন, it is made clear that since the writ petition has already been disposed of, comma, no further question can be gone into within the conspectus of the present writ petition. Full stop. However, comma, needless to say, comma, if any of the parties to the writ petition has any grievance regarding the election process or subsequent consequential acts of either of the parties, comma, it will be open to the parties to challenge the same in a subsequent action constituted in due course of law.
Only one humble request, his, the brief was to only hold the SGM,
Not the election.
not the election. Kindly seize 31st
But
order.
I would pray that let him also
No,
hold
no,
the
no,
election, but otherwise,
Cannot modify
His
that.
brief
but
was,
after the SGM,
But
there
kindly
is a
since
dispute
31st
who will
order.
hold the election.
লাস্ট লাইন যেখানে শেষ
Let him
হলো,
act
তার
as
আগে
the
তারপর
election
এই
officer.
কাটাটা আগের পাতা যা, আগের পাতে লাস্ট লাইনটা বলুন।
that is to be decided in
Let
the
him
SGM.
supervise the election.
And that is to be decided in the SGM.
Yes, Mr. Orle. Yes.
The learned special officer is requested to take immediate steps for completion of the process of the notice on the 462 members as it is not already completed. And to take and to conduct the election.
And to conduct the election at the earliest ticketed in, and to conduct the proposed special general meeting within bracket SGM at the earliest. Full stop.
But
তারপর
SGM
কিছু
is a
প্রকাশ-
part of the election
No,
process.
No, whatever order was passed, let that be restricted to that.
Yes.
That's the পরে
Great.
এটা দেওয়ার দরকার নেই। আর তারপর কিছু দেবেন না। Put regular. SGM last. So only up to that.
My-
Deeply obliged.
Please take this back, Mr. Bhattacharya, and Form 1 also, there is no dispute regarding the Form 1.
No.
They're not disputing these 462 members being there in the Form 1.
He himself has signed. How can he dispute?
I am not disputing.
So that's why I'll not keep it on record.
What I can and I cannot not, I am not here. I am not disputing it at all. I also want the election to take place.
Now I also want the election to take.
Yeah.
Very good. Next one.
Grateful.
Tako.
Top matter, item 3.
Ready রাখো, পর ফাইলটা রেডি রাখো, ফটাফট যাও। Yes, Mr. De.
I'm for the petition of my.
Right.
Opposite on behalf of the private respondent.
What is the matter, Mr.?
The petitioner is a enrolled learned advocate before the learned district
Mr. De,
judge
please come.
at Tumluk, my lord.
Yeah.
The petitioner was enrolled on 20 in the year 1998. My lord, the petitioner is practicing since 1998. The petitioner has made an application to be enrolled as a notary public pursuant to an advertisement made by the competent authority. The application was made in the year 2012. The petitioner was interviewed and the process went on, but the petitioner was not successful. the private respondent was selected as the competent person. My humble submission before your lordship is that the private respondent who has been selected does not have the basic qualification to make an application. But the reason is that the private respondent was in service. She retired in service in the year 2011. Thereafter, she started her practice and she made the application in 2014. The prescribed rule says that she has to be in continuous practice for 7 years before she can make her application.
No, you were not disqualified due to her. It is not like a tender. So you were disqualified independently. You do not fulfill the criteria.
Fulfill the criteria. My humble submission is I had the criteria and I am competent to be appointed as the notary public in place of the private respondent. But I was not successful. The private respondent.
If you are not successful independently, Mr. De, where is your locus to change the other person's success?
But if she is not there, in that case, I come.
Do you come automatically? You are not qualified. You are also gone.
I do have the qualification. I will show to you, Lordship. I have
You are
the
rejected due to her. Can it
Yes.
be? Show me your rejection first. Hey, Oritra, এই পাখাটা নেভানো যাবে দেখো তো। সেরকম কোনো ম্যাটার হলে আমি বলে দেবো তখন পাখাটা চালিয়ে দিই। দেখো। Yes,
Lordship kindly comes to page 37.
37. 37, yes. Your rejection
The list of the successful candidates.
was that. You do not you are disqualified because you don't have the criteria. You don't meet the criteria.
Or that was never said by the authority concerned. The authority concerned published a list of the successful candidates.
How many posts were there?
Only one.
There is a number of posts.
Yes.
As a very yes. Let us see.
And if your Lordship kindly comes to page 40, serial number 16, the name of the private respondent appears.
As which criteria is not filled by her?
Follow the basic criteria that she has to be in practice for continuous 7 years before making an application.
Right.
I will show to your Lordship the relevant rules.
So she was in practice for?
She was in service up to 2011. Thereafter, she started practicing and she made an application. In the application also, she has admitted that.
So 3 years practice.
3 years practice.
And you had?
I was in practice since 1998. I made the application in 2012.
Good. Show me the rule.
Yes, madam.
Yes.
Lordship kindly comes to rule 3.
Yes.
Qualifications for appointment as a notary. No person shall be eligible for appointment as a notary unless on the date of the application for such appointment.
So rule 3A.
Rule 3AB. Rule 3A is for the petitioner. A person had been practicing at least for 10 years, or AA, a person belonging to scheduled caste or scheduled tribes and other backward classes had been practicing at least for 7 years, or AB, a woman who had been practicing at least for 7 years as a legal practitioner. Now, Lordship, she made an application before this Honorable Court, wherein in paragraph 4, she clearly stated that your applicant states that the applicant enrolled her name as a member of Tumluk Bar Association on 1/2/2002, but she was started and or continues her practice as an advocate from the year 2011. This is her application at paragraph 4. The application is on record. So she admits that she has started her practice in 2011 and she makes the application in 2014.
What was the occasion of that application?
Well, she made an application for variation of the interim order that was passed in this writ petition earlier.
What is the can?
Well, can number 1 of 2023. It was disposed of on the last occasion by my lord.
Where does it say that? She say that?
She says in paragraph 4 that your applicant states that the applicant enrolled her name as a member of Tumluk Bar Association on 1/2/2002, but she was started and or continues her practice as an advocate from the year 2011. No affidavit in opposition has been filed in the instant writ petition.
So whether enrollment is practice?
No.
Under this
My lord, in my humble submission, the rule is very clear. The rule says
practice.
on the date of the application for such appointment, no person shall be eligible for appointment as a notary unless on the date of the application for such appointment for the lady, for the
She practices at least.
who had been practicing for at least 7 years. Therefore, it is not the date of enrollment, but the span of practice.
Very good. What else?
This is my basic submission, my lord.
No superficial submission. Don't keep something up your sleeve. Later on, you'll be saying that when I pass my order. Finish it, Mr. De. Whatever you have to say.
This is my basic premises on which I have based my writ petition. And the selection order have shown to your lordship, she has been selected.
And what about your qualification? Why where you held not to be?
That has not been stated anywhere why I have been disqualified.
Let us say that. Yes. Affidavits were not directed in this matter.
Affidavit was directed, but no affidavit has been filed.
Very well. Yes, Mr. Banerjee.
I was briefed, 3 days back. In my brief, I have been favored with a copy of an affidavit in opposition. I was under an impression that there is, but now my learned advocate on record says there is an affidavit.
Mr.
Upon long
Bhattacharya
back,
is there?
I am not.
No, it has not been filed then.
But
I
I
can
am not
assure you,
relying
yes.
on that.
Mr. Lokinath Bhattacharya is on record. Then it has not been filed. He sat with me.
I have not received, my lord.
No.
Presumption is it has not been filed. Yes, yes, Mr. Banerjee.
I do not rebut that.
Yes.
Kindly, have a look at Rule 8 once. My learned
Right.
senior friend has handed over the rules.
8.
8 3. Sub Rule 3.
Right.
This procedure has not been exhausted. Before filing, praying for a writ of mandamus. The rules provide for a grievance redressal mechanism. There is an authority constituted for that.
It was filed within 60 days. I don't think so. That we can extend. And what else on merits?
On merits, but it will kindly have a look at 2 documents from the writ petition. Kindly take.
Acha, the private respondent is represented.
I am the private respondent.
You are for the lady.
I am for the
Acha, very well, yes. What about you? Was this practice?
The
Enrollment-
rule says
Yes.
legal practitioner. Doesn't say advocate.
A woman who had been practicing at least for
as legal practitioner, there is a further qualification.
as a legal practitioner.
I was in a school, serving as an assistant teacher, and I was also a legal advisor in certain concerns at the same time. That is what I should have stated in the affidavit in opposition, which is not on board. But that is the fact. I held a conference. That's the fact. It doesn't say advocate.
No, it doesn't.
Now, my lord knows, rules 51, 52, 53 of Bar Council of India rules. Teaching is an exemption.
Anyway, why should I usurp a forum, Mr. De?
And may I rely on a Supreme Court decision if there is a forum provided under the rules, and the writ petition does not say that there is no efficacious alternative remedy.
Cite that, Mr. Banerjee, and whenever you move the next writ petition,
I do not cite
remind
it.
me of that.
I do not
Definitely cite that, and I'll remember that when you move your next writ.
I do not cite.
Yes, Mr. De. Go to the proper forum. Don't lose the forum. So you can delay her more. This is the main intention of your client.
And he is also not eligible. Otherwise.
He will not be eligible.
He is also otherwise
so far
not
the legal
eligible.
practitioner term is concerned, the
Legal practitioner, I have my doubts, but Mr.
Yes,
Banerjee has
even-
made an
even in their-
arguable point.
in their application, they have very clearly stated that they are practicing or continues their practice from the year 2011.
Mr. Dev, frankly speaking, because the affidavit in opposition was not filed, if affidavit in opposition was filed and she took this point, it would be an arguable point, definitely.
No, this is her admission, my lord. This is her pleadings in
In
the
an
application.
application.
In an application.
No, that
She
cannot
made
be
the
a,
application.
that is not an admission. We cannot take a negative admission like
No,
that.
my lord. I can at least
She
submit
has
that
said 2 things. I was enrolled in such and such year. I have started practicing.
from the year 2011.
Yes, but
As an
that does not
advocate.
necessarily mean she could not have imparted legal advice or whatever. Maybe legal advice to Mr. Banerjee.
My performance shows that.
Anyway, no. This is the brainchild of Mr. Banerjee, but let her have that benefit before the. At the outset, learned counsel for the petitioner submits that the petitioner was wrongly rejected as a candidate for becoming a notary in respect of a particular area, whereas the private respondent was selected, although the private respondent did not meet the criteria as stipulated in Rule 3 within bracket small ab of the notaries rules, 1956. Full stop next para. Learned counsel appearing for the private respondent submits that the petitioner did not qualify for the post, while, on the other hand, the private respondent, although not practicing as an advocate in a court of law during the relevant period after her enrollment, had been imparting legal advice. Whose of learned counsel for the petitioner controverts such submission on the score that such averment has never been made at any point of time by the respondent number 4. So be that as it may, comma, learned counsel for the private respondent has taken a more basic objection as to jurisdiction in view of Rule 8 within bracket 3 of the 1956 rules, providing an alternative forum. For sub next para, Rule 8 within bracket 3 stipulates that an applicant whose application has been rejected or allowed in respect of only a part of the area to which it relates, or against whom an order as to costs has been made under sub-rule 1 of Rule 8 may, comma, within 60 days of the date of the order, apply to the appropriate government for reviewing the order, and that government may, comma, after making such further inquiry as it thinks fit, comma, pass such order as it considers necessary. Full stop, next para. In the present case, comma, there is actually scope of further inquiry in view of the factual aspects sought to be highlighted by both parties regarding the qualifications of the respective candidates. Full stop, as such, comma, this court does not want to usurp the jurisdiction of the said fact-finding authority by depriving the parties of one forum. Full stop. Accordingly, WPA 17851 of 2018 is disposed of with liberty to the petitioner to approach the concerned appellate authority under Rule 8 within bracket 3 of the Notaries Rules, 1956, with the challenge against the petitioner's rejection as a candidate for being appointed as notary. Full stop, next para. In the event the petitioner approaches the said forum within a week from date, comma, it will be deemed that the time stipulated for filing such a challenge would be sufficiently complied with within the contemplation of Rule 8 within bracket 3 of the 1956 rules. Full stop. In such an event, comma, the appellate forum shall decide all issues involved within the parties duly in accordance with law without being prejudiced in any manner by any of the observations made here. No rest.
Only one liberty, Lordship, instead of 1 week, Lordship kindly makes it 2 weeks time.
Very good. 1 week within a fortnight from date.
Milord, would it be
Grateful
Milord's
to your
kind
lordship.
pleasure, Milord, also to record my submission that he is not eligible, Milord, to be engaged as a notary public.
Not gone into
Yes. And Milord, since Milord, the writ petition is now disposed of, Milord, the interim order goes. Milord, I have been.
interim order, if any, stands thus vacated.
I'm grateful, Milord.
Yes.
I'm so grateful. Grateful.
Item 4 and 5.
Grateful to your lordship.
Thank you. Yes, yes. Mr. Bandyopadhyay, you are for the state.
Well, I'm for the response.
1850. 1850, he's for the state. My RTI application.
The last occasion, your lordship was pleased to extend the time to file
Affidavit in opposition?
No, my lord.
Report.
Report, my lord, I directed the information to be
What is the matter of?
Just previously filed by Mr. Bennett.
same. The RTI application by me setting out 10 queries.
They have
The first-
answered here.
My lord, not totally, my lord. I'll just indicate, my lord. First reply comes, I'm unsatisfied. I go up to the appellate authority. Appellate authority says, out of the 10, kindly answer this. He does not. I come before my lord. My lord says, kindly file an affidavit disclosing the documents and also information. My lord, most of the information has been sought, that has been disclosed. My lord, kindly takes up page 19 of 1850. My lord, now only regarding 3 queries, the dispute remains. Their opposition page 16 and my writ petition 19, 1850. My lord, for query number 8 and 9, these 2 documents has to be given to me. They cannot say that go and get a certified copy. These are the gazette notification and the records of settlement, because my land has been taken away, which was mutated in after 10 years, mutated in my favor. So these 2 documents are the documents on which their BLR has based his inspection. These have not been given out. My lord, kindly sees page 16 of their affidavit. He has stated that 8 and 9, yes, that from there was a vesting, but he does not gives me the gazette notification, also the settlement order. And my lord, regarding query number 1, my lord kindly comes to page 18.
That whether any order has been passed under the provision of the West Bengal Land Reforms Act, my lord, the petitioner was one of the parties. I say that he did not get any copy of the order. My lord, kindly see the reply. Yes, you are again requested to file a petition for certified copy of Miss case. My lord, the submission that I am making, my lord, there is a legal.
Miscase number is given.
Yes, my lord.
Miscase number is given.
Number is given.
Then why can't you apply for a certificate?
My lord, we had tried. We had broken. My client has gone there. He has broken open his head, but he was not supplied because there is something. In
I'll
there.
say if a certified copy is
Lord,
applied for.
may I just point out one thing? My lord?
Yes.
Lord, the proposition that a certified copy, if there is a procedure for getting a certified copy, that has to be adhered to, and not the RTA Act comes from 2020, volume 4 SCC. My lord, in that case, what had happened that the petitioner in that case had actually asked for a certified copy. My lord, here I am happy with any copy. Let him give. My lord, I'll again apply.
I'll hold this as a proposition of law. If there's a provision for applying for a certified copy, then
But
RTA
I
Act
don't-
cannot be resorted.
But I am not.
If there's a gap, then only RTA Act can come in.
Yes, my lord.
If there is a provision for getting a certified copy, then everybody will take RTA information, and the certified copy, unnecessarily the revenue of the
No,
state
my
will
lord,
be
because I
deprived.
cannot take it up as an evidence before a court of law. That is the difference.
RTA Act you can.
My lord, no, my lord, unless it is certified, my lord, it will just be a copy.
That's why I ask you to take a certified copy, exactly for that reason.
My lord, very well.
And RTA information cannot operate as a certified copy.
No,
The
my lord,
evidence
that
Act
is the
speaks about-
disadvantage I will face.
So take certified copies.
Very well, my lord. I'll apply after.
What about 8 and 9? What do they say?
8,
Where is that?
yes.
Where is their answer? Which page?
That is in page 16, my lord. Query number 8 and 9. They say that yes, there was a vesting, but he does not gives me
Page
the
16 of?
their opposition, my lord. 1850 opposition. There is a fresh reply by the BLRO after filing of this writ application, my lord.
Opposition. That's
That is
My lord, the
handed
report.
out, my lord.
The report.
the report.
Sorry,
The
Page 16.
page 16, annexure R5.
That is not page 16.
কোন এফিডেভিটটা বল দুটো এফিডেভিট
Page 18. in-
1850, my lord, WPA 1850, page 16, annexure
This is 1848 you handed over.
My lord, that
On the last occasion you had handed over.
on the
Ah,
last occasion I had handed over.
Very good. Right. What?
Yes.
Yes, query number
Lord,
8 from the
Query
act.
number 8 from the account of Lord Bhuvaneshwar Das, son of Thakur Das in E Act. My lord, I need the gazette notification. And also for query number 9, it was settled in favor of Kartik Das by settlement case number this and this. My lord, the records of such settlement case. I need.
Records, how can it be provided to you? Extracts, you can apply for certificate copy. If yes, kindly provide the details and records of such settlement. What records will they give to you? And why should they give to a private person?
My lord, because the
Records of the settlement is public document.
yes, my lord,
Take a certificate copy.
certificate. My lord, I-
Records of the document, take an extract. We
yes,
take extracts from the records,
yes.
I mean, records of rights or whatever. If they go on giving copies to everybody who
My lord,
applies,
I'll just, this land which they are saying that it has vested, my lord, 15 years ago, I had bought it. My name was mutated. After that, I changed the nature and character of the land.
then you have to
Last
file a
week-
civil suit and challenge there.
That is under challenge before the tribunal.
That is under challenge. You have your avenues in that civil suit for asking for records.
My lord, before the tribunal also, they are not bringing forward the record.
That cannot be solved by the writ code by directing under RTI.
Very well, my lord, the documents.
You
which my
cannot
lord-
get direct, indirectly what you cannot get direct.
Very well, my lord, the two documents that my lord is saying that I will apply, but let them from my application, 4 weeks, let them.
No,
supply
regarding the details on 8,
Eight.
that I'll ask them why they are not
gazette
furnished.
notification. Yes.
Details of such vesting can very well be given. They've given the name actually,
Yes.
account of what sort of detail do you want?
Lord,
The
whether
date can only be given.
in query number 9,
8.
8.
Query number
Gazette-
8 is regarding that if yes, provide the copy of the notification of details of such
Gazette
vesting.
notification. That can be given.
Acha, very well, very well.
That can be given.
Right.
And my lord, he's saying white settlement case number this and this. If the records of that settlement case may be given,
Records cannot be given to you. You are a private person.
or the copy.
How can the
or
records?
I'm sorry, I'm the copy.
Apply for a copy. They'll give that.
Very well, I'll apply.
I'll record that in my order. That if you apply, they'll have to give.
My lord, within 4 weeks, my lord, and for even for one, query number 1.
One is,
I saw there was a miss case in which under section 49 of the LRTT Act, they say that your vested land you have purchased will remove your name.
so one you will get a certified copy,
Yes,
8 they'll provide the detail,
yes, and 9.
9 will get a certified copy.
Yes.
Let me ask them what about that. Yes, Mr.
Madam,
Bandhavate.
may I submit one thing regarding notification, madam? If it is, my lord, vested to the state, my lord, either in the West Bengal Land Reforms Act or by the Estate Acquisition Act. Well, there is an order, proceedings, my lord, is there. There is no such notification, but if he, my lord, wants the order of the vesting, then it will be provided by obtaining certificate copy. My lord may pass our order to that effect.
No, give the date of that order, at least something.
We shall give it. He will apply, we shall.
No, he has to apply on giving a date of the order. Something has to be given, the proceeding number.
Query number 9, my lord, it is settled in favor of such and such in case number such and such. It has been.
Query number 9, there is no dispute, he'll apply for a certificate copy. If he wants the records,
Then it will be supplied.
if he applies for the records, Mr. Bandhavate, there is a mechanism.
Same answer, my lord.
No. Query number 9, Mr. Bandhavate, there is a mechanism for giving a certified copy if they apply for the extracts.
External certificate copy of the order.
One.
It can be provided.
Very well. And what about 8?
8, my lord, your lordship kindly turn to my lord the RTI application.
Yes.
The-
Page
Probably
19.
the question, my lord, whether the 0.52 acres such and such, tag number such and such, similar question, my lord, in the right. In the order of the, my lord.
Similar question?
Similar, my lord, he has stated, my lord, if yes, please provide the copy of the notification or details of vesting and a date of such and such.
Oh, same dag
Yes.
number. Acha.
Same the number, same place, same plot
Yes.
number. Same.
Acha.
Then the order sheet entire case, my lord, we will provide.
Right. 8 and 9 pertain to the same property. And 1, they'll apply for certificate. Do that. 8 and 9 are same. He's right. I missed out the acres of land.
Yes.
Dag number is same. Everything is same.
Same land. But
So you have
It is not
asked for
necessary.
separately.
We will apply for that point of that case
Gazette.
number, then we will get.
whether the gazette notification certificate copy can be
Why
given.
not? You জানো না
Learned counsel for the petitioner contends that in the affidavit, in the report in the form of affidavit filed by the respondent authorities, most of the queries of the petitioner has been satisfied. However, certain doubts still remain as to satisfaction of query numbers 1, 8 and 9. Next para, heard learned counsel for the parties. Since query number 8 and 9, as rightly pointed out by learned counsel for the respondents, pertain to virtually the same piece of property, it would suffice if the petitioner applies for certified copies of extracts of the records and/or copy of the order of vesting. With regard to query 1, the same is also pertaining to a copy of an order, a certified copy of which can very well be issued at on the application of the petitioner. Next para. Accordingly, so should I dispose of both the writ petitions? Accordingly, WPA 1848 of 2023 and WPA 1850 of 2023 are disposed of by granting liberty to the petitioner to apply for the relevant extracts of the records as well as the relevant copy of the order of vesting pertaining to query numbers 8 and 9 of the petitioner, which relate to the 0.52 acres of land at RS and LR dag number 602, JL number 320, Mouza Shasinda, district Paschim Medinipur, as well as to apply for certified copy of the order as per query number 1 of the petitioner, which also pertains to the same property. Next para. In the event such copies are applied for in due course by the petitioner and subject to the compliance of formalities in that regard by the petitioner, the respondent authorities shall issue such certified copies to the petitioner at the earliest, preferably within 6 weeks from the date of such application being made by the petitioner. The reports filed today be kept on record. nor rest to cause certain settlement.
One line, if my applications are rejected, they have to give reasons.
They reject the point.
It will be rejected. My lord, kindly, one line, my lord.
Certified copy application, they won't give reasons.
Already
I can
rejected.
put it in my order. If certified copy application is rejected, they won't give reasons. You will file a contempt application where they'll give the reasons. I can
Kindly
put that
gives
in.
me one line. It will, again I
Certified
have to
copy
come back.
reasons.
My lord, thrice I've tried. Thrice.
Today I'm dealing with madness from the morning. I've been.
Item 6.
May it please your lordship, I'm appearing for statement.
But I am for the petitioner.
Yes.
Milord. In this matter, Milord, the dispute was, Milord, between two private parties, Milord, initial. And arbitration, there is an Milord development agreement. There contains an arbitration clause, Milord. And on the basis of, there was a dispute between, Milord, the landlord and the developer, and arbitration proceeding was commenced. In the arbitration proceedings, Milord, there was a direction from the learned arbitrator that the development agreement does not, Milord, sufficiently stamped, and accordingly it has to be impounded, Milord. That was done at the instance of, Milord, an objection raised by the respondent. The arbitrator, Milord, passed an order, Milord, for impounding, and it was sent to, Milord. May I just indicate the facts before I take your lordship?
Yes.
It was impounded, and it was, Milord, sent to, Milord, the collector for assessment. Initially, Milord, the collector had assessed a sum of rupees 19 lakhs and odd, Milord. We have challenged this order before this court, and before this court has remanded the matter for fresh consideration. Again, Milord, they have calculated it upon hearing an opportunity of hearing, and Milord, now they have calculated, Milord, 6 lakhs and 20,000 rupees, Milord, 30,000 rupees. Initially, when we moved this writ petition, Milord, we have made an prayer before this honorable court that we shall deposit the amount without prejudice before the registrar, and it was deposited, and he should, Milord, give the certificate so that the arbitration proceeding can commence. Now, Milord, today the arbitration proceeding has been commenced, and there is an award in my favor. Milord, today my challenge is only to that extent whether, Milord, the collector was justified, Milord, in assessing, Milord, 6 lakhs or not. He has proceeded on the basis of, Milord, as if it was an agreement for sale. Whereas, Milord, the document itself, though, Milord, the document initially says, Milord, the nomenclature agreement for sales, the contents is entirely different, and it's for, Milord, development agreement. May I just first take your lordship to, Milord, the document that is at page 33.
42. Stamp Act.
Of the writ petition.
Stamp Act. Stamp Act.
Milord.
33, yes.
Yes, Milord. It starts from page 32. My lord, you will see that it is initially written as agreement for sale.
32, I'm sorry, I'm on a wrong document. It's also annexed there. Yes, agreement for sale.
Yes, it is stated agreement for sale,
right?
But the continuation, yes, Milord. Your lordship will find, Milord, if you're now the lordship, then take, Milord.
You are the developer or the?
I am the developer, Milord.
Acha, you are which party here?
Milord, I am, Milord, Progressive Uddog, Milord.
Right.
And its parties.
Yes, yes.
This agreement, Milord, is made on Sudhanath Mukherjee and Shashwati Mitra, owners, vendor, and, Milord, Progressive Uddog developers, Milord. First,
right,
page 33. Then, Milord, the details of the property given, and further, my lord, you will see, Milord, at page 35, before, Milord, the definition clause, the intention is clear, Milord, and whereas the landowners having thus been approached by the developers to develop the said premises on the terms and condition hereinafter content, Milord, then, Milord, the clauses.
Yes, please continue.
Yes, Milord. Then, Milord, the definition clause starts, Milord. My lord, you'll see, Milord, at page 36, the definition of new building also given at 1D, Milord. Page 37, Milord, one owner shares has been demarcated. That will continue till, Milord, 38. And, Milord, page 39 is developer shares also indicated, Milord. And, Milord, the rights and obligations are at page 40 and, Milord, 44. For page 40 is, Milord, the owner's rights and representation, and 44 is, Milord, the developer obligation. So, Milord, my humble submission, the documents, Milord, says a total reading of the document that it was a development agreement. Now, Milord, in the order is, this was, Milord, directed, there was an arbitration clause, and this was directed to be, Milord, impounded. The order is of the arbitrator is, Milord, at page 72, Milord.
Is that German?
No, Milord. Just for your lordship's then, Milord, on the pursuant to that, Milord, an assessment was given that the first assessment.
So we have to constitute the clauses of the agreement for
Milord?
the present.
Yes, Milord. Milord, I shall, your lordship will take your lordship to the directly, Milord, the under challenge. The initial was set aside. So therefore, Milord, the subsequent assessment will be under challenge.
Right.
My lord, you'll see, my lord, the order impugned at page 99.
Yes.
Assessment of deficits, it is below to
Got it.
given,
Yes.
yes, my lord. Given to the my lord, the advocate, assessment of deficit stamp duty against FMET case number, that is our case number. With reference to the above valuation, schedule property has been assessed under section 40 of the Indian stamp by collector, North Chobbish Pargana, details as follows. Valuation of property as on 2006 is rupees 52,75,000. Given stamp duty assessed 4,22,000. Stamp duty already paid 100. Penalty 2,11,000 and deficit stamp duty to be paid, my lord, 6,32,000, my lord. Before, my lord, we given it to that, we had also obtained a query from, my lord, the computer generated. There it found, my lord, that at page 57, it came to 40,000 rupees. Page 78 of the, my lord, the writ petition. It was generated by us from the, for the convenience of the authority. By my lord, it was putting, my lord, as development agreement. My lord, you'll see, my lord, the second column, sale agreement or development agreement for construction agreement.
This is immaterial because this is your unilateral. Mr. Chatterjee, you want to say something?
My lord, I am being led by.
You are led by Mr. Chatterjee. I'm sorry. Yes.
Now, my lord, here,
Yes.
the agreement, whatever it may be, the nomenclature, agreement for sale, because heading is agreement for sale, but actually it is a development agreement. It is executed in 2006. There is no dispute about it. So, my lord, this stamp required to be paid, whatever the law stands on that date, not later on, because the execution has been done in 2006. If I accept that on a less stamp, on a not perfectly stamped. Now, my lord, accordingly, the learned arbitrator sent the matter for impounding. The collector, your lordship, kindly take the writ petition. The collector, first order passed by the collector, after the order, first order, page 81. Page 81.
Yes.
19,56,680.
That was set aside and
I don't know what for reasons. Now,
anyway, that was set aside.
we made representation.
Right.
And after the representation, and in the representation, we have given the query we have taken from the collector's department itself. Then what is the actual stamp as on that date? This is the page 85. Your lordship, kindly see. This is 40,000 in the third from the top. This is third 40,020. This is the amount of tax we have, stamp we have to pay.
That has been placed by your lord.
That has been done by the collector's department. Now, your lordship, kindly see, order has been passed in page 88 that reassessment will be done.
Right.
Then reassessment. Reassessment has been done. Prior to that, the hearing has been taken place. This is the notice, page 91, that they will take hearing as per the order of my Lord Justice Moushami Bhattacharya. On 7/2/2023, hearing will be taken place. Then the hearing, in the hearing, we have submitted a written notes of argument. Now, the hearing order of the collector, your lordship, kindly come to order to page 99.
Yes.
Yes. Your lordship, kindly see. May I place this? With reference to the above valuation of scheduled property has been assessed under section 40 of Indian Stamp Act 1899 by the collector, North Chobbish Parganas, details as follows. Valuation of the property as on 2006, 52,72,75,000. Stamp duty assessed 4,22,000. Stamp duty already paid rupees 100. Penalty 2,11,000. Deficit stamp fee 6,32,000, as if it is a sale. It is not a sale. Now, my lord, the actual statute stand as on 2006. Your Lordship, kindly see, this is the stat. We have already given a chart, the statute. It starts from page 96.
Right.
Page 96. Your Lordship, kindly come to page 97, serial number 5. Agreement or memorandum of agreement.
Yes.
Now, your Lordship, kindly see, this is.
They have charged according to D. They have charged according to 5D.
5D.
That is their valuation.
Lease come sale of immobile. It is not lease, not sale, nothing.
Sale or lease come sale?
Yes.
Yes.
We are coming under E. E relating to the matters not otherwise provided for.
The residuary one clause. Yes. Residuary clause.
Residuary clause.
Other agreements.
Rupees 10. We have paid rupees 100.
So you want a refund of rupees 19?
I want refund of 6 lakh for
Oh, yes. You have
that I
deposited
have
that.
paid as per the court's order.
Very good.
Because I have to complete the arbitration proceedings within 3 months. That is the dictum of the court.
Mr. Chatterjee, what is your worst clause in the agreement?
Now, my lord,
Show me that. Which is the worst clause against you? Because they will be arguing on that. You are a senior advocate. You have to show me what.
no worst clause.
No, nothing regarding transfer.
No, transfer, one clause is there. Your Lordship, kindly see. That transfer is that after the construction, your Lordship, kindly come to. My portion is this. Yes. Your Lordship, kindly come to page 49. Sorry, page 38. Yes. Your Lordship, kindly come to the 5 lines from the top. The owners oblique first party shall be entitled to have 30% of share of FAR out of total FAR to which to be sanctioned building plan together with amount of rupees 50,000 only. The advance money which will be adjusted or deducted from the owner's share of 30% of the proposed new building. And it is stated that both parties have settled that 30% of the owner's share will be exchanged price at rupees 800 per square feet, and such sale consideration of Schedule A property and the amount will be paid in cash or check to the above named owner solely on account of Shuddhanath Mukherjee, herein first party by the developers and others part from time to time. At the time of execution of the agreement, that is separate. That is the if at all the worst clause is this. No transfer has been effected till date. Now, this agreement, development agreement has to be registered because there is a dispute in this development agreement. It was cancelled by the owner. The power of attorney was cancelled by the owner. Now, on the basis of this clause, we gone for the arbitration. This is the clause.
Let us come to page 41 once. That's a continuation of the developer's right at clause 7. That is 7B. Let us see that once, Mr. Chatterjee.
The 7B.
7B is it is agreed by and between the parties. That is developer's share.
It is agreed by and between the parties here too that in consideration of the construction of a multi-story building at the said premises, more fully described in the schedule hereunder, the owners of the first part hereby agree and undertake to convey transfer when the transfer will be made.
Exactly. That is what I'm saying.
When the transfer,
it's a future transfer.
Then I shall pay the requisite stamp.
So according to you, this means that after the development is done, they have to independently execute sale deed or transfer deed.
Naturally, because the owner is to sign the transfer in my favor.
Yes, some development agreements incorporate that sale.
No, here nothing. Here sometimes, I may say so that when I have purchased the flat, I have asked my developer, you are executing the deed. You are not the owner. How can you execute? I have the power of attorney. I have everything.
Exactly.
He showed everything.
Right.
And that after that, it has been registered.
Right.
Now
it means for the owners to execute the deeds of conveyance in favor of the flat owners.
Yes.
Thereby meaning that they retain the ownership.
Ownership.
That can be yours.
Yes. And my lord, even assuming for my worst case. If they say that this transfer, that this the deed has been, the development agreement has been executed or signed between the parties in 2006, but actually stamp is being paid in 2021 or 22. So whatever statute stands on that date, you are to pay on the basis of that statute.
On that date also, if it was a conveyance, you had to pay.
Yes. Now, even if I accept that my worst case, that yes, that on the date you are paying this because you did not pay, you have complete, because unless this dispute crops up, you did not come to the forum, you clearly waive this and the government will not get this.
No, then, yes, then 2006 rates have to be applied.
It's my submission.
Yes.
They may say, no, 2012 rate may be applied because now it is being applied.
It was impounded when?
It was impounded in 2021 or 22. 22. Because dispute crops up in 2021. July 2021.
Why not the current rates? Because you did, before that you did not choose to have it registered or stamped.
But that is the actual stamp, rupees 100, more than. Rupees 10 was this stamp.
And what about clause 8, page 41 of the agreement?
It is agreed that developer shall be entitled to sell its allocated constructed area together with undivided property, impartible share of land of the said premises appertaining thereto on such terms and conditions as developer need impede and proper.
So you may sell, you may take earnest money
against
for your
the
portion.
agreement, 1 minute, agreement for sale in respect thereof, after the portions of new multi-story building to be constructed by them. It is made clear that the owner shall have no obligation or liability with regard to breach of any agreement by the developer. Now, this has to be read with earlier paragraph. Deed has to be executed by the owner. I being the developer, I shall identify this is the portion. I will bring the seller. I will take the money. But actually, the owner will put his signature. Now, your Lordship, kindly see the section 40 of the Stamp Act.
Yes.
Now, on section 40, subsection 1, when the collector impounds any instrument under section 3 or receives any instrument sent to him under section 38, subsection 2, not being any instrument chargeable with a duty not exceeding 10 paisa only, or a bill of exchange or promissory note, he shall adopt the following procedure. If he is in the opinion that such instrument is duly stamped or is not chargeable with duty, he shall certify by endorsement thereon that it is duly stamped and that is not so chargeable and it is not so chargeable as the case may be. If he is of the opinion that such instrument is chargeable with duty and it is not duly stamped, he shall require the payment of the proper duty or the amount required to make up the same, together with a penalty of 5 rupees, or if he thinks fit, an amount of not exceeding 10 times the amount of proper duty or of the deficient portion thereof, which such amount exceeds or falls short of 5 rupees, provided that when such instrument has been impounded only because it has been written in contravention of section 13 or section 14, the collector may, if thinks fit, remit the whole penalty prescribed in this section. So, my lord, this is the discretion or this is the decision of the collector, whether it is properly stamped or not. Now, my lord, the collector, while taking the decision, instead of taking records of 2006 statute, 2006 rates, he has taken the rates of 2012. Now, even if he takes the 2012 rates, it is an agreement. No transfer has yet been taken place.
2012 was the date when it was sent for impoundment.
No,
2012 you are saying? Why the 2012?
the collector has taken the records of 2012 rates.
Why 2012?
Because the impounding order, according to the collector, has been made in 2021, 2022.
Why 2012 you are saying?
No. 2012.
2022 or 12?
No. 2012, the rates have been made. Thereafter, no amendment. To the original rate in 2006. Then it was amended in 2012.
Amendment of the deed.
Yes. No, not deed. Amendment of the statute.
But that's why, yes.
Amendment of the statute. And it has been come effect from 2012 itself, not from 2006.
Yes.
No
That
retrospective
cannot be a
effect.
basis.
No. My submission is the
Yes.
collector
Yes.
has misdirected itself by misconstruing the two rates. That is 2006 and 2012. While taking into consideration the document, he has taken the decision on 2012, not on 2006. He ought to have taken the decision in 2006, not of 2012. And accordingly, he has done this mistake. If he is confined his decision to 2006 only, then 10 rupees. Now he has gone to 2012. And even assuming that his decision to 2012 is right, in that event also, your lordship kindly see, this is the rate. Your lordship kindly see, 2012 book is before your lordship. Your lordship kindly see, clause 5B. Wait, 99, na? Now your lordship kindly see, page 99, he has indicated the valuation. 52,75,000. That of 2006. So he has to taken the rate of 2006 and that of the agreement, not anything else. And if he is taken in 2012, then your lordship kindly see where the 2012 will go. 2 II, 5 II, where the market value of the property exceeds rupees 30 lakhs but does not exceed rupees 60 lakhs, rupees 7,000. And 100% of 7,000 is 70,000. So altogether 77,000, not 6,32,000. Because if your lordship have a glance to the agreement itself in all the paragraphs, and your lordship also kindly see that the power of attorney, which was executed, which was cancelled between the by the landowner. This is the cancellation of power of attorney, revocation.
But Mr. Chatterjee, probably we cannot go to extraneous documents.
It's not required. Not required.
Right.
But the power of attorney was granted to me for only construction, not anything else. And that order I have not brought before lordship. That is the finding of the learned arbitrator, because it was the issue before the learned arbitrator that this document, power of attorney, has been issued not for construction but for doing miscellaneous work. That has been decided by the learned arbitrator. So, that issue I have not placed, I have not brought before lordship, because that is not relevant issue. Here the issue is whether this is a document of agreement or not, whether it is a sale document or it is an agreement. Development agreement. If it is development agreement and it is a development agreement of 2006, then actual stamp is rupees 10, not beyond that. I have paid rupees 100. So it is properly stamped. 6,32,000 and
On
odd.
a conveyance in 2006, what was the rate?
8%, my lord.
Must have been less.
8%, my lord.
8%.
So if it is 8% also, then 52 lakhs, 8%, not 6 lakhs.
4,32,000 and pin.
That's 4 lakh, not 8, not 6 lakhs. Whatever it may be. And that is a conveyance for sale, not for anything else.
Yes, what is your answer?
My lord, at page number, rightly fallen from your lordship, my humble submission is I come under 5D, my lord, in 2006 at page number 97, my lord. Read with my lord, the page number 98, which is the explanation clause, my lord. My lord, the expression agreement, if I may read, my lord, the expression agreement or memorandum of an agreement, if relating to a sale, shall include an agreement to sell or any memorandum or acknowledgement in relation to transfer or delivery of possession of immovable property with an intent to transfer right, title, interest in or title to such property at any future date, my lord. My lord, at that point of time in 2006, my lord, my humble submission is 5F, which has been inserted in 2012 notification by way of 2012 notification.
Why
My
should
lord.
the 2006 rates not be taken?
My lord,
Why should the
my lord, 2006 rate is taken, my lord. In fact, 2012, in 2012, my lord, 5F has been inserted and the memorandum of development agreement and new exemption was given. But before that, there was no clause as to that, and I have to fit somewhere between 5A to E.
Yes.
And my lord, I come under 5D because rightly fallen from your lordship, my lord, at page number 41, my lord, that was actually my submission read with 38, my lord. My lord, 1, 2, 3, fourth line onwards, my lord, from at 41, page 41.
Convey transfer, etc.
My lord, and that goes on saying that the owner shall execute, my lord, at the very last the owner shall execute and register deed of conveyance, my lord. And in the second paragraph, it is further noted that if any area out of sanction plan to be made by the developer, then the first party owner shall have no claim, right, interest, and or demand over the same or any part thereof, my lord. And my lord, at page 39, my lord, the developer share, in the developer share, my lord, it was mentioned that the balance portion of the multi-storied building shall mean and include 70% share of the constructed area, which shall belong to the developer, my lord. My lord, the intention of my humble submission is the intention was to transfer their, and this is relating to sell, my lord, in the at any future date, and I come under the explanation in 2006, my lord. And accordingly, my lord, the rate, the market value was 8 lakhs per katta, my lord, and that actually came to 2 lakhs, and 300 square feet tin shed was there, what was 75,000. So the total valuation of the property came to 52 lakhs 75,000, and 8% of that came to 4 lakh 22,000 at as per 2006, my lord. A penalty was charged, my lord, which was 2 lakh 11,000. A penalty was charged due to the deficit stamp duty, my lord. My lord, the thing is, this is obviously government revenue, my lord. If that was waived, then the government revenue will be.
Yes, madam. Thank you. Yes, Mr. Chatterjee. Yes.
Now, your lordship, kindly see, my learned friend has made submission on the explanation. Your lordship, kindly see the explanation. Just look at the internet.
Yes, page 98.
Page 98.
Here I can look into it.
Now, my lord, the expression agreement or memorandum of an agreement,
yes,
if relating to a sale, all include or it's related. Shall all include an agreement to sell or any memorandum or acknowledgement in relation to transfer or delivery of possession of immovable property with an intent to transfer right, interest in or title to such property at any future date. Now, my lord, this, your lordship, can come to turn page 97.
Yes.
Now, my lord, come to 97, clause number 5, agreement or memorandum of any agreement. What does it stand? Agreement or memorandum of agreement? That explanation has been given.
That pertains to D. Because D says if relating to a sale.
Sale.
And explanation says the expression agreement or memorandum if relating to a sale.
Relating to sale
Such and
or lease come sale.
explanation pertains to D.
Now,
You say it does not come with
sale,
the there.
sale means a person will transfer his right to another person. Here, in this agreement, transfer of right has not been done. Transfer of right will be done when the construction will be made, then the owner will execute the deed and the developer will take the money. This is something else. This is not the thing that the revenue of the government, nobody wants to, at least the developer who have made the development agreement wants to make the construction. He is paying government revenue in all respect. Purchasing, in the land revenue, everywhere he is paying. Now, regarding the stamp of a particular document, when it will actually, the transfer will effected place. Now, in order to avoid all these things, now the developer in 2000, after 2015 or 16, they are not making this type of agreement. They are straightway asking the owner to transfer the property with a sale deed, so that they can construct as it is with payment of the entire stamp duty and the construction is made.
Right.
That is, it is in 2006, this was, and your lordship can see here, this agreement, if he has put me there in relation to a sale. For indicating the sale, from this document, it has to be established that this is a sale deed. This is a sale deed. Either it is an agreement for sale or it is a sale deed. So, it is neither an agreement for sale nor it is an agreement for construction. Your lordship, can you see? Your lordship, can you see? 1 minute. Now, the sale takes place when the delivery of the possession takes place. Unless the possession is delivered, no sale is complete. Now, here, nowhere it has been indicated that the possession of the land is transferred in favor of the developer. Your lordship,
with any 41.
Your lordship, can you see page 41, what my learned friend has shown?
The owner shall execute, and no part the owner shall have no claim or right.
That's right.
Please take a seat. Yes.
That's right. So, till the execution is done,
yes,
ownership does not transfer. This is the transfer of property. Execution has to be done by the owner, not by anybody else. If I transfer the Victoria Memorial, that will be a void and voidable transfer. That cannot be a transfer because I am not the owner. I cannot transfer the High Court building also. So this is not the way. I can transfer my property. What is there with me in my possession? Now, here there is no ambiguity. In categorical term, owner said, I shall transfer. You may construct. This is your portion. You may identify your portion. You may take the money, but actual transfer is to be done by me on payment. Your lordship, can you see? What is the sentence? Your lordship, kindly come to the middle portion of that. After 85 and 85A Kalicharan Ghosh Road, allocated to the developer, in favor of the developer and the total consideration amount for the purpose of valuation of the said premises described in the Schedule A hereunder at the settled price or consideration rupees 800 per square feet, only to be paid by the developer to be above named owner of the first party herein in respect of owner's allocation. And accordingly, the owner shall execute and register the deed of conveyance in respect of the flat owners, intending buyers, nominee of the developer, appertaining to be constructed area of the multi-story building allocated to the developer in favor of the developer. Now, your lordship can see from this clause, it is absolutely clear. Owner not only execute the deed in respect of the flat owner, which are owner's portion, also the in respect of the portion which are developer's portion. Both. So transfer will come effect when the owner will put his signature. Here, the cart has been put before the horse. Before I transfer, before the transfer has been effected, it has been treated as sale deed. Now, very well. If they treat this sale deed, let them enjoy the money. When actual sale will be done, this amount will be adjusted. No problem. Let your lordship kindly pass that order. When it will be transferred, then the amount will be adjusted, because agreement for sale, this is agreement for sale. Even if I accept, this valuation has been made and the payment has been made. Very well. But when this actual transfer will take place, then this will be done. Because now the actual transfer may be taken place within a month or two. Because in Bengali, there is a prejudice. In Bhadramas, they are not doing any transaction.
Yes.
Because 8% penalty, everything has been taken.
The present challenge has been preferred against an assessment of stamp duty by the respondent state. Respondent authorities. Next para. In the present case, the dispute pertains to an agreement which the petitioner seeks to represent as petitioners seek to represent as a developer's agreement, although, erroneously, the nomenclature within double inverted agreement for sale, double inverted clause, was used. Next para, learned senior counsel appearing for the petitioners places reliance on several clauses of the agreement to impress upon the court that the same is a mere agreement for development. Next para, in particular, learned senior counsel places reliance on clause 3 of the on the clause of the agreement which sets out the developer's share. The said clause enumerates that the balance portion of the multi-storied building shall mean and include the 70% share of the constructed area out of the total FAR of the proposed new building to be available. Clause 3 stipulates that the developer shall complete the construction of the new multi-storied building within a period of 5 years from the date of sanction of the plan. Clause 7 stipulates the rights of the developers, which includes the exclusive right of the developer to develop the said premises by way of construction of a multi-storied building, whereas clause 7 within bracket small b provides that the owners agree and undertake to convey, transfer, assign and assure undivided proportionate impartible part or share in land, as well as that the owners shall execute and register deed of conveyance in respect of the flat owners intending buyer, nominee of the developer appertaining to the constructed area of the multi-storied building allocated to the developer and in favor of the developer. Full stop. As such, comma, it is clear from the agreement, comma, it is argued, comma, that the same contemplates future execution of transfer deed by the owners, comma, thereby showing that the ownership was retained by the owners themselves and not transferred to the developers. Full stop. Hence, comma, the agreement in question being merely a developer's agreement, comma, it is argued that item 5 within bracket small e of schedule capital IA of the Stamp Act ought to be operative, comma, which relates to matters not otherwise provided for in the other clauses of the said item. Full stop. Next para. Learned Senior Counsel contends further that the stamp duty was assessed by the collector apparently at the rates prevailing in the year 2012, comma, after the amendments came into force with regard to the stamp duties, comma, whereas the calculation ought to have been done at the 2006 rates, comma, since admittedly the the agreement was executed in the year 2006. Full stop. Next para. Learned Senior Counsel further argues that in view of the petitioner having in view of a stamp of rupees 100 having already been paid in connection with the agreement, comma, the same exceeds the stipulated stamp duty of rupees 10, comma, which was, comma, at the relevant juncture, comma, the appropriate stamp duty to be paid in the event the agreement is deemed to be one under item 5 within bracket small e of schedule IA. Full stop. Next para. Learned Counsel for the respondent authorities places reliance also on the same clauses of the agreement. Full stop. It is argued that the said agreement falls within the ambit of item 5 within bracket small d, which speaks about agreement relating to a sale. Full stop. Next para. The explanation thereto provides that the expression agreement or memorandum of an agreement, comma, if relating to a sale, comma, shall include an agreement to sell or any memorandum or acknowledgement in relation to transfer or delivery of possession of immovable property with an intent to transfer right, comma, interest in, comma, or title to, comma, such property at any future date. Full stop. Next para. It is further argued by placing reliance on the assessment impugned herein, comma, that the valuation of the property and the stamp duty assessed was in terms of the 2006 rates, comma, which is which is 8%
No,
of
that
the
is not 8%. In 2006, it is 7%. This is the rate.
no, he argued 8%.
He argued 8%.
I am recording his argument. That is about that is 8% of the rates. Full stop. Next para. Mr. Chatterjee, if it's 7%, what does it come to?
Your Lordship can gives.
Yes, Junior Mr. Chatterjee, please also check. Next para. It is argued that the agreement in question undoubtedly is an agreement for transfer, comma, although containing provisions as to development as well. Full stop. Next para. Thus, comma, it is contended that the assessment of the stamp duty was justified. Full stop. Next para. That 7%, 8%, please clarify. Otherwise, I will show something to indicate.
My lord, it is 3,69,250. 250.
3,60,000.
9,250.
Very good. And this is 8%. The calculation has been made in at the rate of 8%.
At the rate of 8%, my lord.
Next
And the
para.
penalty? Penalty to কিছু বলেনি?
Penalty আছে।
For adjudicating the proper stamp duty, comma, the tenor of the agreement should be read as a whole, comma, not confining the inquiry to the mere nomenclature which is in any event within double inverted agreement for sale, double inverted clause. Full stop. Clause 7 of the agreement speaks about the developer's rights, comma, which speak about the exclusive right to develop the premises. Full stop. However, comma, clause 7 within bracket small b also provides that the owners agree and undertake to convey, comma, transfer, comma, assign and assure undivided proportionate impartible part or share in land of the said premises appertaining to the constructed area of the building to sell the FAR of the sanction plan of first part of 30% by the joint venture. Full stop. Next para. In the same clause, comma, the owners also undertake that they shall execute and register deeds of conveyance in respect of the flat owners stroke intending buyer stroke nominee of the developer appertaining to the constructed area allocated to the developer and in favor of the developer. First of such clause indicates that the owners did not part with their right, title and interest in the property in favor of the developer by the said agreement. Full stop. Next para. However, comma, clause 8 of the agreement stipulates that the developer shall be entitled to sell its allocated constructed area together with undivided proportionate impartible share in the land of the properties appertaining thereto on such terms and conditions as the developer may deem fit and proper, and may also take earnest money against the agreement for sale in respect thereof after their portions of the new multi-storied building to be constructed are given to them. It is made, full stop there, it is made clear in the agreement that the owners shall have no obligation and liability with regard to breach of any agreement by the developer. Full stop. Next para. The said provision indicates that the developer has an exclusive right to enter into agreement for transfer regarding the regarding their portion of the property as well as to transfer and allocate such portions in favor of third parties. Full stop. The same clause, that is clause 8, also stipulates that the other part developers shall have exclusive right to construct the proposed building as per sanction plan at their own cost and expenses with full liberty to construct the building whatsoever subject to municipal law and sanction. Full stop. Next para. Clause 17 of the agreement provides for the developer's further right, comma, which includes that the developer shall punctually and regularly pay rates and taxes in respect of their respective allocated areas to the concerned authorities and shall keep each other indemnified against all claims, comma, actions, etc. Full stop. Clause 20, comma, relating to miscellaneous clause, comma, further provides that the owners and the developer have entered into the agreement purely as a contract on the basis of the joint venture agreement, and any other circumstances shall not be treated as partnership and or association of persons between the owners and the developer. Full stop. Next para. Immediately after possession of the premises be given by the owners, comma, it is provided, comma, the developers shall be entitled to start construction of the said building in accordance with the sanctioned building plan. Full stop. Next para. A careful perusal of the said agreement indicates that although the development and construction on the property is one of the primary considerations between the parties thereto, comma, the same also contains clauses whereby the mode of sale to third parties has also been contemplated. Full stop. For example, clause 8 provides that the developer shall be entitled to sell its allocated constructed area together with undivided proportionate impartible share in the land of the said premises appertaining thereto on such terms and conditions as the developer may deem fit and proper, and also take earnest money against agreement for sale in respect thereof after their portions of the new multi-storied building are constructed. Full stop. Next para. The developers also have exclusive right as per the agreement to construct the proposed building with full liberty to construct the same subject to municipal law and sanction at their own cost and expenses. Full stop. Next para. Thus, there are several components to the agreement, which include ingredients of development stroke construction as well as sale by the developer in favor of third parties, subject, of course, to consensus on the part of the owner. Full stop. Next para. As such, the respondent authorities were justified in classifying the agreement in question under item 5 within bracket small d, which pertains to agreements or memorandum of an agreement relating to a sale. Full stop. Next para. The explanation thereto also pertains to agreements for sale and include agreements to sale in relation to transfer or delivery of possession of immovable property with an intent to transfer right, interest in, or title to such property at any future date. Full stop. In view of the above discussions, the explanation fits in the agreement in toto and the said proposition cannot be deviated from. Full stop. However, insofar as the petitioner's argument as to the rates prevalent in 2006 is concerned, the same definitely has force behind it. Full stop. Even the valuation of the property has been made by the registering by the collector on the premise of the valuation as on 2006, which was the year when the agreement was entered into. Full stop. Next para. However, the assessment of stamp duty, as rightly pointed out by learned senior counsel for the petitioners, has been made at the rates as prevalent after amendment in 2012, and not as per the 2006 rates. Full stop. The rate prevalent in the year 2006, as pointed out by learned counsel for both sides, was 7%. Full stop. Hence, it was incumbent upon the collector to calculate the stamp duty at the rate of 7% on the valuation of the property as evaluated by the collector himself. Full stop. Keeping in view the above observations, WPA 4744 of 2023 is disposed of by directing the respondent stroke collector to reassess the stamp duty at the rate as prevalent in the year 2006, taking the agreement in question to be classified under item 5 within bracket small d, that is an agreement for sale, under Schedule IA of the Stamp Act within bracket as amended in West Bengal, bracket closed. For such assessment, the penalty, thereupon, shall also be calculated accordingly, taking the stamp duty to be assessed at the rate as prevalent in the year 2006. Full stop. Such exercise shall be concluded by the collector within a fortnight from date, and the collector shall intimate to the petitioners in writing the re-evaluated stamp duty and penalty thereon, as well as the deficit stamp duty to be paid by the petitioners. Full stop. Upon such intimation being given to the petitioner, the petitioners would be at liberty to applicable, you have already paid
I have already
at
paid
the higher
and
rate.
at the higher rate that has been deposited before the registered High Court.
But under the law, you have to claim refund before the collector.
No, the assessment, whatever he will
Very well, very
he
well.
will
It will
make,
be the petition, upon such intimation being made, the petitioners will be at liberty to apply for a refund of the excess amount paid by the petitioners in terms of the impugned assessment dated February 2023, comma, by deducting the fresh assessment from the deficit stamp duty already paid in terms of the input assessment by the petitioners. Full stop. Upon such application being made, comma, the registrar appellate side of this court shall refund the excess amount to the petitioners at the earliest thereafter, comma, preferably within a month from the application being made by the petitioners. No rest to cause settlement.
and whether it has been invested to a short-term fixed deposit.
Last Mr. Chatterjee, that has been invested subject to final orders passed by the arbitrator.
No, by the court in the writ petition.
Or the writ petition, that writ petition is pending.
No, this is the writ
Or
petition.
this writ petition. Then the rest of the amount has to be given to the state. Then the portion, the part which has to be refunded to you, apart from that, the rest has to be given back to the authorities. Then the state authorities.
Yes, my lord. I'm not on that. I say that the investment which has been made on this amount,
Yes.
that interest accrued,
But then the
that
interest
should be given to me.
Then the interest has to be calculated on that portion. It has to be apportioned on the amount being refunded to you. You are not entitled to interest on the entire amount.
No.
একটা line add করো। Apart from seeking a refund of the difference between the amount already paid by the petitioners and the amount reassessed now pursuant to this order, comma, the petitioners will also be at liberty to seek a refund from the registrar of the amount of interest apportioned according to the proportion of the amount refunded to the petitioners out of the total amount deposited by the petitioner. Full stop. If such an application is made, comma, the same shall be processed by the registrar and the
Or my lord, your lordship also may direct, as I have already prayed, that if it is treated as the sale deed.
No, that will create complications. I cannot do that from at this stage. You have section 4 for that. You can pray for that adjustment the entire. কি বললাম কোনখানটা ছাড়লাম just সেটা অনুযায়ী the registrar and the due amount of apportioned interest which has accrued on the deposit made by the registrar, comma, commensurate with the amount to be refunded to the petitioners shall also be paid. Full stop. Insofar as the rest of the amount and the interest thereon is concerned, comma, on an appropriate application made by the respondent authorities, comma, the Registrar General shall also refund the balance amount along with the interest accrued thereon to the respondent authorities. Full stop. It is, comma, however, comma, made clear that while refunding the amounts respectively to the petitioners and the state and the respondent authorities, comma, the Registrar General shall be at liberty to deduct the necessary expenses which has been incurred for opening the said accounts and any ancillary expenses, if any, comma, by apportioning that same equally between the petitioner as well as the respondent authorities. The costs will be deducted equally, apportioning between you and them. Interest apportioned according to the refund made to you, that ratio will be.
Only one thing, your lordship kindly grant me liberty, if comments to your lordship, that if I made any application to the register for this adjustment, when the final sale will be taken place?
No, that I cannot do now, Mr.
No, no,
Chatterjee.
no.
That is a premature.
No, not premature. I'm saying that will not prevent me from
Nothing will prevent you.
as I have made this
I'll
application.
not make that rider, put that rider in my order. That is beyond the scope of the petition, sir. No rest to question. Thank you.
Much obliged. With your kind leave, my lord. Item 7.
Well, it is, I represent the state, my lord. It is that matter of where the boy was electrocuted, my lord.
My lord, I'm for the
There was-
petition. I'm praying for notice.
No time.
Kindly, my lord.
No. Upgraded matters, no time.
On the last occasion, I had filed a report.
Kindly.
No, I said.
So
Yes,
my lord passed
you had
over
filed a
for
report.
some time.
You had filed a report.
On the last occasion, I had filed a report for after it was reheard. My
What
lord,
does it say?
my lord, the report suggests that, my lord, there was an electrocution. And my lord, but the place, time, and the cause of electrocution could not have been identified from the hearing that was given to all the authorities.
I'll adjourn the matter. It will appear in the next monthly list. But an adjournment is sought when the matter is called on for hearing by the petitioner. Full stop. Since other matters cannot be taken up due to the list being blocked by upgraded matters, comma, let the matter stand adjourned till the next monthly list when it will be listed in due course. Next matter.
Grateful.
Item 8.
Yes. Who is for the petitioner?
I'm the petitioner, my lord. I'm paying for the short password, my lord, Mr.
Goes to the next monthly list then. An adjournment is sought by the petitioners. Since this is an upgraded matter, comma, such adjournment is refused, full stop. However, comma, upon such. Yes, Mr. Bhattacharya, what is the matter? What is your response to the reports?
Lordship will kindly, I am drawing your lordship's attention to the affidavit filed by the Medical College Hospital.
Yes.
As also Sagar Datta. Sagar Datta say that patient was never brought to me.
Right.
And Medical College say that he was brought and he was treated thoroughly. And details have been given in the affidavit at page 5, page 2.
Right.
Page 2, the opposition. May I place the opposition?
Yes.
The report filed.
Yes.
Well, as per, I am reading from paragraph 5.
Right.
As per record, the patient Shubhajit Chatterjee, 18 years, male, came at jail emergency on 10th of July 2020 at 3:39 p.m. with a case of fever, cough, shortness of breath. PR 60, so and so, my medical terms, my lord, kindly excuse me. I COVID positive and all patient registration, so and so, 3:39.
Yes.
Comorbidity is there. The patient admitted in CRP at 5:30 p.m. on 3:50 p.m. on 10/7/2020 and white so and so registration number, the 10th of July 2020 at 3:43 p.m. At around 4:10 p.m. on 10/7/20, that patient was unconscious and GL condition very poor, not arousable, PR 130, so and so, my lord, oxygen 10 LTR, NPM, along with the other medical management. Photocopy of the record. At around 6 p.m. on 10/7/2020, this patient already received 11 fluid and holus insulin with oxygen via prawn, 92% on oxygen so and so minimum, but this patient was still unconscious. At around 7 p.m. on 10/7/2020, this patient shifted in SSB 7th floor male ward, bed number 752. At around 7:30 p.m. on 10/7/2020, vital of this patient as follows. PR so and so, so and so, so and so, my lord. It had been given injection INJ regular insulin at the rate 10 IU stat bolus plus hour infusion and IVS NS monitored CBG K plus PO423 urine along with continuous oxygen support. At around 7:35 p.m. on 10/7/2020, this patient was gasping for breath, non-responsive and disoriented. At about 8 p.m. on 10/7/2020, sent referral letter for CCU bed for the patient for ABG monitoring with ABG blood sample of this patient. At about 8:30 p.m. on 10/7/2020, the vital of this patient were as follows. That at around 9 p.m. on 10/7, the ABG report of the patient pH 66.86, HC03 is equal to 6.8 mm, 01 L, Na plus 135.7 mmol, LK 321 ml, L patient still drowsy and non-oriented. Reported no bed vacant in CCU at that time. That at around 9:15 p.m. on 10/7/2020, patient was non-responsive even to maximal stimulation. So and so attempted inject adrenaline 1 AMP 1/4 stat and inject atropine AMP 1 VAS. CRP continued for 10 minutes. At about 9:45 p.m. on 10/7/20, SP02 PRBP could not be measured and people fixed this patient. The patient declared dead at 9:45 p.m. on 10/7/2020 with a cause of death being metallobic acidosis in a CO DKA in type 1 DM patient having COVID-19 illness. This affidavit may kindly be treated. Now let us see the affidavit of Khagor Dotto for once.
We'll continue after the recess.
As you know.
Before your lordship.
Yes.
Now you are placing before your lordship the affidavit file in respect of Sagar Datta.
Right.
My lord has got it.
Yes, Mr. Bhattacharya. Yes.
My lord, the affidavit affirmed by Assistant Superintendent College of Medicine, Sagar Datta Hospital.
Yes.
Kindly come, my lord, to paragraph 5. As per records of the patient available in record section of the College of the Medicine and Sagar Datta Hospital, Kamarhati, in connection with the period of instant writ petition, no such patient was found on 9/7/2020. So the story that I have, Sagar Datta approached and Sagar Datta refused to give admission, my lord, that is something, my lord, to be considered by your lordship, because the government hospital, Sagar Datta and Medical College were the only hospitals taking the COVID patient at that material point of time, no other. My lord, 5:30 a.m., the patient was taken to at page 30-31 in the judgment. Kindly, my lord, look for once.
Yes.
Page 31 is the backdrop.
Right.
The patient, since the husband was having ESI facility, they approached the said hospital at about 5:30 a.m. in the morning. ESI hospital released him and asked that you should go to my nursing home. 5:30 a.m. to 10 o'clock, no explanation has been given how the patient was there. ESI hospital in their own, my lord, ambulance had sent the patient with all oxygen support is there inside the said ambulance. And the our nursing home Midland, my lord, had not bring the patient out of the said oxygen support. We have entered in the said ambulance and checked that. My lord, this is the treatment we have done.
Mr. Bhattacharya, we cannot rely on anything which is not on record. So keep it with you.
Only the medical.
This is a factual aspect of the matter. This is vital. I cannot.
OPD prescription of the hospital. We have just xeroxed one, something like that. Lordship may accept, may not accept, but Lordship.
No, I don't accept, Mr.
Leave it, leave it. So at 5:30 to 10 a.m.,
yes,
no explanation has been given. At 10 and 10 to 10:30,
yes,
the patient was attended by Sagar Datta, by our nursing home, and RMO was attended and detected COVID positive, and I had no bed, no ICU. I have given a chart, my lord, all beds and beds were lying full at page 16, annexure P16, page 82, or kindly look for once again.
yes.
All the beds, my lord, ICU, ITU, RCU, CCU, all were having the full patient capacity. So we said that we have no bed, kindly return it to the ESI hospital. ESI hospital is only a 10 minutes distance from Belghoria to Kamarhati. 10, maximum 15 minutes takes the time. And in those COVID days. But we returned it. 10:30 to 3:39, the report of affidavit of medical college that speak of that at 3:39 a.m. 3:39 p.m. in the afternoon, the patient was 3:39 p.m. at page 5, page 2, paragraph 5 of the affidavit of medical college. The patient did attend the said hospital. Patient came at the hospital. So patient's detail as to what he was doing from 10:30 to 3:39, so at 4 o'clock, is unexplained. The case that has been made out that Sagar Datta I approached. Mala Sagar Datta, if refuses to, my lord, to admit, a hospital does not, my lord, refuse to admit any patient without a referring prescription. That this is how refer it back. A government hospital, Sagar Datta. That is not how it is done. And from 10:30 to 3:39, 4 o'clock, nearly, these 5 hours, my lord, has not been explained what he was doing with the patient. Nowhere, my lord, the medical college said that he came before and we refused to admit him. And after at 4 o'clock, my lord, we are compelled to, because of the agitation made, as the story, my lord, repeated to before your lordship. That story, my lord, is absolutely not supported by any evidence. And had the commission, my lord, considered the statement of medical college and the Sagar Datta, the hospital, my lord, definitely, the commission should not have passed the impugned order. Page 76, lordship will kindly pay a look. I have said before your lordship that ESI hospital had sent them back in their own ambulance. Lordship will get it at page 76, the West Bengal Clinical Establishment Regulatory Commission affidavit on behalf of the complainant himself. Kindly come to, my lord, page 76, paragraph 4, page 77. ESI hospital arranged for their own ambulance for our son, and we reached the medical Midland Nursing Home at 10 a.m. So ambulance, a person having respiratory problem, the oxygen as is available in the ambulance was definitely given support to him, and accordingly, my lord, he was brought to our nursing. So the finding ultimately made, COVID positive report itself, my lord, has been supported by medical college also in their affidavit. And there are other comorbidities there, other physical ailments are there, other diseases are there, and ultimately it is a normal death, my lord, out of certain illness that has been recommended by the Calcutta Medical College Hospital. So I am restrictively submit, my lord, the impugned order should be set aside.
Compensation was directed to be paid by.
Yes, 5 lakhs to me. Did your lordship find any contribution on my part in the said final episode? I have given the COVID certificate. And that, my lord, that too at 10:30 a.m.
This was a reconsideration by the regulatory commission, because the result at page 43 is we are conscious of the fact no amount of compensation would bring our order of compensation is just to acknowledge the plight. Where is the compensation directed?
Compensation directly impugned order itself.
Initially, they came before the Honorable High Court, and Honorable High Court returned the matter and directed within a specific period, the final order has to be.
5 lakh was the initial order.
Compensation was stayed by High Court.
Initially, thereafter, High Court returned back the matter.
Yes. So that 5 lakh was finalized, made absolute, and disposed.
5 lakh initial.
That was made absolute by this impugned order.
The court has stayed it so long the final order is not done, and final order also will affirm the same.
Yes.
This is the challenge.
Shall I submit?
Pardon?
Shall I submit?
Yes.
I am on behalf of the victim's family.
Yes.
My lord. What happened initially? He was suffering from some kind of uneasiness, vomited twice, and at about 5:30, they reached before ESI hospital. Now, my lord, first I shall take your lordships to Calcutta Medical College Hospital's affidavit, my lord. Though, my lord, my learned senior friend, he has placed thoroughly, but it has been said, kindly comes directly to paragraph 5. it was said, fourth line, paragraph 5, that COVID positive. So COVID positive was, it was thought that he was suffering from COVID positive. Thereafter, my lord, kindly comes to paragraph 6. The patient admitted in CPR at 3:50 p.m. on 10th of July 2020. I'm not going into medical terms. Thereafter, we have, my lord, kindly appreciates, we have also allegations against Medical College Sagar Datta, because if your lordship kindly sees that Medical College admitted in paragraph 15, Medical College admitted that my son died at 9:45 p.m. on 10th of July. And we have been informed on the next day. At 6 a.m. we have been informed. My lord, this is not a case that we have not.
So who has jurisdiction to look over these?
Yes, my lord, what happened in this case? Initially, we filed a complaint before the Belghoria police station. That complaint was taken by West Bengal Health Regulatory Commission. My lord, kindly comes to page 76 of my learned senior friend's petition. Page 76 is the affidavit which has been filed by myself. Kindly see what I have written. It has fallen from your lordship that whether only allegations are only given, only heaped upon Midland or upon all the 4 institutions. Yes, I have given allegations against 4. But West Bengal Health Regulatory Commission, they have penalized because that was under West Bengal Health Regulatory Commission's jurisdiction. That's why Midland was penalized. Otherwise, I do not. My lord, kindly comes to page 76. Wide order dated September 2010, September 10, 2020, the Honorable Commission was pleased to grant liberty to the deponent, being the complainant of the instant case, to file an affidavit. Thereafter, what I have said, paragraph 3. No, paragraph 3 is not required. I'm reading from paragraph 3. I state that our only child, Subrojit Chatterjee, got ill on 9th July 2020, and he started feeling weak sometime in the midnight. During that pandemic situation, we could not get him to be treated at the night, and early in the morning at about 5:30 a.m. on 10th of July 2020, we took him to Kamarhati ESI hospital. At the ESI hospital, certain preliminary medical tests were done, and the doctors at the ESI hospital advised us to take our son to Midland Nursing Home at Belghoria and referred our son to the said nursing home.
Why did ESI not take your son?
My lord,
Why did ESI?
ESI said they did not have enough infrastructure. That's why they advised us to take
Infrastructure for treating COVID.
No, for treating such kind of patients, they could not understand what happened in the morning. They said, take the
So you did not file any complaint against ESI?
Yes, we have lodged complaint against all. Against all.
Let us proceed, yes.
Yes. ESI hospital arranged for their own ambulance for our son, and we reached the Midland Nursing Home at around 10 a.m. Reaching at the Midland Nursing Home, the hospital authorities and the staffs did not allow our son to come out of the ambulance, and for more than half an hour, son remained inside the ambulance on the road beside the nursing home without rendering any medical assistance whatsoever. At such juncture, my husband, out of compulsion, died 100 from his mobile phone, and we could contact the Belghoria police station. However, unfortunately, the inspector in charge, Mr. Ratan Chakraborty, refused. We have also lodged complaint against him before the police station. Refused to render any cooperation and disconnected the phone. Upon overhearing that we were desperately trying to contact the police and administration, one person came with a wheelchair and made our son sit on the wheelchair and wait outside the emergency department in the open way. No doctor or any other staff attended our son. My lord, I am grateful to your lordship that your lordship has not seen the document which was being submitted by your lordships, because our case is no preliminary medical aid was given. Then how they have collected that document, be that as it may, I'm not going into that. They have not come before your lordships with clean hands. Thereafter, one person came and took blood sample from our son and got inside the emergency ward. Within 2 minutes from taking such blood sample, we were informed that our son was COVID positive. This was our case, my lord, that within 2 minutes, no COVID test is possible. And that was,
you cannot blame them. I mean, COVID positive, he was ultimately had to be COVID positive.
My lord, we have the report, my lord. We have.
So
the-
why do you single out Midland? What was the fault of Midland? I mean, they
Yes.
said it, you are COVID positive,
No,
you were sent to some
but
COVID positive.
our cases,
Yes.
within 2 minutes, they have made the COVID kit test. COVID kit
For
test.
that, you are not entitled to
Yes,
compensation.
my lord,
Why?
no, I'm not entitled for compensation for
That has been
reason.
granted. They have challenged
But
that.
my lord,
Yes.
but my lord, as they have stated,
If you have to prosecute, you should prosecute Calcutta Medical College.
my lord, all right, my lord, I am.
Calcutta Medical College is
I have
apparently where it
allegations
happened.
against all, my lord, regarding Calcutta.
Definitely,
Medical
all are
College,
responsible.
I shall bring my submission. But my lord, the fact is, within 2 minutes, no COVID test is possible. That has been admitted by the CMOH. CMOH also rebuked them. And my lord, CMOH himself stated, they have annexed, my lord, I shall read that part, that how and what.
Let us briefly touch the points, Mr. Chatterjee, because so many matters are pending. I cannot spend so much time on one matter. I'm being very candid. Let us come to the point. I mean, sentiments, I appreciate the sentiments, but let us be on the point.
I bow down before
Because
you.
I have to
Not
cut short sentiment.
anything on the basis of sentiment, my lord.
No, not that you are praying. There are sentiments involved. Mr. Chatterjee, this involves the life of a young boy. There are definitely sentiments around it, and I do appreciate that. That was my intention. But let us be short on the points.
My lord, kindly comes to page 80. This is COVID kit positive.
Right.
Within 2 minutes, no COVID test is possible. Then, my lord, on the basis of COVID test kit, a COVID kit test, my lord, they have stated that COVID positive and no other hospital, nursing home, they allowed us to enter, and my lord, proper treatment was
You
done.
had COVID positive. That is an admitted position.
No, my lord, my lord, after all, there
Did you not have COVID? Did your patient not have COVID?
No, my son,
Your patient was not.
she did not die due to COVID. We have the report, my lord.
Did he have COVID or not? Was he COVID positive?
No.
Medical says he was.
My lord, who says medical?
How can you take your statement against the medical?
My lord, we have the report.
The hospital statements. 2 hospitals have said
My
you are.
lord, she did not die out due to COVID.
He.
That is our case. Sorry, he.
Yes.
He did not die due to COVID, my lord. We have the report. Ultimately, the
Report from whom? Report from whom, Mr. Chatterjee?
Viscera, my lord. Viscera has collected autopsy by medical authority. And that we have collected on 3rd of March.
Medical kept you from 10 p.m. 45 minutes. You were there from 4. They took you at 4.
My lord.
They admitted you at 4. You went there
We have
at around.
medical college also. But my lord, ultimately.
That is where it happened. This Midland probably kept you waiting for half an hour. They said you were COVID positive. You are on that 2-minute test. But Mr. Chatterjee, that cannot tantamount to medical.
Appreciates, my lord. On the basis of that 2-minute test, my lord, my son died. No other hospital treated him because they thought he is suffering from COVID. Our case is he did not die due to COVID. Now, my lord, kindly comes to page 62. Kindly, my lord, once, my lord,
Page 62.
Page 62.
Yes.
Sorry, 63 plus 65. 63 is the show cause letter. Show cause letter, Chief Medical Officer of Health. Page 63. I'm reading, my lord. One patient, Mr. Subrojit Chattopadhyay, was referred from Kamarhati ESI Hospital on 10th of July 2020 with medical advice to admit in the ICU bed with ventilatory support facility to your nursing home. You could not produce any evidence of medical intervention for stabilizing the patient before returning back to Kamarhati ESI. Avec COVID-19, IgM, IgG antibody rapid test. So kit was performed at your nursing home for diagnosing COVID-19 infection status of the said patient. You have failed to produce any documents of approval for commencement of the said test. Who told them to go for this test from the competent authority as well as the evidence of performing the said test also. Thereafter, kindly comes to their answer, page 65, relevant.
Yes.
Undersigned has already stated that for this particular case, as a special case, checked a COVID kit in discussion with ESI Hospital Kamarhati Authority and the visual understanding of COVID kit only been shared with ESI Hospital Kamarhati Authority and the same was done for benefit of patient. Undersigned has also stated that we are not using COVID kit for a single case other than this, but one case that was fatal for me. And my lord, it has fallen, another question has fallen from your lordship, whether my son died due to COVID or not.
No, whether he had COVID, that was my question.
He had COVID or not. Answer is no. Yes, my lord, he did not die due to COVID.
That was not my question. You were bending my question, Mr. Chatterjee, every time.
Sorry, my lord.
Don't try that with the court.
Sorry,
Please don't.
sorry.
At least not in my court.
No, no. my
You
lord.
thrice said that I am asking you whether he died of COVID. I never asked you that question, Mr. Chatterjee. Let us be very
Right.
clear on that.
My lord,
Don't
you are
apply
not-
those tactics on the court.
My lord, I.
Thrice you have asked the question. I say thrice. No, that is not my question. My only question is whether he was COVID positive or not. Not whether he died of COVID. That is not my concern.
Whatever will be the question fallen from your.
Did he have COVID positive?
No.
What
We
about
have that
Medical College
documentation.
Hospital says he was COVID positive?
We can.
Paragraph 5.
My, which is paragraph 5?
Please come to Medical College. The affidavit you just placed by Mr. Bhattacharya before you.
College answered, my lord, on the basis of the report that has been provided by Midland.
They provide the medical college provides the emergency ticket. They say it was he was comorbid and COVID positive was there. He was COVID positive.
Yes.
So that is the diagnosis of medical also.
No, diagnosis was done by medical. This is my submission, my lord. My lord, I have never done any.
You're trying to extract from the death of your son, Mr. Chatterjee. Very unfortunate. You're trying to extract some money from the hospitals on the death of your son. No, this is not done.
My lord,
If you have to extract money, extract from the medical college, which is the government hospital.
except money, my lord.
Medical college.
I have lost.
Why are you? I mean, this Midland, I don't know where it is even.
My lord,
This Midland is.
complained before health regulatory.
What happened to the medical college hospital? Because it's a state hospital, you are not pursuing.
That answer will be given by the person.
You tell me what happened to your complaint. You must be aware of that.
I have lodged 2 complaints. One.
What happened to that complaint against medical and Shagud Dottu?
I have lodged complaint before West Bengal Health Regulatory Commission. This order has been passed by them. So they are liable, my lord.
Was it followed up? What is the follow-up of that? Like here, Midland was followed up before the authorities.
Midland, I have not come against Midland. Midland have come, they have made us party.
Midland came against an order of the regulatory commission, which took place because of your complaint, because you have pursued that and you have tried, that has been tried out in your presence.
My lord.
Not because of their fancy they have come up. They have come up against a particular order which was passed because of your pursuance. How did you pursue against medical college? What did you do against medical college?
My lord, we
After
have-
that complaint, what did you do?
My lord,
I have to be clear on your bona fides also.
My lord, yes, one thing should be very clear. That, my lord, I have not tried to extract any money.
Mr.
from
Chatterjee,
the death
we
of my
cannot
son.
be only on your submissions.
Lord,
We have to be
whatever
clear
you
from the
have-
records.
Your
What have you done against medical college? You're still not answering. After that complaint, still I don't.
Apart from these 2 complaints, we have not gone anywhere. We have not gone anywhere, my lord.
Mr.
Even
Chatterjee, what happened to your complaint against the medical college hospital after that? After lodging the complaint, have you followed up?
my lord, police case we have followed. We have followed the.
My question is not on police case. My one sentence is, after the complaint being lodged against medical college, have you followed up that?
My lord, kindly appreciates one thing. We have lodged only 1 complaint before Health Regulatory Commission. Apart from that, we have not gone anywhere.
So therefore, you have not followed up that complaint.
No, because my lord, question did not arise because we did not try to extract money from the death of my son. This is very, my lord.
If you did not want to extract money from because of the death of your son, Mr. Chatterjee, you wouldn't have asked for compensation. You have asked for compensation. You lodged complaint before the police authorities for medical negligence. They should be behind the bars.
Of course,
Medical
my lord.
college, the person's concerned should be behind bars, not paying compensation to
We
you.
are pursuing that matter also. But the fact is, West Bengal Health Regulatory Commission, they have passed this order and that has been challenged thrice before this honorable court.
Show me that challenge. What happened to that? You say that has been challenged thrice.
One is before the honorable justice.
Did you challenge the non-grant of any compensation against medical
No, my
college?
lord, thereafter they have come. We have
Did you challenge the inaction of the medical of the health?
We have got an opportunity of coming before your lordships. We have come. Now it is before your lordships.
Mr. Chatterjee, you did not come before me. It is the petitioner who has come up before me against an order.
Appearing in that matter, my lord. If your
Mr.
lordship-
Chatterjee, empty talk won't help you.
My lord,
Empty talk won't
my
help
lord,
you.
if your
Tell me clearly, what steps have you taken against the medical college hospital?
We have
I'm not
already
bothered with
taken-
this 5 lakh only. If your son died due to the medical college negligence, they should be behind the bars.
My lord, it has fallen from your lordship that.
I'm not
all
on
the
granting
four-
5 lakh rupees
all the 4
to the
hospitals
bereaving
are
parents.
responsible. That I
No,
know,
not
my
that. Only 5 lakh rupees. What is
lord.
5 lakh?
I know that, my lord. It has fallen from your lordships on earlier days.
What did you do regarding that?
My lord, we have not done anything because, my lord, it was not possible for us to go everywhere from pillar to post, my lord. My lord, again, this question will come to extract money. My lord, we have not gone anywhere. We are sitting tight.
Very well, I'll direct the which authority has to look into that. I'll dispose of the writ petition, whatever may be the fate of their midland. That I'll decide on law, whatever you have.
I know that.
Regarding medical college and Sagar Datta, there has to be an inquiry.
My lord,
If you don't take steps, the court will sue me to do it.
my lord, honorable Reed Court has the power. My lord, your lordships can. Your lordships can. Because
We,
these
thi-
are-
we think so. We think so. We don't have. Unless it comes before us, there's a specific complaint, Mr. Chatterjee, we cannot sue to take up cudgels for people. Why should we?
My lord, this has fallen from your lordships that all the 4 medical institutions are responsible and we bow down to
No,
that.
I
my lord.
cannot say they're responsible, Mr. Chatterjee. But the lack of apathy on your part in not pursuing the remedies against them, that strikes me very much.
No, my lord,
And that
after
strikes me
you
very hard.
Child, my lord.
If it was my child and if medical did this, definitely if I challenge this, Midland is a petty operator here.
Yes, but what was our case? My lord, kindly
I'm not
appreciate-
at all bothered about you getting 5 lakh from Midland. They can pay you much more.
My lord,
They can pay you much more. If they can afford Mr. Bhattacharya, they can pay you much more.
we have no other, my lord.
Why didn't you
intention.
pursue these remedies?
Our submission was, had it been a case that they did not have written COVID positive, fate of my son could have been otherwise. This is our case. One liner, my lord, one liner.
Acha, Mr. Shahi, you tell me what should be the authority to inquire into medical college in Sagar Datta. Tell me that.
My lord, I have no such knowledge about it, my lord. Then I have to take the instruction if you allow.
Thank you for the being candid. Thank you. Yes, Mr. Chatterjee, who should be the authority? Midland will decide right now.
Regarding medical college. Yeah, medical council. Medical council, apart from medical council, there is no other forum.
Medical council cannot decide on clinical establishments. They are hospitals.
Clinical
Doctors.
regulatory commission regarding only private
Yes,
organization.
Mr. Banerjee, you have any idea? You are?
Health regulatory commission.
Then you tell me, you are the authority who should.
That's why I was saying, my lord.
The private organization, we do not have any authority to.
Who has the authority to deal with
Director of
government?
Health Service is the authority.
Yes, Director of.
Director of Health Service is the authority.
He has to take these steps. He has to.
But no complaint is made before the.
Similar, this complaint was lodged before the police station, not before us. Subsequently, it was forwarded to us. Thereafter, we have taken steps.
Yes.
In respect of the Midland only, because we cannot go beyond that.
Oh, your complaint, the complaint before you was also regarding Midland only.
Because we cannot go beyond that, because our files are very restricted under the act.
Yes. Mr. Chatterjee, where is your complaint against the other hospitals? Let me see those.
No, my lord, we have not filed any.
No complaint.
Written complaint has not been annexed over herein. My lord.
Have you filed any written complaint?
Yes, yes.
Your client is present, ask him or her.
My lord,
Ask him the date when he lodged complaint against medical and the other hospital.
one complaint was.
Don't try to protect Mr. Chatterjee. Just I'm asking a question. I'm asking a question. Answer me.
পুলিশ কমপ্লেন কবে করেছিলাম 12ই জুলাই আর হেলথ রেগুলেটরি কমিশন কবে নিয়েছিল
Health Secretary Commission, they did not do.
Not required.
They took up the cudgel.
On 12th of
Police
July.
forwarded that to health.
Yes,
That even I know by now.
I was also saying that, my lord. Entire complaint has gone over there. They have taken only the allegations against Midland. Because other 3 forums, they did not interfere.
It's like, no, right, we cannot interfere.
Very like to order. I'll decide this Midland issue right.
Only one thing, humbly, my lord.
Yes.
My lord, we did not try to extract money, my lord, from the Midland. Because
Very well. I take back that comment. Yes, Ashwin. Learned counsel for the petitioner contends that the present challenge pertains to the compensation awarded against the petitioner stroke clinical establishment within bracket CE, capse, bracket closed, with regard to the unfortunate demise of an 18-year-old boy. Full stop, next para. It is contended that a chain of events took place on the relevant date. Full stop. First comma, the patient was apparently taken to the ESI hospital, comma, Kamarhati at around 5:30 a.m. as per the complaint lodged by the complainant, comma, who are the parents of the deceased. Full stop, next para. Upon ESI having referred the patient to the petitioner establishment, comma, the said patient was brought to the petitioner at around 10 a.m. Full stop. According to the petitioner, comma, the petitioner found out upon a test that the patient was COVID positive. Full stop. Since the petitioner was not equipped properly to deal with COVID cases at that juncture, comma, the petitioner could not admit the patient, comma, upon which the patient was taken to the Calcutta Medical College Hospital. First, prior to taking there, comma, the patient was also taken to the Sagar Datta Medical College and Hospital, where he was refused admission as well. Full stop. Ultimately, the patient met his unfortunate demise in the Calcutta Medical College and Hospital. So it is submitted that the petitioner had no role to play regarding the alleged negligence for which the patient died. Full stop. Next para. Learned counsel for the petitioner seeks to assail the order of the West Bengal Clinical Establishment Regulatory Commission on several grounds. Full stop. Next para. First, comma, it is argued that no proceeding was drawn up against the other hospitals and the entire brunt of the allegations were made against the petitioner, comma, which had no role to play. Full stop. Next para. Learned counsel also places reliance on the materials on record to indicate that there is no clear explanation as to why the patient was not admitted at ESI. Full stop. Moreover, comma, it is argued that the affidavit filed by the Calcutta Medical College Hospital shows that the said patient was admitted near about 4 p.m. there. Full stop. It defies logic, comma, it is submitted, comma, as to what took the parents of the patient to bring the patient to Medical College Hospital over such a long stretch of time. Full stop. It is also contended that the distance between ESI Kamarhati and the petitioner is not much, and it could not take the family of the patient 4.5 hours from 5:30 to 10 a.m., comma, to bring the patient from ESI Kamarhati to the petitioner establishment. Full stop. As such, comma, it is argued that the compensation imposed on the petitioner was unjustified. Full stop. Next para. By placing certain portions of the impugned award of compensation by the commission, comma, learned counsel submits that the petitioner has been singled out to impose compensation, whereas it had no role to play at all. Full stop. Next para. Learned counsel appearing for the complainants, within bracket, parents of the unfortunate deceased, bracket closed, submits that the complainants have run from pillar to post. Full stop. The private respondent number 3 herein, comma, who was the complainant and mother of the deceased, comma, contends that the family of the patient took the patient to several hospitals, but to no effect. Full stop. In fact, comma, it is submitted that Midland, that is the petitioner, comma, did not have any infrastructure or examination kit for a proper examination of the patient as to whether the patient had COVID. Full stop. Next para. It is further submitted that admittedly the petitioner undertook the purported COVID test within 2 minutes, comma, which could not have been done by the petitioner. Full stop. Next para. The petitioner, comma, it is argued, comma, kept the patient waiting outside its precincts and never admitted the patient, comma, which led to the harassment of the patient party. Full stop. More importantly, comma, it is strenuously argued that in view of the faulty COVID report issued by the petitioner, comma, without having actually tested the patient properly regarding the same, comma, no other hospital intended to admit the patient, comma, which ultimately led to the inordinate delay in the patient being treated properly, and also led to the demise of the petitioner. Full stop. As such, comma, it is argued that it is the apathy and faulty report of the petitioner which led to the demise of the unfortunate patient. Full stop. Next para. A perusal, the two reports filed by the government hospitals involved herein, namely the Sagar Datta Hospital and the Calcutta Medical College Hospital, are nothing but an exercise to pass the buck regarding the cause of death of the patient. Full stop. While the Calcutta Medical College Hospital, comma, without referring to the reason for keeping the patient waiting from around 1:30 p.m. to 4 p.m., comma, directly address the issue of the patient having been admitted having been taken to the general emergency at 3:39 p.m. on the fateful day, that is July 10, 2020. Full stop. It has been alleged that certain medical procedure was undertaken by the Calcutta Medical College Hospital to the best of their efforts. Full stop. However, comma, the patient could not be saved. Full stop. Insofar as the Sagar Datta Hospital is concerned, comma, it has gone one step further and has alleged in paragraph number 5 that as per the records of the patients available in the record section of the College of Medicine and Sagar Datta Hospital, Kamarhati, comma, no such patient was found at all on July 9, 2020. Full stop. Next para. It is to be noted that the allegations in the present case pertain to the next day, that is July 10, 2020, when, comma, purportedly the patient was taken to Sagar Datta Hospital at around 5:30 a.m. Full stop. Next para. Thus, comma, this court is not satisfied at all with the explanations given by the College of Medicine and Sagar Datta Hospital, Kamarhati, as well as the Calcutta Medical College and Hospital, with regard to the role played by them in the sad demise of the 18-year-old boy. Full stop. Next para. Reverting back to the case at hand, comma, the petitioner alleges that the petitioner undertook a COVID test and found out that the patient was COVID positive, comma, which led to the issuance of a COVID positive certificate by the petitioner. Full stop. The matter had gone up to the Chief Medical Officer of Health, comma, North 24 Parganas, from a police complaint lodged by the petitioners against all the hospitals. Full stop. From a show cause letter dated July 24, 2020, annexed at page 63 of the writ petition, it is evident that one of the questions posed in the show cause letter against the present petitioner establishment was that the petitioner could not produce any evidence of medical intervention for stabilizing the patient before returning back to Kamarhati ASI Hospital. Full stop. It was further alleged in the show cause letter that the petitioner establishment had failed to produce any documents of approval for commencement of the said test from the competent authority, as well as the evidence of performing the said test. Full stop. Next para. By way of written explanation thereto, within bracket, reply to the show cause, bracket close, comma, the petitioner stated that the patient being referred by ESI hospitals comes with referral quotations with an advice of ICU ventilation for each patient, and there was no difference in the case of the patient concerned, that is Shubhrojit Chattopadhyay, within bracket since deceased, bracket closed. It was further stated that the patient had already been stabilized in ESI hospital and had come in full support and guidance of ESI hospital, Kamarhati. Full stop. On being informed by the petitioner regarding non-availability of bed, the said patient was allegedly summoned back by the ESI authority without delay, for which reason the petitioner was not authorized to conduct any medical intervention and so were not able to provide any evidence of the same to the investigation authority. Full stop. By way of further explanation, the petitioner stated in the said reply that for this particular case, as a special case, a COVID kit check was undertaken, allegedly in discussion with ESI, Kamarhati, and the double inverted the visual understanding of COVID-kit, double inverted close, was only shared with ESI, Kamarhati for the benefit of the patient. Full stop. The petitioner also stated in the said reply that it was not using COVID kit for a single case other than this and are doing RT-PCR test only for detection of infection in collaboration with government approved center. Full stop. Such explanation of the petitioner, however, regarding the COVID test was not sufficient, even ex facie. Full stop. If the petitioner does not use the COVID kit for a single case other than the present case, it defies logic as to what prompted the petitioner from undertaking the said test in the present case. Full stop. That apart, the allegation of visual understanding of COVID kit only being shared with the ESI hospital is extremely vague. Full stop. Next para. However, from a comprehensive perusal of the reply of the petitioner, it is seen that even apart from the COVID test, purportedly conducted by the petitioner, there was another ground for not admitting the patient, the same being that all the beds in the petitioner establishment were full. Full stop. As annexure P16 at page 82 of the writ petition, the petitioner has annexed a chart indicating the bed profile and the patient names on the fateful day when the patient in question met with his demise. That is on July 10, 2020, which indicates apparently that all the beds and the CCU units were full, being occupied by patients on the said date. Full stop. However, the said list does not find place in the discussion of the commission and apparently was not produced by the petitioner before the commission. Full stop. Next para. It is seen from the observations of the commission that the incriminating evidence against the petitioner, which was considered by the commission, was that when the patient reached the petitioner establishment, it was the bounden duty of the establishment to examine the patient in the emergency. Full stop. The fact that the patient was not allowed to go inside was not in dispute, it was observed, the establishment could only dispute the COVID positive report. Full stop. The commission held that even if full credence was given to the same, it would not find any plausible explanation why the CE could offer refusing to examine and admit the patient. Full stop. The plea of absence of vacancy was also considered by the commission, and it was observed that it was taken for the first time at the final hearing on March 15, 2021. Full stop. The commission recorded that there was a specific assertion on the part of the complainant to the effect, though on affidavit, and the CE was given opportunity to file counter, but they did not avail the same. Full stop. Mere verbal submission, that too on the final day of hearing, comma, it was observed, comma, would not impress the commission. Full stop. On some such premise, comma, it was also observed that a completely different stand was taken by the CE according to the commission that would rather corroborate the complaint. Full stop. However, comma, sufficient clarification does not find place in the observations of the commission regarding the difference in stand taken by the petitioner before this court and the commission. Full stop. The commission lastly proceeded on the premise that a young boy of 18 years was deprived of even primary medical aid and were impressed by the contention made by the petitioner, by the patient's parents, that the golden hour was lost. Full stop. Next para. Upon a comprehensive perusal of the materials on record, comma, it is prima facie evident that the petitioner was not solely responsible for the plight of the patient on the said date. Full stop. Next para. The Calcutta Medical College Hospital as well as the Sagar Datta Hospital cannot absolve themselves from liability of scrutiny before an appropriate authority, comma, in that regard as well. Full stop. Next para. The petitioner, the complainant cannot be entirely blamed for not prosecuting further against the said hospitals, since it may be difficult for an individual, comma, particularly who are suffering from the demise of their young son, comma, to run from pillar to post in pursuing their allegations against all the clinical establishments. Full stop. Insofar as the present petitioner is concerned, comma, its liability is limited to two aspects, comma, one, issuance of a COVID positive certificate without having any proper reason to do so, and secondly, comma, not examining the patient in its emergency, comma, prior to refusing admission on the ground of absence of vacancy. Full stop. Next para. The commission considered such issues and observed that the petitioner establishment could very well examine the petitioner in its emergency. Full stop. In fact, comma, even if the petitioner establishment did not have any specialized emergency unit as such, comma, it is well settled that no hospital or clinical establishment can refuse treatment to a patient, comma, who has come to the establishment, comma, merely on the ground that there is no availability of outdoor or emergency examination. Full stop. Even if there were no vacancies in the petitioner establishment, comma, it was the duty of the petitioner at least to check, examine the patient in its outdoor stroke emergency, comma, thereby rendering at least preliminary assistance to the patient, comma, instead of refusing the patient from the outside of the precincts of the establishment. Full stop. Insofar as the issuance of COVID positive result is concerned, comma, the same also is vitiated, comma, since there was no occasion for the petitioner all on a sudden to resort to the test which was resorted to allegedly in the present case, comma, since admittedly the same was not applied by the petitioner on any other patient. Full stop. On such premise as well, comma, the doubt cannot be dispelled that such COVID positive result, comma, without any authority, comma, was a deterrent in the patient being admitted in other hospitals before ultimately being so admitted in the medical college. Full stop. Next para. The question is not whether the patient was suffering from COVID or not. Full stop. The issue is, comma, whether the petitioner was properly equipped to conclusively observe that the patient was suffering from COVID, comma, sufficient to deter the petitioner from admitting the patient. Full stop. Moreover, comma, the petitioner could not shirk its responsibility in at least administering first aid or preliminary treatment to the petitioner, comma, in view of his critical condition. Full stop. Irrespective of the delay occasioned by the family of the patient in taking the patient from ESI to the petitioner, comma, we are only concerned with the specific window of consideration when the petitioner had an interaction with the patient. Full stop. Having found so, comma, I do not find any gross irregularity or illegality in the decision-making process of the commission, comma, in granting a meager compensation of 5 lakh to the petitioner, comma, in view of its limited but undeniable role in the plight of the patient on the fateful day, full stop. Accordingly, there is no scope of interference with the impugned order of the commission, full stop. However, comma, before parting with the matter, comma, it must be ensured as a court of equity, comma, that not only the patient gets justice, but there is also some deterrent on clinical establishments and hospitals, comma, private or government run, comma, in treating patients nonchalantly, comma, leading to their death. Full stop. Accordingly, WPA 16953 of 2023 is disposed of by granting without interfering with the impugned order. Full stop. The petitioners are granted liberty. Then the petitioner, sorry, the respondent number 3 is granted liberty to approach the Mr. Bhattacharya. Can you please tell me the name of that authority again?
Director of Health Service.
Approach the, thank you very much. The Director of Health Service, comma, Government of West Bengal, comma, with a server copy of this order, comma, lodging, reiterating her complaint against the 2 government hospitals, that is the Calcutta Medical College and Hospital and the
Thakur Datta Medical.
no, the full name is different. And the College of Medicine and Shagor, SAGORE, Datta Hospital, comma, regarding the demise of the son of the respondent number 3, full stop. As and when so approached, comma, the said authority shall look into the matter and initiate appropriate inquiry into the role of the said hospitals in the demise of the said deceased. Full stop. The it is made clear that the merits of such investigation, comma, which shall be undertaken at the behest of the Director Health Services, comma, pursuant to this order, have not been gone into by this court, and it will be open to the appropriate authorities to come to their findings in that regard. Full stop. In the event the respondent number 3 is aggrieved with the outcome of such action or investigation on the basis of their complaints in that regard, comma, it will be open to the respondent number 3 to approach this court for further relief. No address to cause. Thank you.
Grateful, my lord.
Thank you.
But I'm extremely sorry, my lord, I raised my.
No, you are right. You are right. I withdrew that way. I shouldn't have commented that.
Grateful.
Yes.
Item 9.
9. Yes. 9, who's appearing?
Lordship, I appear with the petitioner.
What is the matter, please?
My lord, I'm for the WBCTC.
Right.
6 to 9.
Lordship, petitioner applied for new connection, electric connection.
Right.
Quotation money has been deposited, Lordship, but due to obstruction made by the private respondent, the connection cannot be given, Lordship. That is page.
Who are the private respondents?
The co-owner. Page 20, page 22, annexure P4 is the, my lord, intimation of objection. Lordship.
Yes, what do you say?
My lord, on 7th June, he has applied for domestic connection and
Yes.
inspection was made on 12th June, my lord. And upon inspection, it was found that 2 poles are required for giving him domestic connection.
Yes.
And on 15th June, my lord, when the technical team went to that spot, the private respondent raised objection and they did not allow us to erect the poles. And for that, the technical team
Yes.
left that
Who are you? Your neighbors or co-sharers?
69. Your private 5 is the actual owner of the land in question, who is our father. He died. But against the dead person, this is also 5.
What, 6 to 9?
6 to 9 is the sons of the private 5. Private 5 died in the year 2021. And we are the owner of the land in question.
The land where the poles are being erected?
No. No electricity in our premises. It is in our land. It is 21 decimal land which is owned by us. And 5A own rest 10 decimal land of the plot.
So this person is a co-owner, your co-owner?
No, he has no authority to at all. This is our land, and in the year 2020, he tried to forcibly occupy our land. Against that, a civil suit is pending and injunction order has been passed against them.
What injunction has been passed? Please give me a copy of the injunction.
Status quo. To maintain status quo. And commissioner report also made.
Have you got a copy of the plaint?
Yes.
Please hand over a copy of the plaint as well as the injunction order.
I have filed a suit for declaration of right of interest and not to disturb by the petitioner who is a rank outsider and not in possession. And there is the order, my lord.
Yes, please.
This is the last order for extension up to 24 January. This is our land, my lord, and they are not trying to construct 50 meters line through our land. And in the petition, they did not mention anything about the ownership, plot number, nothing else. Kindly see the petition, their statements. All of a sudden,
I can't read this order. Have you got another copy? Please read it out for me.
this is the extension order, my lord. I am replacing the.
Where is the original order?
Original order.
Please read out the original order.
This is the type order.
Read out for me. I have no difficulty so that they can also hear. Yes.
Plaintiff files Hajira. Learned advocate for the plaintiff has paid for hearing of injunction petition with administrative relief and local inspection petition on the ground of urgency. It appears from the case record that no caveat is pending against the suit till death. Therefore, the case record is taken up for hearing. The brief facts of the plaintiff case is that the plaintiff has purchased 20.23 decimal property from a total property 31 decimal in Ela plot number 986. Total area 986 is 31 decimal, out of which.
What was the ordering portion? Just read the
ordering portion. The defendant or hereby restrained from changing the nature and character of the custodial property of plain till 24th August 2017. And that
nature character, not possession.
Not possession.
Not possession. Not changing the nature and character.
If they are not to change nature and character, they have to be in possession for changing that. Your allegation.
No, they are not under possession. Can you see the plaint?
If they're not in possession, where is the question of their changing nature character?
Can you see the plaint?
Your plaint says that, but that has not been granted to you. What has been granted is they cannot change the nature
and
character.
Yes, below nature and character.
So nothing has been said. It has not been said they cannot disturb your possession.
No. You are in possession. That is a statement.
That is your statement.
And report of the commissioner is also there.
Commissioner report says they are not in possession.
Yes, below. Commissioner report.
No. The status order is also here.
Yes.
In this copy.
The recordable right is also in our name. Now, kindly see the record of rights, which is also stands in our name.
What sort of a report is this? The report says, I, the undersigned lawyer, have been appointed as advocate commissioner and received writ. I informed learned advocate such as that plaintiff and two defendants were present. I filed field notice. Plaintiff signed in the field notice, but defendants refused. Then I started my local inspection work as per direction of the writ. Wanted Moja map. I prepared hand sketch map of the suit plot and non-suit plots with help of it. Plaintiff and defendants identified the suit plot. I satisfied with the identification of the suit plot.
Yes, sir.
So where does it speak about possession?
But recovery rights is
He has identified the suit plot. Very good. Fair enough. Court has directed them not to change their nature and character.
But I am in possession. It's admitted fact. Kindly see the
Who has admitted?
record of rights.
Record of right is not their admission.
They're filing this case tied to taking electricity in my own house and over 50 feet lands of our own land. And in the
You have produced any proof of your possession of that property?
and they totally suppress that fact of pending of civil suit.
Is your client?
Yes, yes, sir.
What possession of proof can you prove? Give.
They have totally.
So I am in possession. Inspection was done in my presence, Lordship.
Yes. Do you have any stand on that?
One sketch map.
No, they are in possession according to you.
Inspection was done in my presence.
And one pole is to be erected at the edge of the pond and another pole just in.
And 50 foot pole, 2 poles has to be in over our own land, my lord.
Lordship, I am representing state. These are my instruction.
What is your instruction? What does it say basically?
Lordship, it has prepared a report. During the local inquiry, I collected report of PLRO Mahishadol in which he has opined that the owners of the land bearing Moza, Laksha jail number 103, plot number 986 are SK Jamal, son of SK Matara, and Alafujuddin, son of Gul Muhammad, both of village Laksha, PH Mahishadol, district Purbo Mednipur. From the report of BLRO Mahishadol is found that there is no right of the petitioner Eknath Khan Mahishadol over the land bearing Moja, jail number 103 and plot number 986. During the spot inquiry, it is found that there were two abandoned government pump house which were used for supplying water for irrigation purpose. Beside these two houses, there were another house made of bamboo and polythene. All the above noted 4 houses were occupied by the petitioner. On asking, petitioner did not produce any valid document about his engagement of the said pump house and ownership of the said plot. Allegation of the petitioner regarding threatening of OP members is not substantiated during local inquiry. The matter is civilian in nature. So this is the report.
Learned counsel for the petitioner argues that the petitioner is in occupation of the property in question, but cannot get electricity connection there due to resistance by the private respondents. Full stop. Learned counsel for the distribution licenses submits that although prima facie possession of the petitioner has been found, 2 electricity poles are required to be installed to give such connection to the petitioner, but such work could not be done due to resistance by the private respondents. For the next para, learned counsel for the private respondents argues that the private respondents have instituted a civil suit where they have claimed their title as well as sought for injunction restraining the petitioner from entering into the property in question. First up, it is argued that the private respondents and not the petitioner are in occupation of the property. Full stop. Moreover, an injunction order has been passed in the suit. Full stop. Learned counsel for the private respondents further argues that Even a local inspection was held and a commissioner's report filed in connection with the suit. Full stop. Learned counsel also seeks to place reliance on an extract of a record of right, which apparently shows that the private respondents are in occupation of the property and that the property has been described as a water body. Full stop. Next para. Learned counsel for the state files a report which is kept on record. Full stop. It transpires from the submissions of the state and the report that the state is of the opinion that the petitioner has no title over the property in question and could not produce any document in that regard. Full stop. Next para. Upon construing the documents which have been relied on by parties, it transpires that the petitioner has been found to be in prima facie possession by the WBACDCL. Full stop. Under the law, a person who is in settled possession of a property can only get electricity connection to the said property. Full stop. In the event any obstruction is raised, the matter can, in certain cases of a credible case having been made out by the objectors, be referred to the concerned district magistrate. Full stop. In the present case, the private respondents' arguments cannot be accepted on the ground on the question of possession for two reasons. Full stop. First, the mere filing of a suit does not indicate that the pleadings therein are sacrosanct unless a decree of a competent civil court is passed in that regard. Full stop. Secondly, the order of the ad interim order passed in the suit, as relied on by the private respondents themselves, merely restrains the present petitioner, who is the defendant in the suit, from changing the nature and character of the co-scheduled property of the plaintiff. Full stop. Next para. It was observed by the civil court in its order dated July 21, 2017, a copy of which is handed over in court and kept on record, that from documents filed by the plaintiff, it transpires that he has a prima facie case for adjudication and that the nature of the property is jol, single inverted. Full stop. Next para. However, there is no mention in the said order as to who is in occupation / possession of the said property. Full stop. Although the property has been described as jol, it is doubtful as to whether the exact plot over which the electricity connection is sought by the petitioner falls within the description of a water body, since a primary inspection by the distribution licensee also did not reveal so. So rather, the petitioner has a right under section 43 of the Electricity Act 2003, being in prima facie occupation, to have an electricity connection. Full stop. Next para. Regarding the dispute raised by the private respondents, as to title, the same will definitely be decided conclusively in the suit, along with conclusive decision on the possession of the parties. Full stop. However, as on date, there is nothing in the orders of the civil court which conclusively or even prima facie determine that the petitioner is not in occupation of the property. Full stop. Next para. In such view of the matter, WPA 18342 of 2022 is disposed of by directing the WBACDCL to give electricity connection to the petitioner at the plot in question by installing the electricity poles required therefore. Full stop. In the event the private respondents have any objection regarding the location of the poles, it will be open to the private respondents to approach the concerned district magistrate, who will decide the issue. Full stop. However, such reference by the private respondents shall not prevent the WBACDCL from giving the connection to the petitioners at the present, subject to the outcome of the proceeding before the district magistrate, as well as the suit, full stop. Next para. The connection shall be given by the WBACDCL to the petitioner, subject to the petitioner complying with all formalities in that regard, preferably within 4 weeks from the date of such application, and 4 weeks from the date of such compliance being made by the petitioner. Full stop. It is made clear that the connection, comma, as and when given to the petitioner, comma, shall not create any special equity or right in favor of the petitioner and or establish the position of the petitioner conclusively, which will be subject to the outcome of the civil suit as well as the proceeding before the district magistrate, comma, if initiated by the private respondents with regard to the installation of poles on their land. Full stop. Next para. If the WBA-CDCL is registered from any quarter in giving electricity connection to the petitioner, subject to compliance of formalities by the petitioner, comma, it will be open to the WBA-CDCL authorities to approach respondent number 4, the inspector in charge, Mohishatal Police Station, who will give adequate assistance to the WBA-CDCL personnel at the cost of the petitioner to ensure that the connection is so given. No address to cause urgency report.
Only one point. If in future failure to make payment of the electricity bills, no charge or lien to be made over the plot and further correction by the petitioners.
No, how can I say that?
If they failure to do,
No,
the
but
electricity
the
will not
difficult,
keep
no,
correction.
you are right. You cannot suffer for his
Yes,
fault,
Lord.
but the law is definitely clear that if there is an excess only, then they can ask for that. And here, after this order and your suit, I don't think there can be any nexus. That you need not apprehend that. Pardon? Within 4 weeks from their compliance.
Private issue to be applied before the district magistrate within certain period.
No, you can apply
Immediately.
tomorrow also. You can even stall this if you can get that heard before that.
My lord, take back the suit, take back, my lord, take back the copy of the plaint.
Plaint, but I have referred to the order.
Order. No, I am take back the.
So give a copy of the order, take out the copy of the order.
Plaint, my.
You can isolate the copy of the plaint, then hand over a copy of the order. I only require that order. I have referred to that.
Order checked only and upon my.
Do that, segregate it and give the order. দিয়ে দাও
বলছি
হাঁকুর নিদানে
অর্ডারটা রাখুন প্লেনটা
সাইডে চলে যাও
অর্ডারটা রাখুন
Original site mentioning.
My lord, item 11, my lord, I'm sorry for the indulgence, my lord, this is that matter where SEBI was going to do an auction and 3 flats in in Behala. The auction has taken place, my lord. Today was the date, my lord, was fixed. My lord, there was no interim order because sale certificate was supposed to be given by the bank to us. So still now they have not, they are trying to find it out, my lord. My lord,
tomorrow I'll take it up.
What can we do? I'm obliged. I'm obliged.
Yes.
For hearing item number 1.
What is hearing there?
My lord, I think your lordship intended it to come for extension of interim order.
Oh, what?
My lord, it was mentioned yesterday. my lord.
I'll extend the interim order for a
Very
little
well.
I'll extend it till before the puja vacation and I'll keep it in the list for here. It will remain in the list for hearing.
And for the respondent number 2.
Very well. The interim order granted earlier is extended till October 19, 2023 or until further order, whichever is earlier, full stop. The writ petition shall be listed tomorrow for hearing.
Obliged.
Thank you.
Item number 2, appearance to the win. Item number 2.
Suppose you are for the petitioner?
My lord,
yes, right.
Well, since the respondents are not appearing,
yes,
may I just file the affidavit of service?
Good service has been affected. Not affected yet. Can you give a notice to the other side? Come back tomorrow. It will retain its position.
I'll do that.
It will remain in its position.
I'll do that.
Although the petitioner is represented, comma, none appears for the respondents. Let the matter stand adjourned for the day.
Okay. Item number 3. ও 3 থেকে কত আছে? হ্যাঁ 3 to 6.
3 to 6.
My lord, I am appearing for the petitioner, my lord.
Yes.
And Mr. Shuddha Sat Banerjee is appearing. He had made his submission and respondent was making reply to our submissions. Mr. Aniruddha Chatterjee was appearing for the.
For item number 2, Mr. Kormokar is appearing in item number 2. He's just coming before your lordship. Just short pass.
Short pass over. Short pass over. Let us see. Wait for 4-5 matters.
Yes, my lord.
Item number 7.
And for the petitioner lordship, kindly allow short passover.
No short passover in every, then I'll make it not today. Not today.
Item number 8.
Your Lordship, I'm for the petitioner. There was a vacating application which Mr. Kundu had mentioned on 2 occasions. Now he's not there to move it.
Yes.
I'm led by Mr. Shuddhasattva Banerjee.
So I'll make it not today. Then.
If your Lordship will hear 3, 4, 5, Mr. Banerjee will anyways be there. Your Lordship may also choose to keep it as a passover.
Passover,
If
very
your
well.
Lordship so desires.
Passover. For the respondent,
Yes, it's for Corporation of India.
you have
That
filed a
is the-
vacating application.
Huh?
You have
I
filed-
have filed a vacating application.
So let us hear it. Yes.
Yes.
Let us hear it.
Your Lordship, the affidavits are complete. Your Lordship can hear the.
The main writ petition.
Yes, Your Lordship.
Then I'll hear the main writ petition, Mr. Kundu. Well, passed over. Mr. Kormakar has to have preference. He's taller than all of us. Yes. Pass over থাকে এটা এই আগে একটা কর্মকারের ম্যাটারটা দেখবো তারপরে আবার এটা দেখবো one matter pass over ইনফরমেশন ব্যানার্জি
এই পেপার
ইয়েস ওই পাস ওভারটা আরেকবার দেখবো
আচ্ছা item number 7. 7
ভুলে গেছে
2 তো 2টা পাস ওভার হয়েছে
এটা পাস ওভার হলো
8 পাস ওভার
কি
2 পাস ওভার হয়েছে 2
টা
তারপর
pass over।
3 to 7 কোন নম্বর
Mr. Kormakar, you are appearing which
in
one?
item number 2 and also Milord item number 3 to Milord 7
3 to 6 পাস হলো তো পাস ওভার হতো
2টা পাস ওভার হ্যাঁ 3 to 6 পাস ওভার হয়েছে
না না 3 to 6 পাস ওভার হয়েছে তো তোমাকে বলছি 3 to 6 দেখো
আচ্ছা ওকে item number 3 to 6
yes
For the petitioner.
টুটা কি বলছো
মালিক চ্যাপ্টার
ওনাকে ছাড়ো তো, যেটা পাস ওভার সেটা yes Mr. Kormakar, unfortunately Mr. Chatterjee is also here. It will take some time.
That's fortunate.
Unfortunate can
It will take some time, that's right.
No, I will be as
No,
crisp as possible.
argue a matter, Mr. Chatterjee, no difficult.
খুব বেশিক্ষণ লাগবে। I don't have much to say as না আগের দিন আমি বলিনি, আগের দিন এন্তা বলেছি।
Yes.
আমার ব্রিফটা
Grounds extraneous to scheme. You have to start with that.
Well, I'll start a little
earlier
before that.
Right. Internal correspondence. Just ensure that Mr. Basu's matter is taken up today
He does it when I don't have a
when he is not there.
যে কি লোভ এত টাকার I do not understand why is it?
That is the main motivator. So, at the end of the day, what else?
Continue till 425 and then
তোর কোনটা?
425 then
Yes, Mr. Chatterjee, no special effects. Move it quickly.
Yes, my lord, there was one very important submission that Mr. Banerjee made, and I feel that's wrong. That's my lord. He said that scheme was jute boards.
Scheme was?
Scheme was of jute board. So that I will show immediately, my lord, that that's not correct. Kindly turns to the scheme once. আমার ব্রিফটা দেবে না তোমাকে বলো আমার ব্রিফটা দিতে Kindly turns to the scheme once, my lord. It starts off NJB Act about page 22. My lord, your lordship will kindly, my lord, remember or recall that his prayer is that he wants, my lord, the incentive in terms of the scheme from 1st of October 2013 to 31st of March 2017 and 1st of April 2017 to 31st of March 2020. So there are two schemes he's clubbed together and he wants them wants the money in terms of that scheme.
Right.
Kindly turns to the scheme he's annexed, my lord, at page 22. National Jute Board. Then kindly turns over, my lord. The lordship will find the objective. Kindly have a look at, my lord, very importantly, because this will again be a point later, is number 3, Is number 23, page 23, my lord, at clause 3.
Up to 31st March.
Yes, 31st March 2017. It
Right.
starts from 1st October 2013, 31st March 2017. Then the definition, National Jute Board means the National Jute Board constituted under the National Jute Boards Act under Ministry of Textiles, Government of India. This is one. Then the Jute Commissioner, my lord, your lordship has already seen. Your lordship may turn that over. Then kindly turns to, my lord, page 24.
Yes.
Lord, IJIRA is again very important at the top, means Indian Jute Industries Research Association located at 17 Taratala, and IJMA is the Jute Mills Association. Then kindly comes down a bit, operating agency. National Jute Board Kolkata will operate the scheme. My lord, I am nothing but an operating agency. This is my first point before your lordship to say that the writ petition itself is not maintainable in the absence of the Government of India, who has floated the scheme. And this is something which he himself has said, not me. Forgets about, my lord, what I have said. He himself, kindly takes up, my lord, the second
Page 197.
kind of 197.
210.
Kindly turns to, my lord, his letters at yes, 209. কেন আমার ব্রিফ আসবে না এখনো বুঝতে পারছি না
Yes.
209, my lord, he is writing to the chairman technical committee ISAPM.
Right.
Kindly turns over.
The 209 of quadruple 2
Yes,
WP.
of Balifab.
Balifab. 209, he writes to Honorable Minister of Textiles and all.
Yes, yes.
Right, right.
Yes. Kindly, this is 209. Your lordship will find. Just give me
Yes,
two,
yes.
2 minutes. রাগড়া কেন মাঝে মাঝে করে ফেলি বাট ওটা অন্যায় yes your 209 he writes to Smriti Irani and he turns so to 20210 second paragraph. It is pertinent to mention here that in view of large export orders of jute diversified products, we have taken up further modernization and upgradation program and submitted letters of intent with NJB such and such under incentive scheme of acquisition of plant and machinery. The said acquisition has been completed and we are now in the process of submitting further claim applications for release of incentive and national jute. It may kindly be appreciated that a continuous efforts to modernize and upgrade the manufacturing facilities requires much needed support provided by the Government of India through its implementing agency, National Jute Board under ISAPM. This is his consistent stand. And this is true. I am saying, my lord, that he is right here. I am agreeing with him for a change, but once he says this, he can't make a submission before your lordship, my lord, that the scheme belongs to the Jute Board. My lord, if your lordship sees, my lord, the National Jute Boards Act, the entire scheme of the act is, my lord, that I am really implementing what is being given by the Government of India. The various, my lord, I'll just give your lordship the outline. My lord will see the entire National Jute Board Act is with respect to, my lord, the Ministry of Textiles having a complete control over the jute board. And he himself understands, my lord, that the scheme is of the Government of India. I am only an operating agency. So if he has a grievance that his money is not being paid by the Government of India, my lord, the actual defendant or in our case, my lord, the respondent is the Government of India. And the other point is, my lord, that I had pointed this out to them. They have consciously said that they are not going to include the Government of India. So I say, my lord, the Government of India not being a party makes the writ petition not maintainable. Because any order that your lordship would pass, my lord, would be on the Government of India to, if your lordship is interested, my lord, after going into the merits, then it would have to be, my lord, on the Government of India, who is not a party to the proceeding. Lord, his consistent stand also comes in later. He writes to the Jute Commissioner, 210, your lordship will find.
Yes.
The same paragraph, the same thing. So I say, my lord, that Mr. Banerjee, my lord, made probably that I don't agree with him when he says that, my lord, it is the Jute port. Now kindly turns to, my lord, the first volume back again to the scheme. আমি বলেছি outline, আমার তো বড় করার প্রয়োজন। Kindly turns back to the scheme. My lord has already noticed, my lord, that the scheme will come into effect from the 1st of October 2013 and continue up to the 31st of March 2017. Very importantly, my lord turns over eligibility criteria. I'm not on. My lord, I say, my lord, for a to be fair, the eligibility criteria probably he comes under it. I'm not going to say that he doesn't come. Kindly turns to 26. Lord, to give your lordship a little bit of a background, what is this scheme for? Lord, the jute industry needs a little bit of money. It's not that they don't have money, but they require certain sum of money, my lord, to push, my lord, their business, which is my lord, beneficial for the economy at large. Today, my lord, what happens is the plastic bags have to go, my lord, and the jute bags have to come in. So the government of India's policy is, my lord, to promote the jute business and the jute industry. Now, to promote that, my lord, these incentives come in. The incentive of government of India, I am only, my lord, a nodal operating agent, disbursing money and disbursing agency, and even the inspection, my lord, I'll show you a lordship that. What happens is they are supposed to buy these machines from, my lord, the vendors approved, my lord, by IJIRA. Then there is an inspection technical committee which goes and inspects that what are these machines, whether they've actually bought it or not, and whether they're using it or not. And also your lordship will find that they will have to give an undertaking that within 5 years, my lord, they will not going to touch those, my lord, machines. I'll show your lordship all that. So this is a part of, my lord, that inspection team where, my lord, it's not just the jute board. IJIRA, IJMA, Government of India, a part of the jute board, some of them, my lord, are all members of that committee. Kindly see 26. Upgradation, modernization, or setting up new units along with the scheme. NJB will involve IJIRA or any other technical institution as may be considered by the technical committee and notified by NJB for the purpose of the scheme from time to time to appraise technically the scheme and will inform the jute mills or JDP units for its approval of the eligibility of the scheme for subsidy. NJB will issue an in-principle approval to the investment after examination and appraisal of the proposal. Then the applicant will be required to submit claims. This is very important. Within 1 year to be extended to 18 months under special circumstances from the date of issue of the in-principle approval. Then Lord, I don't think your lordship needs to trouble my lord self with the entire. For bank finance, there will be a different way of doing it, but they have done it, my lord, on their own finance. So this is going to be important for your lordship. Then Kelly turns to the next, my lord. This one I showed your lordship. I showed your lordship, my lord, at page 27 the other day. That in case it is found that the incentive has been availed of on the basis of any false information, the company shall be liable to refund to National Jute Board the incentive availed of, along with interest to be charged from the date of disbursal to the date of refund. The rate of interest shall be the prime lending rate of NJB's banker at the time of invoking this penal clause. Then kindly turns over, my lord, to page 28 at 11, clause 11. A total fund of 19 crores shall be provided by the Ministry of Textiles to NJB for 4 years. They're very important. To show, my lord, that I am not the person who is funding it. The Ministry of Textiles gives it to NJB and I am only disbursal authority. Under non-planned fund for this scheme, the NJB shall disburse funds. Kindly, my lord, appreciate this. Shall disburse funds to the respective eligible applicants against the non-planned grants from the Ministry of Textiles. So the entire money comes there. I find them eligible in terms of the technical committee's report, and then I only disburse. So if the government of India doesn't want me to disburse something, my lord, I don't have an appellate authority on them saying that I will disburse irrespective of what you say, because the scheme belongs to the government of India. Kindly, my lord, turns over now. Kindly turns over, my lord, to 29. This is the technical committee. Jute Commissioner, Secretary NJB, Chairman IJMA, Director IJRA, Chairman CJFSA, Secretary Jute Shippers Council Chethala, Representative of JDP sector, Representative Yan. This is what is the technical committee. Now turns over to page 30. And this is the, my lord, the operational guidelines. Your lordship is not interested with the other part. Kindly turns right to 31 at the bottom. Secretary NJB may approve extension of period of 6 months beyond the existing limit of 1 year to allow delayed submission of claims only arising out of factors considered as force majeure. Thus, if a jute mill or JDP unit fails to submit its claims within 18 months from the date of IPA for own source or disbursement of last installment of loan or date of installation of plants or machinery, whichever is earlier, for bank finance, the claim will not be considered. Very importantly, K and L. The jute mill JDP unit intending to avail the incentive under the scheme on its acquiring and installing machinery for upgradation and or modernization will apply to the Secretary National Jute Board for the same in form number 1, annexed hereto along with the required documents as mentioned therein. Such application shall be submitted within 1 year from the date of issue of the in-principle approval to the upgradation or modernization proposal or during the continuation of the scheme, whichever is earlier. So, my lord, even if the extension, if I can grant, it can be granted only during the continuation of the scheme. So they cannot, in my respectful submission, go beyond the time and apply, my lord, when the scheme is not there. Vis-a-vis that, I take your lordship directly, my lord, to their application. বলেছি তো আগে, আবার বলছিস না। যখন ভুলে যাব তখন interrupt করবি। Kindly now, my lord, turns to their application, which your lordship will find. না, শেষ হয়ে গেছে তখন না, application. Yes. Kindly turns to, my lord, page 121. My lord, and kindly directly goes to, my lord, 124. Looks to the date plot. This is 21st of August 2017.
Yes.
Which is beyond the period of, my lord, the scheme. The lordship remembers the scheme was 31st of March 2017. It ends. It starts from 1st October 2013 and ends on 31st of March 2017.
Yes.
So this application, my lord, is beyond the scheme, beyond the life of the scheme. So ipso facto, my lord, they were not entitled to, my lord, under the scheme at all, because their application was late. My lord, there could have been an argument made by Mr. Banerjee that I had a right to extend it. My lord, I had no right to extend it beyond the period of, my lord, the scheme was functioning.
Would it be evident from your conduct that you did extend actually?
Lord, there was nothing
from you.
Nothing, and there's no arguments also.
That is not there, your argument is
Not there.
sustained.
My lord, I say, my lord, even if I have a right to extend, I cannot extend. Because it says the operational guideline that I have a right to extend only if the scheme is operational, whichever is earlier. They know about it, but they did not, my lord, apply in my respectful submission, my lord, within that time frame. So they are not eligible to that extent either. Now, my lord, a lot was said that, my lord, my main problem was that they belong to a particular group, and the particular group earlier, my lord, had been, my lord, really been, my lord, instrumental in, my lord, taking money from the government and not utilizing the way they should be.
If
And there-
adjusted with those claims.
Yes, a lot was said on that. Now, I will come back to that later, but I will show, my lord, from the inspection itself, my lord, there were anomalies. From the inspection report itself, there were problems, and there were major problems. Now, what happens is, what is not known to them is, and not what is not known to us also. Now, what happened was, in a matter, there was a earlier scheme that was called the MM4 scheme, mini mission scheme. In that scheme, again, such a thing, my lord, was allowed to them, an incentive was given, they were allowed to buy, my lord, and all that. Now, what the CBI found was, the Kankaria group people, they, my lord, did not buy the products. What they did was, my lord, they were in hands and gloves with some of my officials. And what they did was, those machines, which were all old, but they showed as if, my lord, that they were new. There were inspection report, my lord, where, my lord, my officials were, my lord, involved. Disciplinary proceedings started. My lord, they were dismissed from service. I was appearing for the Jute Board at that point of time. Justice Sinha, my lord, was pleased. I mean, Justice Sinha was pleased to, my lord, dismiss the writ petition, and then, my lord, now an appeal is pending against that order of dismissal. Now, this is what has happened earlier. Now, once that happened earlier, my lord, may I ask this question to myself? Is it not open for a disbursal authority to be more, my lord, cautious before, my lord, money is dispersed? Now, it is not that absolute right, my lord, under the scheme that they will have to get it. My lord, I am trying to tell your lordship is that the disbursal authority has within its rights to see, my lord, that a person who has in the past cheated, my lord, the government of India of money which belongs to the public, is it not, my lord, may I ask this question to myself, that the disbursal authority will be extremely cautious before, my lord, the money is, my lord, given to them. So if a point is available, my lord, to the disbursal authority to stop the payment to them, my lord, it is within their rights, my lord, to avail of that, my lord, particular, I would say, my lord, cautiousness. Now, kindly look at the inspection report. Kindly look at the inspection. First one, it starts off from 127. Why I say, my lord, that they are probably made a mistake by not making them these technical committees a party, because the reports are, my lord, in some reports it's against them, and it's based on those technical committees, my lord, reports. Looks to 127. The inspection team comprising of Sri P.K. Shahu, Sri T. Ayappan, Sri A.C. Deka, Sri Sach and Sach, and Miss Rajani Behera, JC's office, visited Messrs. Bali Fabs International Limited at 3 Horen Mukherjee Road on 27/11/2017. All the members of the inspection team except Sri D.R. Guriveli also visited such and such on such and such for inspection of machineries. As reported, Sri D.R. Guriveli could join the team on such and such due to his sickness. The inspection team was accompanied by Mr. Sri P. Gupta, who is the applicant for Bali Fabs, and Sri M. Chakraborty of Messrs. Bali Fabs at 3 Horen Mukherjee Road, Belur on such and such. Claim application of MS Bali Fab such and such, phase 1. Date of application is 1/12/2016 and date of claim is 21/8/2017. 21/8/2017, I showed your lordship that. Now, kindly sees the remark portion. With respect to, my lord, Hiracle machine, not included in IJIRA's TAR. TAR, my lord, is technical audit report. This is not included there. And they have imported this, my lord, as new non-core jute machinery from somewhere, my lord, in Singapore probably. I have no clue. But this is not included, my lord, in the IJRA's TAR. And why it's not included, my lord, it would have been IJRA's, which is an independent agency, my lord, to have shown your lordship why it was not done that. It is not, I don't have that technical expertise to show your lordship why this was said. IJRA is not a party, so he can't come and my lord, protect pillar whatever he's written. Now kindly turns over. Will not waste your lordship's time with the entire.
Not trouble your lordship. Hold on. I'm asking him not to use the word not trouble your lordship.
I remember on the last occasion that happened. But this is what it's colloquially, my lord, it's gone into our systems, not to say something like that. Kindly have a look at 131. Embroidery machine supplied by Rich Piece is not available during inspection at 3 such and such on 27/11, 28/11. It was informed to the inspection team that the machine has been installed at 2 Kamak Street. This is again in violation, because in their application, my lord, they had said that the machine is at Horen Mukherjee. My lord, these are very, very technical things, my lord, which I have to bring out for your lordship's kind consideration. Because I am saying, my lord, that this is creating, my lord, a doubt in the mind of the disbursal authority. Sample hose, this was mentioned in the application form. Since this is a different location, the inspection team could not inspect the machine at Kamak Street. Payment receipts have not been enclosed in all cases. Marks it. Being all are imported items, outward evidence, delivery report issued by the concerned bank are enclosed. The inspection team could find the machines such and such were in operation, but could not find manufacturing details with model number, etc. in the machines as given in IJRA's TAR and claimed application. Hence, the team left the machines uninspected. So my inspection also, my lord, revealed quite a lot of anomalies. Then kindly turns over to, my lord, page 134. There was another, my lord, inspection on another date. Again, that problem crops up with Hiracle machine. That's not included in IJRA's TR. Lord, there are several, my lord, your lordship will find at 135. Several, not included in IJRA's TAR, not included in NJB's approved MC list under this scheme. Quite a few remarks on the right-hand side column. Quite a few. Then turns over. Very importantly, this creates a lot of confusion at 136. Because I have not been able to take a final decision in this, I means my client have not been able to take a final decision as such here. Before that, he's come before your lordship. 136 looks at A. Manufactured nameplate have been pasted, not riveted. This is the most important problem. This is the same problem, my lord, which happened with the earlier matter. Same problem. What's riveted and what's pasted? My lord, what happens is there can be a machine. This machine, your lordship looks at this machine. My lord, shear is, my lord, embossed in the machine. Embossed, not pasted. So this can be another machine from another era. And my lord, a name, just a, my lord, my lord, if your lordship goes to Rajabajar, your lordship will find that a shear thing has come.
The machinery are mostly from China. Yes, from the names it appears.
Yes. So
probably pasting is riveting.
I don't want to, my lord, it's all here.
So that maybe pasting is equivalent to riveting there. So you cannot proceed on that promise.
I don't know that. I want to be sure on. Sachet number, he's absolutely correct. The car's sachet number, the car's casket number, everything can be changed. Yes. Very well be changed. This is my problem. And what I am really, my lord, once bitten, twice shy. Really that. Because I am in the middle, my lord, being, my lord, in a sandwich position, where my lord, they are saying that you will have to pay me money, and the government of India says, why have you paid them money? So whoever pays them money, my lord, if the CBI is running after them. And now the CBI is everything, as your lordship pointed out on the last occasion. So I want to be very sure, my lord, before I use any of the public money and give it to a private person, from where recovery becomes very difficult for me. There is a lengthy procedure. Though he's given all the undertakings, he's also given that undertaking in the earlier scheme as well. Now, PSC, my lord, took this up. Your lordship, my lord, I would take your lordship immediately, my lord, to the legality of a PSC's decision. I'll take your lordship immediately to the constitution. Tally turns directly, my lord, to 266. Oh, it is full stop. তো NJB অতটুকু টাকা খরচ করতে হবে। Kindly looks to 266. This is the constitutional, my lord, validity of the Public Accounts Committee. Subject to the provisions of Article 267 and to the provisions of this chapter with respect to the, my lord, kindly got it, lord?
Yes, yes, sir.
Of the whole or part of the net proceeds of certain taxes and duties to states, all revenues received by the government of India, all loans raised by that government by the issue of treasury bills, loans or ways and means advances, and all monies received by that government in repayment of loans shall from one consolidated fund, from where your lordships get my lord's salary.
Yes.
Fund to be entitled the Consolidated Fund of India, and all revenues received by the government of a state, all loans raised by that government by the issue of treasury bills, loans or ways and means advances, and all monies received by that government in repayment of loans shall form one consolidated fund to be entitled the Consolidated Fund of the state. All other public monies received by or on behalf of the government of India or the government of a state shall be credited to the public account of India or the public account of the state, as the case may be. And then the committees are formed. Kindly turns to Lord 118, turns back. My lord has an iPad with your lordship.
Yes, I do.
My lord, if your lordship opens the airdrop,
Samsung tab, yes.
if your lordship opens the airdrop, my lord, then he will be able to, my lord, send your lordship directly to your lordship's iPad the rules, because it's a little lengthy and it's
This is not an iPad. I do that.
It's
It
not
has
an
to be no. This is tab, Samsung tab. I chose the tab. I mean,
your lordship may, my lord, if your lordship has an email, if your lordship tells it to Mr. Kormakar,
I'll give my email right now. You can
Ah,
send it. Yes. What is the you are trying? You will be sending
slowly
what?
I'll get it back. My lord, these are the rules of the Lok Sabha, my lord, which has been under 108, which has statutory force.
You can send me the link.
I can send your lordship the entire. There's no problem.
Very well. I'm giving my email right
Mr.
now.
Banerjee, my lord, is there. My lord, he's more technical than technically savvy, not savvy.
No, Tevri is savvy. His brother is savvy.
That's exactly why I
Take my email ID. Send it there. That's savvy actually. SABY 4237 @gmail. You can send it right now. Yes.
Actual art, constitution.
Yes.
রুলটা আমাকে ফরওয়ার্ড করে
হ্যাঁ,
দিন।
Lord, till he sends, kindly turns to me on 118.
118.
Each House of Parliament may make rules for regulating, subject to the provisions of this Constitution, its procedure and conduct of business. Until rules are made under Clause 1, the rules of procedure and standing orders in force immediately before the commencement of this Constitution with respect to legislature of the Dominion of India shall have effect in relation to Parliament, subject to such modifications and adaptations as may be made therein by the Chairman of the Council of States or the Speaker of the House of the People, as the case may be. The President, after consultation with the Chairman of the Council of States and the Speaker of the House of People, may make rules as to the procedure with respect to joint sittings of and communication between the two houses. This is where, my lord, the rule-making power, my lord, comes into effect of the Lok Sabha. In terms of this, my lord, a rule was framed, which has been sent to my lord. Why I am saying, my lord, that it has some statutory force and is in a way binding upon me, just to show your lordship. Lord, when we open the news channels these days, my lord, this is very important these days, this rules. The rules of procedure and conduct of business in Lok Sabha. Often talked
I'm
about.
sorry, I'm out of battery. I'll check it in my phone.
Right. Lord, we can give you a lordship this one.
No, I'll use my phone.
জজ সাহেবের কাছে থাকলে ভালো।
আমাকেও ইমেল কর না।
তোকে এয়ারড্রপ করছি তোর
কি করতে হবে এয়ারড্রপ জন্য ব্লুটুথ অন করতে হবে?
হ্যাঁ।
Yes.
কি এবং
এয়ারড্রপ
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 আমি কোথায় যাব এখন?
Send a copy to Mr. Banerjee.
Yes, yes. এখানে যা, এখানে গিয়ে এয়ারড্রপ টাইপ কর।
দাদা এটা নেটেও অ্যাভেলেবল আছে।
এয়ারড্রপ কর, পাঠিয়ে দেব। এয়ারড্রপ লিখ।
এয়ারড্রপ
অন কর। Everyone.
আচ্ছা।
এবার দেখ, চিন্তা কর।
This is regarding conduct of business in the
Yes,
Lok Sabha.
and that's where, my lord, that's where the PAC, my lord, how they are formed will come into play. I'll show you a lot. In the Lok Sabha, my lord, what is the duty of a PAC and how their orders are being implemented? There's another rule to that. How, my lord, their recommendations and their orders are to be implemented. There's another rule to that. That also, my lord, we shall send it immediately so that, my lord, I can refer to it. iTunes से ही देते हैं गान बाजी थी। Lord, these are not really readily available, my lord. It's there on the net, but it's not available readily here. So just give us 2 minutes time.
You can send us letter. You can proceed with the next point.
Yes.
So
Now,
you say this has a binding effect.
On me at least.
On you, yes.
On me at least. My lord, I do not understand why it might not be binding on anybody else, because there is statutorily, my lord, in those rules, statutorily, the government has to act on that.
All right, very good.
And the government, if it doesn't want to act on that, my lord, will also have to give an order saying that I'm not going to act on. This is the checks and balances, because your lordship will find in the PAC, everybody is basically from the opposition.
All right.
From the opposition. This is a check and balance on the functioning of the government of India, that they don't, my lord, do anything and everything that they want to do.
All right.
So that, in my respectful submission, is what the government of India did with the recommendation. I don't know.
But that's vague.
Because I'm before your lordship on vagueness.
You have cited a specific reason, Mr. Chatterjee, that you have adjusted with the MM4 and all.
That is what the PAC has recommended.
As you say, that is person.
Yes.
It goes down to that.
Yes, yes. And it goes down to them. The PAC's basic recommendation is that anybody from the jute mill industry and the Kankaria group who have taken money and have misutilized them, you cannot give them money.
The PAC takes decisions on particular groups.
And it has. And it has a right to do so. Milord, that's there in the rules itself. Because they are dealing with, Milord, if they had taken
Chatterjee, you derive it. The PAC derives its powers in turn from 118.
Yes.
If that be so, that is confined to the parliamentary houses.
Yes.
It cannot govern the functioning of the government in relating to schemes and all.
There's a chain there. It's there. I'll show you a lot of it. They can and they have to. I'll
Because
show you.
we-
Lordship.
there's a division of power, right? The legislature is there, executive is there. We are there. Now, legislature within the regarding the conduct of the proceedings in its own house.
Lord, it's not about legislature. It's about the government.
Each house of parliament is legislature.
Yes, that's what I am.
So how far that can bind
It's
the,
a different aspect. Now,
Yes.
can you look to
that
the
is
change
regarding
of-
the functioning of the
Absolutely.
legislature.
Now, the
internal.
legislature
Yes.
will have a control over the functioning of the government. And especially when public money is involved. My lord, if he had used his own money, my lord, the PAC would have nothing to do with it. But once the PAC sees that a public money is being misutilized, it's it's their obligation to find out, investigate. And where do they find it out from? From the comptroller and auditors general. Now, my lord, kindly looks to the dots here. PAC is a body, constitutional body having.
It cannot legislate.
No, cannot. It can only recommend.
Yes.
And the recommendation has to be acted upon by the government. That's the rules. And these rules have statutory force. And how the government is going to act, that action needs to be challenged by them. Not my disbursing of the money.
Mr. Chatterjee, you do not derive your powers from 118. I mean,
Not me.
Not you. Well, Rule 1183 says the president, after consultation with chairman of such and such, may make rules as to the procedure with respect to joint sittings of and communications between the two houses. That is too large a periphery you are trying to attribute to the this.
Look, this is the
No, no.
functioning.
This
This
is
is
regarding the
the
joint sitting of the two houses regarding that, the procedures regarding that. So suppose you throw a flying kiss, that will be governed by this.
My lord is looking into 118 procedure generally.
Rules of procedure. Yes. Yes.
Each house of parliament may
No.
make rules
True.
for regulating.
I was referring to sub-article 3.
Yeah, no, not that. One.
Only one, you say.
One.
Yes, each house of parliament may make rules for regulating.
Subject to the provisions of this constitution, its procedure and conduct of business. This is where, my lord, PACs are, my lord, formed.
Its procedure.
Subject to the provisions of the
Yes.
its procedure.
Yes.
Yes, its procedure.
This is the.
And the conduct of its business.
Yes, under these, the rules are formed, which is one of the rules of procedure and conduct of business in Lok Sabha. Kindly turns to that rule now.
Mr.
Kindly
Chatterjee,
turns
you are
to
not
that
even
rules.
confusing.
No. But
Not convincing, not confusing even.
No.
Parliament it
lordship,
regulates its own procedure. How can that be binding on as a neither a legislation nor an executive
But
action?
I was going from A to Z. My lord has gone to Z. A is, well, this is where how the PACs are formed. Now,
Very good,
the
yes.
powers of the PACs, my lord, will come from the rule itself. Kindly turns to that rule which we sent your lordship.
Right.
না প্রথম থেকে একবার লিখিয়ে দিই তারপরে 308 দিই This is the provision. 118.
118, yes.
Kindly looks to the below the preface. Looks to the first page. Below, kindly do not go down. Looks to the first preface. Just after below the. It's on the third page. Third page. My lord, kindly got it.
Yes, preface.
Yes, the Constituent Assembly legislative rules of procedure and conduct of business and force immediately before the commencement of the Constitution of India were modified and adopted by the Speaker of Lok Sabha in exercise of the powers conferred on Speaker by Article 118(2) of the Constitution and published under the rules of procedure and conduct of the business in the House of the People and the Gazette of India Extraordinary. Those rules were amended. Your lordship may comes down. Then the history, my lord, is all set. 10th Lok Sabha also. Lordship comes down. My lord has come to 16.
Yes, 16th Lok Sabha.
Yes. Now comes to the contents. In the contents, kindly looks to 308.
253.
253 তে যাবো?
253 is parliamentary committee.
Okay, very well.
308 are your functions.
ঠিক আছে।
ওটা একবার দেখিয়ে দেবো।
আর না অসুবিধা নেই, আমি তো ভালোই। Page double 253,
253 শুরু হচ্ছে
98.
starts from 253.
It does. It does. জজ সাহেব একটু আগে যেতে চাইছেন, আমি তাই জন্য খুব একটা এই করতে চাইছি, তো যত তাড়াতাড়ি করতে চাইছি।
253 it starts.
That's from
regarding
where
parliamentary
PSCs are
Starting from 1. I'll impose costs on you personally, Mr. Chatterjee.
I was not starting from 1. I was going way ahead to 308. He wants me to not get to impose cost on him.
308.
Eight.
We'll go backwards if necessary.
Yes, kindly looks to 253 first. Your lordship has already seen that.
Yes, 253.
Yes, that's how my lord, the parliamentary committee my lord, comes into play. কি রে? তো এটাতে চলে গেল কোথায়? এটা পরেরটা। এটা বই আনলে এই জন্য সুবিধা। দুশো তিপ্পান্নটা জজ সাহেব দেখেছেন বলে।
So 308 would be better, I think.
308.
Let us start.
I am on 30.
Right.
Really on 30. There shall be a committee on public accounts for the examination of accounts showing the appropriation of sums granted by the House for the expenditure of the Government of India, the annual finance accounts of the Government of India, and such other accounts laid before the House as committee may think fit. In scrutinizing the appropriation accounts of the Government of India and the report of the Comptroller and Auditor General thereon, it shall be the duty of the committee to satisfy itself that the monies shown in the accounts as having been disbursed were legally available for and applicable to the service or purpose to which they have been applied or charged, that the expenditure conforms to the authority which governs it. Very important. That every reappropriation has been made in accordance with the provisions made in this behalf under rules framed by competent authority. It shall also be the duty of the committee to examine the statement of accounts showing the income and expenditure of state corporations. Very important, Lord. 3A. 3A.
Yes.
It shall be the duty of the committee to examine the statement of accounts showing the income and expenditure of state corporations, trading and manufacturing schemes, concerns and projects, together with the balance sheets and statements of profit and loss accounts, with the President may have required to be prepared or are prepared under provisions of the statutory rules regulating the financing of a particular corporation, trading or manufacturing scheme or concern or project, and the report of the Comptroller and Auditor General thereon. This I was trying to explain to your lordship, that this is their duty. They will inspect whatever is happening with respect to public money, and then they will recommend the government that you have to act accordingly. My lord, I have no powers to blacklist them. The scheme doesn't tell me, my lord, to blacklist them at all. It is not like a tender. But this is constitutional. Why? Because Government of India's money is involved, or public money is in. And it is falling within, my lord, the duty of the, my lord, the PSC to look into, my lord, if any anomaly has happened on. I'm taking my case way further. কি করে বলি বলো তো সপ্তাহ
Should I release?
He will reply, so I don't think.
I will not take much time.
Other matters are released.
No, then if he doesn't take too much time, then your lordship will not release the other matter. I might want to come back on some other day if your lordship gives me that time.
See, Mr. Vasu. Other matters are released. Mr. Chatterjee will take.
When I am only against him in that matter where he wants to argue. Item number 8. I am for the petitioner, he is for the rest.
Other matters are released. Yes.
Then
yes.
A, then to examine the B, to examine the statement of accounts showing the income and expenditure of autonomous and semi-autonomous bodies, the audit of which may be conducted by the Comptroller and Auditor General of India. They've done it. My lord, I will show your lordship the report of PAC. The Auditor and Comptroller General has run this audit. And then they've given a report to the PAC, and on that PAC, my lord, is acting against the Kankaria group. My lord, if they had their own money, if they were doing whatever they were doing with their own money, my lord, the PSA had no jurisdiction whatsoever. But the moment they want to lay hands on public money, the PAC will have a right to see whether the public money, my lord, is being utilized in a proper fashion or not. This is what my submission is before your lordship, because your lordship asked, my lord, that they are only recommended. No, they are recommendatory, yes, but the government will have to act on that recommendation. And what action they are taking, my lord, is they've asked us not to disburse money. So I am not taking a decision, my lord, not to disburse money on them. It's the government of India which is taking the decision, my lord, not to give them money. There is a separate.
Have you disclosed anything? Your opposition was directed in this matter. Have you disclosed
it
anything?
was there. Yes. In our supplementary affidavit. About the PSC, everything.
About the PSC.
Yes. That's our supplementary affidavit. Okay. They are saying, my lord, on that supplementary affidavit, that what the other companies in the group have done, I am not liable.
No, the
if I've done something in
PSC directive and all, have you annexed anything?
Everything. Yes. In our my lord, supplementary affidavit.
Yes.
And he has, my lord, placed it before your lordship on the last.
Yes, he did. Yes.
Just relevant portion.
Right.
So, my lord, my respectful submission is that I am being hounded, my lord. If I may say, it's a deliberate attempt, probably, my lord, not to include, my lord, the government of India. Because the government of India has with itself everything, my lord, in the armory. Why they should not be, my lord, given the money, which I don't have. I say, my lord, this is a deliberate attempt to just put the NJB. Obviously, Mr. Banerjee is there, my lord, his mind works. To just put the NJB, who is, my lord, nothing but a puppet.
Puppet.
Nothing. So I have very limited powers, my lord, under the scheme. What am I? I am only going to disburse you money, nothing else. Who gives you the money? The government of India. Where is he? Nowhere. So why he doesn't want to give you the money, it's for him to say. I am not going to talk for him. And that's why I say, my lord, the writ petition in the beginning, when he started arguing, I took up this point before your lordship that this is not maintainable without the government of India. I started off at the onset. So this is where I come from. This is what the statutory force is. My lord, there is a separate procedure for implementation. We've sent your lordship. Yes. We sent your lordship.
Not a regular recommendation.
And this is not, my lord, like a useless recommendation, my lord, body that we all have, my lord, in probably even the Heritage Commission. Because the government of India is bound to act upon. And there is a rule with respect to these, my lord, implementation of recommendations of PAC by ministers of finance, ministries of finance, defense, and women and child development. ওটা নয় should I call everyone call?
Accept. Not opening.
My lord kindly looks at chapter 1.
Not opening.
Lordship has
Network.
Achha, may I hand this over? If your lordship was
you have to place from that. Mac, I am not very comfortable, Mr. Chatterjee. I mean, the compatibility is easier with Google, everything. Android on Android.
All corrected that. They've all corrected that, and now Apple is more user friendly, my lord, than
I don't know. I returned my
because
MacBook actually.
these things, my lord, the airdrops, collaboration. If your lordship is like my lord is dictating something, my lord,
Yes.
to your lordship's officer.
That we have the Dragon that has been provided to us.
Now that's the MacBook itself will have it, my lord, inside.
Yes.
So if your lordship is, my lord, dictating something,
Yes.
it will directly from my lord's laptop, my lord, your lordship may collaborate with your lordship's stenographer. So your lordship will see what he is actually typing and, my lord, correct it accordingly.
That is possible via Microsoft also.
Yes, Microsoft has its own
Yes,
software.
right.
It's very good.
Yes.
But Microsoft is not that popular, my lord, today, my lord. It's basically Apple and Samsung.
That's more because of the security.
Security, yes.
Yes, it has opened. Yes.
Lordship. Kindly turns to, my lord, chapter 1. The Public Accounts Committee is the principal instrument of the Parliament. Lordship, kindly got it?
Yes, he's got it. Right.
Enforcing financial accountability of the executive to the legislature. Marks this. In pursuance of this objective, the committee take up subjects for detailed examination. The lines of inquiry and preliminary information are derived from the reports of the CAG of India, followed by written and oral submissions made by the government. Thereafter, the committee give observations or recommendations in their reports pointing out extravagance or waste for corrective and remedial action. Very important in our case, corrective and remedial action, because the fraud happened in the earlier scheme. Now we have to be very, very, that's why I showed your lordship the anomalies in the inspection report. These recommendations not only bring out the inefficiencies, irregularities, and other shortcomings in the implementation of policies and programs approved by the Parliament, but also are constructive suggestions for bringing about improvements in working and better utilization of resources in the largest interests of the nation. The government is expected to gear up the administrative machinery for optimum performance and galvanize the national economy to serve public interest. The government is required to take action on the observations or recommendations. Very important. This is what your lordship wanted to, my lord, know. Definitely. Because this is what your lordship wanted to know. Given by the committee and submit its reply within 6 months. That's been done, my lord, internally within them. After analyzing the action taken replies so submitted, action taken reports are presented by the committee to the Parliament. The analysis includes categorization of replies into these accepted by the government, those which the committee do not desire to pursue in view of the replies received from the government, those that have not been accepted by the committee and which require reiteration, and those in respect of which the government have furnished interim replies. Regarding actual implementation of the recommendations of the committee that have been accepted by the government, though the CAG examines the status of implementation of these recommendations during follow-up audit after a few years, there is no mechanism to simultaneously determine and ensure actual implementation of the same. Then, as the implementation of these recommendations is imperative in ensuring best use of limited resources for accelerating the process of development, transparency in government action, probity in public life, and inspiring reverence for accountability to Parliament, the need was felt to devise an alternative to monitor the implementation of the compliance of the government. Then I can read on, my lord, if your lordship so desires. The recommendations have to be implemented. Just give me a second. So this is what, my lord, the broader picture is. The broader picture. My lord, it's not like a recommendation which the government can just say that I don't want to look at it. It has to act upon. There is no mechanism, my lord, which the rules say to have absolute, my lord, implementation, but there needs to be action on it. Now, in our case, what is my problem? The government has acted upon it. The government says that you can't give it to the Kankaria group because they've cheated the money from the public in the earlier scheme. My lord, it's gone to the extent that one of my officers, my lord, had to my lord, leave his job.
Chatterjee, they are otherwise eligible under the scheme.
I say so.
You have floated a scheme. Now, Article 14 also
Government
comes
of
in a different sense. I mean, if these people are not suffering, this particular company, the petitioner, if it is not Balifab, suppose, if Balifab is not suffering from any criminal action or something like that,
Lord,
how
I
can
don't know that.
on basis of presumption or assumption or
the
apprehension?
government knows it. That's why the government has asked me not to, my lord, pay him.
That cannot be the premise. I mean,
My lord, I cannot disburse.
the government
Let's
will
put it this way.
cite anything. I mean, that will be used as a screen for government action, for arbitrary action.
Here before your lordship, it's for them to answer.
That's a very, yes.
I am, my lord, kindly do not get me wrong on that. I say why I wanted the government. My lord, let him have the money. I am not standing in the way. Let him have the money. But kindly
You rely on the PSC recommendations which are mandatory on the government.
They have taken an
Therefore,
action.
you are
on
also
it.
bound.
I am bound because
You are
the
the
government has
disbursing
taken
authority only.
I am bound because the government has taken an action.
Right.
I don't, I have taken full instruction, my lord, from my client. My lord, what they say is that they are not standing in the way. They don't have any mechanism under the scheme to stand in the way. If the government doesn't want me to pay, my lord, I cannot pay. Because they are funding it, the scheme is that of the government, not of the NJB. That is very important. সেটা second part আসছে. That will come to, that is the second part. Now, my lord, how do I show your lordship that the government has acted upon? It's a very easy way to show your lordship. My lord, your lordship remembers they were claiming, my lord, under two schemes. The first scheme and the second scheme.
Yes.
Now, sees what happens in the second scheme. Kindly turns to, my lord, page 102. Lord, it starts off at page 69. 69.
Yes.
Okay, Galagal sledging me, my lord.
No, not so.
Oh, yes.
I'm
Mr. Banerjee.
congratulating him for having taken the matter there where he has taken it.
70.
102.
আমার টাকা যাচ্ছে. Can you see number 3? This is, my lord, 1st of April 2017 to 31st March 2020. This is, my lord, the second scheme. This is the second scheme, my lord, in the prayer, my lord, your lordship had seen earlier.
This is the same writ petition.
Same writ petition. This is the second scheme at page 70. Starts from 69.
69, yes.
Yes. And my lord, 70.
70, right?
Duration, your lordship has seen. Scheme will come into effect from 1st April 2017 and continue up to 31st March 2020.
Right.
Same things are there.
The ETU amended. 73 times.
Kindly turns to 73 at pilot 10.
Yes.
In the event of submission of false or misleading declaration by the claimant under the scheme, the plaintiff may be imposed financially penalty, issue show cause notice, and the technical committee may take necessary action against repeated offenders as deemed fit.
Oh, in 12, it's specified that fixing brass plate having embossed engraved identification, it's also there in the scheme.
It's after we come
It's
to know
not
about
an
what's
invention of the.
because we, after coming to know of all the frauds that's happened,
Yes.
happens.
This was
so
not
this
there in
was-
the other scheme. Oh, achha, very yes.
And this was brought in here to be more, my lord, on the safest part. 10, 11 funding, again, your lordship has seen, my lord, this is the Ministry of Textiles. 12, my lord has seen it. I don't have to, my lord, your lordship. Then kindly, দেখালাম যে? দেখালাম তো operation.
77 is important. It is all the same. This one was.
Kindly have a look at 77F.
In evolutionary theory, Mr. Chatterjee, there's always a competition between the hunted and the hunter.
Yes.
I mean, to outgrow each other.
Yes.
I mean, to develop skills,
Skills to
which
Milord,
they
yes.
can outgrow each other.
Yes.
So it's similar in commerce also.
If your
Yes.
lordship Milord likes
Yes.
the animal world,
Yes.
Milord, I don't know whether your lordship has traveled Milord to the jungles, Milord, how they. My lord is only
Nearby
after,
jungles. Yes.
only after Milord
In India, I've traveled.
in India, lordship. in
Not to the
India.
jungles we have traveled.
But I,
Yes, in India, yes. Some of them.
even in India, if your lordship sees to see, go to see a tiger. Now, how a tiger, Milord, is actually hunted down by the Milord, the people who actually go to see,
Yes.
is very interesting. Your lordship needs to Milord, look into that. There will be Milord, a call from Milord, the langurs, from the peacocks.
No, you have seen all the field actually hunt. Achha, that I've never had the
That it
only
is-
in these
it's
channels.
Very,
Yes.
very, very interesting. Milord, I had the occasion with my father, Milord, I had gone to Africa. In Masai Mara, we had followed Milord, 2 cheetahs for about 5 to 6 hours. From the second hour, they got hungry and they wanted to Milord, eat. How they changed Milord, the way they changed their attitude, went and had water, sat under a tree, got their energy back. Then there was a pile of a lot of wildebeest in the front. They divided. One went this way, the other one just that way. They selected one from them, and we were all chasing Milord. Just our car was there. They selected one wildebeest in about 1,000. Caught hold of that. One went and caught hold of it here.
Jugular.
And the other one did nothing. Just sat to see that nobody else comes in. Milord, it's fascinating. Yes, that wildebeest died and was food for not just the leopard, the cheetahs, but also Milord, for the hyenas. Then Milord, the vultures came in.
The entire ecological system is
Entire
supported.
ecological
Yes.
subsystem is. So it's a fascinating thing. Even Milord, here in India, if your lordship has seen, Milord, I have seen a tiger hunt down, and it's again very fascinating. It runs from the way it changes its position and moves down.
Entire. Right.
And it's a fascinating thing. Same way here, Milord, they will find out ways to Milord, get the money by not spending that money. This is where the problem lies with me, and I have to Milord, evolve as well.
Not necessarily in this case,
Huh.
but we have an example.
I would try to
generally speaking.
I would try to think in this case as
Yeah.
well. But this is true.
Right.
This is true. Then this has evolved. Kindly now turns to 102. I should have taken it to 107, but your lordship takes up 100. Milord, your lordship has seen, I had wanted company management details. Now, what was happening was the Kankaria group cheating the public money in the earlier scheme. Milord floats another company, being the same directors, the name changes, and they will say that, look here, they might have cheated, I did not. But company is a juristic person, but not a living person. Lives the corporate way and sees what's happening. That's why, Milord, I have asked for details at page 102. Who are the people behind the company? Name of the applicant form, status of the application, date of incorporation, constitution of the firm. Very important. Public limited, private limited, attached memorandum or article of association, copy signed, certificate, names, addresses, directors of proprietor, partners, directors having interest in the firm. If that's in 2, and then F. If the directors, partners, proprietor have financial interests or are represented on boards of other companies, give details. So we become wiser now. Milord, it's really not we, it's the government of India. Then, Milord, kindly, there is another very important thing which I had to show. Bali Fab, Milord, your lordship will find is a small industry. It's manufacturing at 107. It has taken, Milord, loan from Yes Bank. Your lordship will find, Milord, bank details, Yes Bank. my lord, while giving, my lord, the credentials to Yes Bank, they have given credentials of the persons of the other companies, my lord, Usha, but he was talking about Usha, MFL. Credentials, my lord, are given of those companies to get loan, my lord, from Yes Bank. And we've produced that, my lord, for your lordship in the, my lord, the opposition. Mr. Shudra Prasad Chattopadhyay would have killed me if I had not said this. Opposition to rape, my lord, if your lordship takes up the opposition.
Additional গুলো কোন পুলিশ দেখালে বলো তো?
107 102 তারপর 102 I think it has to spill over, my lord, to another day. But there are 1 or 2 decisions I'll have to cite. It'll take a little bit of time. But if your lordship allows us,
Yes, we can come back.
the day after tomorrow. Out of
একটা order record, just heard in part for further reading day after tomorrow. August 31st, 2020.
না টাইম নেব না পাগল নাকি আমাকে
Thank you. এটা কাজে
দেখাবে
লাগবে।
তো সে
না করতে পারলাম না, ইন্টারনেট ছিল না।
আচ্ছা
পরে নেবেন, আমি আপনাকে হোয়াটসঅ্যাপ করে দিচ্ছি। যে কোনো জাজ, পাবলিক অ্যাকাউন্টস কমিটি, ফ্রড